Well, it being 8:30, we're going to call meeting number 64 together, and I want to welcome everybody back, and I want to welcome new members to the committee and all of our invitees to testify today. We're starting on an interesting mission, our study on Bill C-45, an act respecting cannabis, and I expect it's going to be very interesting. It looks like we have some interest in the issue. And we have several witnesses today, but I want to just point out that today, being September the 11th, we're going to have a moment of silence at 8:46 in recognition of the disasters that happened in Virginia and Washington and New York, where almost 3,000 people died in that awful tragedy, including somewhere between 24 and 29 Canadians. So. At 8:46, I'll just call for a moment of silence. But in the meantime, I'll introduce our guests, and I will be interrupting at 8:46, just so you're aware. We have mostly federal, provincial, and territorial responsibilities on our agenda today, and our witnesses are from the Department of Health, Jacqueline Bogdan, Assistant Deputy Minister, Cannabis Legislation and Regulation Branch, Eric Costin, who is Director General, Cannabis Legalization and Regulation Branch. From the Department of Justice, we have Carol Morency, Director General and Senior General Counsel, Criminal Law and Policy Section. Diane LaBelle, from General Counsel for Health Canada Legal Services. From the Department of Public Safety and Emergency Preparedness, we have Kathy Thompson, Assistant Deputy Minister, Community Safety and Countering Crime Branch. From the Royal Canadian Mounted Police, we have Joanne Crampton, Assistant Commissioner, Federal Police and Criminal Operations. I want to welcome you all and thank you for coming, and I'm sure your lives are getting very interesting about now, so you can share some of that with us. My understanding is that Ms. Bogdan is going to open up on behalf of everybody, so you'll have 10 minutes, and then we'll open the floor to questions. So, Ms. Bogdan.
Great. Do I turn the mic on? Yeah, I'm on. Thank you, Mr. Chair. Good morning, Mr. Chair. Thank you for the opportunity to appear before the committee this morning. As the chair has already introduced us, I'll dispense with the introductions of myself and colleagues. As public servants, we're responsible for providing advice and support to ministers in developing this proposed legislation. I should also note that Bill C-46 was introduced to strengthen the laws for drug-impaired driving, and it's being studied by the Justice Committee. Mr. Chair, your committee is embarking on the study of an important, complex, and transformative piece of legislation. On behalf of my colleagues, I'd like to provide the committee with a brief overview of the proposed legislation. I'll focus on three main aspects. First, one is the context that has informed the development of the new control framework for cannabis in this bill and the government's objectives. Second, I will highlight some of the key provisions of the bill. In particular, the roles and responsibilities of the different levels of government. In doing so, I will also describe how we're working with our provincial and territorial colleagues collaboratively. Third, I will describe the equally important work that is underway to support this legislative change, including increased public education and awareness that is focused on the health and safety risks of cannabis use. Let me begin by describing the current context. Canada has some of the highest rates of cannabis use in the world. Of particular concern are current patterns of use that we're seeing among teens and young adults. More than 1 in 5 Canadians between the ages of 15 and 19 say they have used cannabis in the last year. The rate is higher still for young adults. Nearly 1 in 3 Canadians between the ages of 20 and 24 report using cannabis in the past 12 months. These rates of use are of concern, given that the risks of cannabis use are higher for youth than for adults, and these risks increase the younger they start using it and the more often that they use it. Alongside these high rates of use among youth and young adults is an illegal market that's valued at $7 billion annually for organized crime and those who choose to break the law. This illegal market also places a considerable strain on the resources of Canada's criminal justice system. We see the results in the prosecution of simple possession offences, In 2016, Statistics Canada reported that over 3/4 of cannabis-related charges were for possession of cannabis. Mr. Chair, against this backdrop, it becomes clear that the status quo has not been effective at deterring use or preventing easy access to cannabis for young people. With Bill C-45, the government is setting out a new proposed control framework for cannabis. The government's objectives are clearly laid out at Clause 7 of the proposed bill. These objectives are to protect the health of young persons by restricting their access to cannabis and protect them from inducements to use cannabis. It also seeks to deter illegal activities through appropriate sanctions and enforcement measures. It provides for the legal production of cannabis to reduce these illegal activities. It seeks to reduce the burden on the criminal justice system. It would allow adults to possess and access regulated, quality-controlled cannabis, and, very importantly, enhance public awareness of the health risks associated with cannabis use. The proposed act is closely aligned with the findings of the Task Force on Cannabis Legalization and Regulation. The task force consulted widely and extensively. It sought expert opinion from public health, justice, law enforcement, among others. It sought the views of provincial, territorial, and municipal governments, U.S. state government officials, and, of course, Canadians. The proposed act would create strict national rules that will control the production, distribution, sale, and possession of cannabis in Canada. It would allow adults to have legal, strictly regulated access to cannabis, which they could obtain either through a government-licensed seller or growing it in limited amounts at home. In particular, the bill proposes a number of measures designed specifically to better protect young people from cannabis. For example, it would be illegal for adults to sell or distribute cannabis to anyone under the age of 18, and provinces and territories could increase this minimum age. The Act would create 2 new criminal offenses with maximum penalties of 14 years in jail for distributing or selling cannabis to a young person and using a young person to commit a cannabis-related offense. The Act would also prohibit the promotion and advertising of cannabis that could be appealing to young people, similar to the restrictions that we have in place now for tobacco. It would also prohibit products and packaging and labeling that are appealing to youth. Adults would be permitted to possess up to 30 grams of dried cannabis in public or an equivalent amount in other forms. There would be penalties for those who break these new rules, and these penalties would be proportional to the seriousness of the offense. There would be ticketing options for minor offenses. More serious violations, such as illegal commercial production or taking cannabis across Canada's borders, would be subject to fines or imprisonment. I'd like to turn now to the roles and responsibilities of the federal, provincial, and territorial governments. In keeping with the advice of the task force, the proposed act sets out a shared framework for the control and regulation of cannabis that will require ongoing federal, provincial, and territorial cooperation. Under the proposed act, the federal government would be responsible for licensing and regulating the production of cannabis, including setting and enforcing high standards for health and safety. Consistent with their jurisdictional authorities and experience, the provincial and territorial governments will be able to regulate the distribution and sale of cannabis in their respective jurisdictions. Provinces and territories, together with municipalities, would also have broad flexibility to adapt certain rules into their own jurisdictions and enforce them through a range of tools, including tickets. These could include setting a higher minimum age or stricter limits on personal possession or personal cultivation. Local governments would also have responsibility for establishing rules around whether cannabis can be consumed in public, enacting zoning bylaws governing where stores may be located, as well as policing and bylaw enforcement. Mr. Chair, coordination among various levels of government is and will continue to be absolutely essential. For that reason, in spring 2016, federal, provincial, and territorial ministers of health, public safety, and justice established a working group of officials to facilitate consultation, information sharing, and collaboration throughout the design and the implementation of this proposed legislation. Since that time, senior officials have been meeting every 3 weeks to discuss key issues, to consult each other, share information, and coordinate our respective efforts, and this collaboration will continue. Provinces and territories are preparing. Many jurisdictions have announced plans or launched public consultations or their intention to do so. And we are completely committed to working together collaboratively in the months ahead as our respective jurisdictions prepare for potential implementation of this legislation if it is approved by Parliament. Mr. Chair, as I near the conclusion of my remarks today, I'd like to describe briefly a couple of other dimensions of work which will support this legislation. One is a system of comprehensive monitoring and surveillance. It will help us to evaluate the implementation of the legislation and make appropriate adjustments as necessary, just as other jurisdictions, such as Colorado and Washington, have done. And two, as I mentioned at the outset of my remarks, is a comprehensive public education and awareness campaign in concert with provinces and territories, municipal health authorities, and other key partners. This campaign will provide Canadians, especially young Canadians, with the information they need to be informed about the health and the safety risks of cannabis use. In closing, Mr. Chair, I wish to emphasize that Bill C-45 seeks to provide a new, more effective control framework for cannabis, one that can ensure greater protection for young people and that will, in time, displace the illegal market. With that, we would be most happy to answer the committee's questions.
Thank you very much. I want to make sure that Justice and Public Safety have an opportunity to make opening statements. No requirement to make opening statements? All right. Well, we'll go right to questions with Mr. Oliver. 7 minutes.
Thank you very much for the presentation and for the rest of you for being here. So it's quite clear that our current approach to cannabis is not working, and I think Jacqueline, your opening comments about the use, 21% of youth have reported using cannabis in the last year, 30% of young adults have reported using it. So we needed to make a change, and this legislation, I think, has done a great job of bringing those changes forward. The goals, I believe, from the government were to better protect youth, to take business away from criminals, and to put a public health front and center in so that we, the people who are consuming cannabis, understand who's made it and how safe it is to use. So those are the three overall sort of arching goals, I guess. So I wanted to begin with the question about youth. That's the number one goal. How do we better protect our youth who have right now fairly easy access to marijuana? So I guess my first question then is to Justice Canada, Carol, Diane. How does the proposed legislation specifically protect Canadian youth?
Thank you for the question. So Bill C-45 proposes criminal offenses that will prohibit anyone from selling or distributing cannabis to a young person. So the intention with the bill is to keep it out of the hands of young persons. However, the bill does recognize the reality that young persons, even under a completely prohibited regime as we have today, do have access to cannabis and in quite high numbers relative to other countries. So Bill C-45 would not propose to criminalize possession of a very small amount, 5 grams or less, but rather would leave it to provincial jurisdictions to determine if and how they wish to address that through their area of legislative jurisdiction. To the extent that a young person does commit an offense under Bill C-45, Bill C-45 does take the usual criminal law approach in the sense that a young person who commits a cannabis offense would be dealt with under the Youth Criminal Justice Act, which takes a more rehabilitative, restorative approach and directs police to consider alternatives to the formal justice system, including cautions, warnings before laying charges or referrals to community programs. So those are the criminal law protections that Bill C-45 proposes for youth. And of course, as my colleague has already mentioned, the bill also proposes numerous requirements that will protect youth against being able to access in terms of labeling requirements and promotion, advertising, and the like.
I just To break in here for a moment. As I said earlier, as we opened up, we won't take away from your time, but today's the anniversary of 9/11, and at 8:46, at this time exactly, planes crashed into the World Trade Center, taking the lives of 3,000 people, including dozens of Canadians. And I would just like to take a moment of silence and just remember that there was men, women, and children, and grandchildren, and grandparents, and people from all walks of life that lost their lives on that day. So we'll just take a moment of silence on the Health Committee side and think about it for a moment. Okay. Mr. Oliver?
Thank you for that. So I think everybody in the panel would agree that there's been lots of clinical evidence that shows that the overuse of marijuana, especially for young Canadians, can create both short and potentially long-term damages. So could you maybe explain then why the 5-gram exemption is in place? Why wouldn't you want a zero tolerance?
So, correct, as you've noted, that the medical evidence suggests, documents the impact that cannabis can have on all Canadians, including youth and the developing brain. C45 proposes to protect youth, as I've described, but it also recognizes not just the harm on the health of the young person, but also the harm that can come from having a criminal record and that can follow a young person throughout their life, in the sense of could have an impact on education or employment, crossing the border, etc. So Bill C-45 recognizes that and proposes a very small window. It's not condoning or promoting the use of cannabis, but recognizes the reality that young persons may still access and use cannabis. The committee may be aware that on Friday, September 8th, Ontario announced its intention to move forward with its proposals to address cannabis, and it included an announcement to the effect that it would not allow young persons under the age of 19 to possess any amount of cannabis. So it's this combined approach that reflects a balancing of the harms on young persons.
Is there anything you would like to see in the legislation that would go further to protect youth? Is there anything, since you've been involved in the drafting of it, that as a committee we could take on to further protect the youth, Canadian youth? Or are you fairly satisfied with that balance of issues that you've struck?
I would suggest that Bill C-45 strikes a welcome balance. However, the committee may hear from other witnesses as to other ways to address it. But I think what's important to bear in mind, as I mentioned, the Youth Criminal Justice Act would apply to young offenders that are dealing with cannabis-related offenses, and that in and of itself also brings a very different lens to dealing with young persons within the criminal justice system.
Thank you for that. And then I've had some comment back from members in my own community that they don't believe the legislation will actually deal with organized crime, that organized crime is ubiquitous, it's everywhere, in distribution of drugs. So my other question was around that, and I guess, Kathy Thompson, I direct this to you. So one of the stated goals of the legislation is to take profit away from organized crime. Can you elaborate on that then for us? How do you see the legislation doing that? Do you think it will be effective? Yeah.
Thank you, Mr. Chairman, for the question. We know that it's going to take some time to fully displace a sector that has, over a century, made a good gain in this area. It's going to take some time, and it's going to take a robust regime. You've heard Ms. Bogdan describe some of the key elements that we are trying to address to ensure that we do displace organized crime, including safe supply, and communicating to Canadians as well that there is a safe supply available to them, making sure that there is access for Canadians, ensuring also that we meet marketplace demands. So that goes to the variety to make sure that, and eventually over time, we will move into those areas. And also pricing, of course, is going to be very important in order to be able to displace organized crime. And we do have an FPT working group that is looking at the issue of pricing, public safety. We actually conducted a large study over the past year looking at the pricing in the illicit market. So we are working to tackle all those 4 pillars in order to work to displace organized crime. We know, looking at other jurisdictions, such as Colorado, for example, that they are, and I believe you're going to be hearing from officials from Colorado, Mr. Chair, but we do see them slowly displacing organized crime year over year in terms of the amount of supply that actually comes from the legal market. As well, the government announced last Friday a significant investment of $274 million. Part of those funds will go to RCMP and CVSA to ensure that they have an intelligence-led approach to tackling and targeting organized crime, transnational movement of cannabis. And for the RCMP, and maybe I'll turn it to my colleague, organized crime is a key priority for federal policing as well.
Certainly, if I may. Certainly, as Kathy mentioned, organized crime is a high priority for federal policing, in particular with the RCMP. We target the highest of echelon within the organized crime world. And we're very cognizant to realize that the chances of organized crime being eliminated in the cannabis market would be probably naive to think that that could happen. Obviously, there's a lot of unknowns as time goes on, and we'll have to assess as the legislation, if the legislation is in place, and how it moves forward, and continue to reassess at that time. But as Kathy mentioned, there are areas that would give us concern, and those would be, pardon me, the undercutting of legal prices, the price market, that the legal market could come in below the price point of what cannabis is sold at. They could continue to do exportation, which of course is a priority for us as well, ensuring that we have strong intelligence and understanding that exporting market. Also trafficking to youth, which of course the Act is well legislated. And looking at infiltrating the legal regime, which of course we're also engaged on the medical side, doing criminal records checks, and we would continue being engaged in that part.
Am I out of time? Okay, thank you.
And then some, but
Thank you
Ms.
very much.
LaBelle had I think you wanted to make a comment.
Yes, I would like to mention to the committee that and thank you for acknowledging me, Mr. Chair, that the purpose of protecting youth is carried throughout the proposed approach before you today. For example, if a legislation enacts if a province enacts legislation addressing distribution and retail sale of cannabis, they're required to have a prohibition against selling to youth. That's one item I wanted to mention. We also need to look at the broader regulatory measures that are proposed through C45, such as placing restrictions on promotion, particularly promotion that is appealing to youth. We've learned through the lessons from tobacco that youth are particularly vulnerable to the manipulations of advertising, and that the Supreme Court of Canada has recognized in several cases the significance of protecting youth from these types of measures. So as well as having these 2 new offenses on selling to youth, or using youth to commit some sort of a crime with cannabis. We've asked provinces to take this issue into consideration as they develop their own legislation, and these measures will carry through restrictions on promotion and advertising aimed at youth, also with packaging and labeling measures. Thank you.
Thanks very much. And I want to acknowledge that question went quite well over the time period, or the answers did. So I think we all want to hear the answers. So I'll continue to allow the testimony to continue, but not once the time is up, I'll stop the questions. But I won't stop the answers unless somebody disagrees with that. But I think the answers are important. We want to hear them all. So now we go to Ms. Gladu, and welcome.
Thanks very much, and certainly I also would like to hear answers, and I'm all about fairness. I'd like to thank the witnesses for their testimony today. It will likely come as no surprise to you that I'm opposed to the legalization of marijuana, but I'm in favor of adult personal possession being ticketed. So my questions will mostly be directed at how to protect the children and public safety and issues like that. So we'll start off with the Department of Health. The Canadian Medical Association has clearly given scientific evidence that people who are smoking marijuana under the age of 25 have a much increased chance of psychotic disorders and schizophrenia. And so in light of that, what do you think about this legislation allowing all provinces to set their own age, anything under?
Okay, thank you for that question, Mr. Chair. Establishing a minimum age for access to cannabis is a key control in the legislation. It's an area where the government actively sought expert opinion. The advice of experts like the Canadian Medical Association, including the Task Force on Cannabis Legalization and Regulation. And after extensive consultations, the task force consulted with public health officials, but also with law enforcement and justice, youth and youth advocates. The task force recommended that the government set the minimum age at 18. And that provinces have the flexibility to set a higher minimum age if they wish to do so. And this strikes a balance between the known health risks of cannabis use to youth and young people, but also the reality, as I mentioned in my opening remarks, that 30% of young adults between the ages of 20 and 24 report accessing cannabis. So it's trying to strike a balance between those two things. What I could also offer is that setting a minimum age that is too high runs a number of risks, including encouraging those young adults to continue to seek out cannabis on the illegal market. Which poses risk to their personal safety. They're accessing products that are unregulated and potentially unsafe. And I think another important point is that it would also continue to subject them to the possibility of criminal prosecution, conviction, and a criminal record, which, as my colleagues outlined earlier, could have lasting consequences.
Thanks. That's good for that question. My next question has to do with the purpose of the legislation, which is to protect the health of young persons by restricting their access to cannabis, and also to provide access to a quality-controlled supply of cannabis. So I wondered if you could comment on how allowing every person to grow 4 plants up to 3 meters high in their house prevents or reduces the access of young persons to cannabis, or actually quality controls the cannabis.
Okay, thank you for that question. So under the proposed Cannabis Act, it would no longer be a criminal offense for adults to grow a minimum of 4 plants at home. And provinces and territories could put in place additional, would have the flexibility, of course, to set additional rules in their jurisdiction. The proposed approach in this bill reflects the advice of the task force after extensive consultations with law enforcement, public health officials, and others, and careful consideration of the issue of personal cultivation. The task force ultimately recommended that adults would be permitted to grow up to 4 plants, but that there be certain restrictions around that, including that the plants could not be more than 1 meter in height, that they need to come from a legal source, which would be important, that if you're growing at home, you would be prohibited from selling it to another person, to providing it to young people. And of course, as I mentioned, provinces and territories could put in place additional controls.
Okay, I'm interested from the Royal Canadian Mounted Police. If you think about people that are growing this material in their house, and of course they're not doing any of the testing or quality control that any of the legal businesses would be required to do, and you can't really tell whether they're giving it away. How do you police and enforce that?
We would recommend the local police of jurisdiction would be engaged in that, or other regulatory body that the government might set out. Certainly, there's concern in terms of growing in a home, like you suggested, but there is provision for that within the legislation.
Okay, so my next question has to do with some of the information I've received from provinces. There's less than 290 days left until the government intends to legalize cannabis, and they've downloaded to the provinces the ability to sort of make up their own rules within some guidelines, and then to implement it. All the money that the government is giving is going towards training and not really to enforcement or to helping implement tests or any of this kind of thing. I'll start with the Department of Justice. Do you have any concern that the accompanying provincial guidelines would be able to be put in place in that less than 290 days?
I believe Ms. Bogdan, Adrian Bogdan, and my colleague, Mr. Costin, would be quite able to describe the number of measures that are being taken at the moment to set out the framework and to proceed with the implementation. I believe they're in a better position to respond to these questions.
Thank you. Government officials have been working, as I mentioned in my opening remarks, very closely with provinces and territories. Since the bill was introduced in the House of Commons, we spent the weeks and months following that, spending time with our provincial and territorial colleagues, making sure that they understood the government's objectives, the content of the legislation, answering technical questions, to do exactly as the honourable member suggests, ensure that they, have the capacity and support from the federal government to prepare legislative frameworks accordingly. I think, as I also mentioned, we are seeing that provinces are moving forward with either announcing plans for what their legislative frameworks might contain and other measures that they're putting in place, and most, if not all, jurisdictions have begun public consultations or announced their intention to do so, and we will continue to make sure that we are there to help them to do the work that they need to do in their jurisdictions.
Just for clarification, Ms. Glad said each adult has the ability or the right to have 4 plants. Is it each adult or each household?
That's a very good question, Mr. Casey. It is each household. It's an important restriction or a conscious choice in the design of that provision of the legislation. I should have mentioned that. Thank you.
Thank you. Mr. Davies.
Chair, and thank you to all the witnesses for being here today. C-45 restricts legal cannabis products to dried cannabis, cannabis oil, cannabis plants, plant seeds, and there's one other poor part of it that escapes me. But what is clear is that this legislation will continue to keep illegal cannabis products like edibles, creams, tinctures, patches, those kinds of things. I'm wondering what percentage of the current cannabis market is taken up by the products that will still remain illegal under this bill?
Perhaps I could clarify. Thank you for the question, Mr. Chair. Perhaps I could clarify for the honourable member that this legislation does contemplate the provision of both dried cannabis and cannabis oil, as you mentioned, plants and seedlings, but does contemplate that the sale of edibles, a broader range of products that would be competitive with the illegal market. Upon introduction of the legislation, the government indicated that it would seek to bring that sales at the outset of the coming into the force of the legislation would be for dried oil and plants, and that it will take us a little bit more time to develop regulations that we would need to bring into force for edibles. If you would like more information.
Yeah, my question is I understand that upon coming into force of this bill, edibles will not be legal. I understand that the bill contemplates future legalization, but am I correct that it will not be legal? The day after this comes into force, I can't go buy edibles, can I?
That's correct.
Thank you. My question was, what percentage of the market currently is taken up by things that will still be illegal upon coming to force of this bill? Does the government not know?
I don't think I have that information, and I can commit to get back to you if we have an estimate in that regard.
Okay, thank you. Well, my research indicates that about 65% of cannabis in this country currently is being smoked, and about 35% of the market is being accessed by people who actually don't want to smoke cannabis, both for health reasons and for a variety of other health-related and preference reasons. So if one of the purposes of this bill is to bring illicit black market products into the licit regulated market, I'm having trouble understanding how it will achieve that if we still leave to the black market 1/3 of the products that Canadians are currently accessing, and I'm advised growing, by the way, because people are seeking to move away from smoking, and they prefer to ingest cannabis in healthier ways. Isn't it the case that by leaving those products illegal, we're still going to have Canadians accessing those products in the black market way and therefore not really achieve one of the prime objectives of this bill?
So thank you for the question. I'll perhaps start and then turn to my colleague, Mr. Costin. So you raise a very important point at the outset of the coming into force of the legislation. I guess the first thing I'll say is that you're absolutely correct that an increasing number of Canadians are, choosing not to smoke cannabis, but rather moving to smoking or to consuming, for example, cannabis oil, which can be consumed in many forms. I should clarify that Canadians would be able to consume cannabis oil in the form of edibles. They could bake it into goods as they do now. People create butters at home and things like that. There is a provision in the legislation that would prohibit people from using dangerous solvents to produce those edibles at home. So people would have the ability to consume it in healthier ways.
Ask you a question about that, because I'm curious about that. You indicated that one of the purposes of the bill when you went through our Clause 7 was to provide Canadians with regulated, quality-controlled cannabis. Mm-hmm. How is leaving Canadians to bake their own edibles in their own kitchens with no quality control whatsoever? And I would imagine that some of those products are going to get out of those kitchens and be shared with neighbors, etc. How is that giving Canadians quality-controlled cannabis as opposed to regulating edibles and other products like the task force actually recommended this government do?
Mm-hmm. Thank you for that question, Mr. Chair. I think it's important to recognize that it will take time to be able to have all of the regulations in place to implement this legislation. We have existing regulations now that govern the production of cannabis for medical purposes that can be used and easily brought into force with respect to the production of cannabis, dried cannabis and cannabis oil. The government is planning to have the regulations regarding edibles prepared as soon as possible so that those could be brought into force quickly.
I'm sorry, I'm going to move to something else if I can. The Government of Canada information relating to C45 explained that provinces or territories could increase the minimum age of sale for cannabis, but it also says that they may lower the personal possession limit in their jurisdiction, and that's from the Government of Canada legalizing and strictly regulating cannabis, the facts. Is that correct? Would this legislation permit provinces to lower the personal possession limits, which I believe is 30 grams?
Yes, that's correct.
So what if a province decided to reduce that to 0?
I'm going to ask my colleague from the Department of Justice, if that's all right, to answer that question.
Thank you, Mr. Chair, and thank you for your question. As stated in the legislative backgrounder as well, we have used that example. The scheme set out in Bill C-45 provides for the prohibitions, offenses, and penalties, and authorizes activities in relation to cannabis, while allowing at the same time provinces and territories to enact legislation of their own in this same area. this comes back to how the legislative power is divided amongst the federal level and the provincial level. Health is one of these areas that's been stated as or described as amorphous by the Supreme Court of Canada. So depending on the purpose of the legislation, it can either fall to Parliament under the use of the criminal law power or to the provinces in this very area under a power of their own, for example, local matters or civil rights.
Ms. LaBelle, can it go to zero? What's the floor that a province could reduce it to if they could? Could they not defeat the purpose of the
idea
legislation?
here is that each exercising their own authorities, right? Parliament has set an upper limit, for example, for 30 grams in public. A province, for its own purposes, could then set it down to 15 grams for its own purposes. Where we have limits to this kind of range has to do with the double aspect doctrine. So where compliance with one act requires noncompliance with the other, a province brings it down to zero, or where the purpose of a federal act would be frustrated by the provision of a provincial one, again, a province bringing it down to zero, this could give rise to paramountcy. In other words, a court would examine whether there is a conflict or whether the purposes of the federal act are frustrated and can find the provincial law inoperable to the extent of that frustration. So when we're looking at a situation where Parliament is wanting to allow access to a lawful supply by adults, and a province enacts legislation that interferes with that ability to the point where it is zero, then a court, if challenged, right, could look at the situation and see to what extent the Parliament's law has been frustrated.
Thank you.
Dr. Ayolson.
All right. Thank you, Mr. Chair. Thank you all for coming. This legislation, I've always believed is a long time in coming, even long before I was in politics. I practiced emergency medicine for 20 years in Winnipeg. And one of the things I found in my experience was, in one respect, cannabis was a very dangerous drug in that it does kill. And how I found that it kills is through the criminal activities of those who market it. I saw an unconscionable number of gunshot wounds and stab wounds and fatal beatings, and the vast majority of them were due to the drug trade. I was once evacuated from an apartment building that was firebombed over a bad drug deal back in the late 80s. Not my apartment, but the building I lived in. So I know the extent of the violence of the current regime and how thriving the black market is. So it's been important that we make a change to this. Now, in regards to some of the concerns that I've heard brought up, now the provinces may set their own ages. You know, some we know that the Canadian Medical Association suggested 21. Our legislation says a minimum of 18. Now, there was an experience in the United States a number of years ago. They increased their drinking age to 21 across the board, but before that there was a variation in ages. They had an experience where if there was a drinking age of 19 on one state and a neighboring state had 21, you had a lot of people traveling over to drink and a lot of accidents. They use the term blood borders. Now, if there was too much disparate age restriction between provinces, would you see that kind of a public safety issue?
I think the situation that we have in this country now recognizes that provinces can make those decisions, and that we do actually have different ages for alcohol. I think I would also offer that the provinces are very alive to that issue that you're raising, and are having discussions amongst themselves about the areas where they might wish to achieve consistency. You know, what are those areas where they might wish to have consistency, and where are those areas that they could live with that inconsistency but put in place mitigation measures of some kind.
All right, thank you. Now, in regards to the policing costs, there's been a lot of speculation. Well, the province is saying, how much is this going to cost? We should be getting money for policing. Is there an estimate as to how much the current regime is costing police departments, because we know police resources are right now being used in, arresting people for simple possession, these people going through the court costs, these sorts of things, and also the societal costs of these people with criminal records that can't get jobs now because of this. So is there an estimate as to how, if not a solid number on that, then how the current costs of our current legal regimen might compare with what they would be after this legislation's passed?
I could perhaps, my colleague from Justice, Madame Morancy, could respond to that question.
I don't have an actual estimate of the cost, but what I can indicate to the committee is what's the magnitude of the charges and the offenses before the criminal justice system today. So you may know that the Canadian Centre for Justice Statistics releases an annual report on police-reported crimes. And in the July Eurostat, which reflects the 2016 data, they reported that there were just over 95,400 offenses reported to police under the Controlled Drugs and Substances Act. Of these, 58% were relating to cannabis. If you drill down further from there, cannabis possession was the #1 charged offense. So in 2016, 76% of the charges were for possession of cannabis, or 17,733 charges. How does that translate to the criminal justice system? Well, the committee may know that the Supreme Court of Canada pronounced on the issue of delays in the criminal justice system in July 2016. Volume, the number of cases being processed through, has a huge impact on the system. So presumably, as C-45, if and when C-45 is enacted and implemented, one would expect to see less charges being laid for simple possession. To the extent that there are charges or there's an offense being committed, police would have new authority under Bill C-45 to deal with ticketing for smaller amounts that are slightly over the 30-gram possession, so between 30 and 50 as an example. And then beyond that, the regular penalties would apply. So Bill C-45 would definitely have an impact in diverting many charges from the system officially, to the extent that some stay in, provides new tools to police and Crown to deal with them in a more efficient, effective way. Thereby, we would expect reducing some of the costs to the system overall.
Thank you very much. How much time do I have left?
1 minute and 12 seconds,
Great, thank you.
approximately.
All right. Now, this is directed at justice. They talk about some of these offenses being ticketable offenses as opposed to a criminal record. Now, one of the concerns that people have regarding anything to do with drugs, we know that people who travel to the United States, if you so much as admit to a border officer that you've ever consumed marijuana, or if you're even on the public record as admitting it, that you might be indefinitely banned from entering the United States. If you have one of these ticketable offenses, like I know that U.S. Border Services would have access to any of your criminal records. Would they have access to these lesser offenses? So if you had one of these tickets, would this be somehow accessible to the database of U.S. Border Services?
I think there's two parts to the question, and I'll start, and then my colleague can finish. In terms of the ticketing offenses, the Bill C-45 requires that if a person is convicted pursuant to a ticket, that record, judicial record of that conviction on the ticket, remains separate from other records and cannot be used to identify the person. So it is treated differently than a criminal record. And then to the rest.
And just to build on that, it's currently prohibited to import or export cannabis. That will continue to be the case. We will continue to be prohibited to import or export it under the Controlled Drugs and Substances Act. Moreover, CBSA will be undertaking awareness campaigns. They have received some funding to do that. They'll have clear signage to warn Canadians not to take cannabis across the border, and also Canadians should be aware that cannabis is illegal at the federal level in the United States, and so we'll make that very clear to Canadians and make sure that they understand that that is and continues to be the case.
Thank you.
Ms. Morency, could you clarify that statistic you gave us on 76%? What were those numbers you gave us?
So of the number of charges actually laid for possession of cannabis, there were 23,329 persons charged with cannabis-related offenses. Of those, 76% were charged with possession of cannabis.
Okay.
So
Thank you.
we can provide the link for the Jurostat to the committee.
If you would, please, yes.
So it came out in July. It's the Jurostat for the year 2016 data.
Okay, that completes our 7-minute rounds. Now we go to 5-minute rounds with Dr. Carey.
Thank you very much, Mr. Chair, and I want to thank all the witnesses for being here, because at the end of the day, I think everybody's priority is the health and safety of Canadians, particularly our youth, and I think everybody would agree that youth use is obviously too high. But I'd like to maybe challenge a little bit what Madame Bogdan said, and you said clearly the status quo is not working, but according to the World Health Organization and the Public Health Agency of Canada, they released a survey of over 30,000 kids in 377 schools across Canada. This survey was first administered in 1990. And according to this survey, which surveys kids, cannabis use is now at its lowest level since 1990. About 23% of boys and girls aged 15-16 report having tried the drug, which is down by half compared to its peak in 2002, when 50% of boys said they had smoked. So I was interested that you parroted exactly the government's line that Mr. Oliver put out, that obviously the status quo is not working. So if we define the status quo, we've seen the rates go from, say, 50% to boys, and maybe it's just 40% or whatever. But clearly we're seeing a decline to where they're saying it's around 22% now. If we're saying a decline of that percentage is not working, how would you define a system that is working? And how are you going to measure what you're going to be doing? And do you have any evidence to suggest that legalization is actually going to lower that even further?
Thank you for that question, Mr. Chair. So I appreciate that. I shared with the committee the information that we have. The Health Canada does regular surveys of Canadians and young people to get a better fix on on the rates of use. I think perhaps and we are also investing additional funds in to undertake additional surveys to get even a better sense of.
My question though is that you've said that the status quo is not working.
Yes.
And I'll take that statement at face value, what you said, but according to the evidence that's out there, it seems like it says cannabis use is now at its lowest level since 1990, and it seems significantly so. The approach of legalization, we've had a few states that have done it. Is there any evidence that that will go even lower with your approach? And if you define it as not working, going from 50% at its peak down to 23%, how are you going to define something that's working?
My colleague, Mr. Costin, will answer your question.
Sure. I'll do my best to answer your question. So I'm not familiar specifically with the data that you're making reference to, but I can talk a little bit about the data that we have at our fingertips, which inform the position around youth access. So the Health Canada, one of the Health Canada surveys that Ms. Bogdan was referring to is called the Canadian Tobacco and Alcohol Drug Survey. It's a survey that's issued every few years, and it allows us to track use longitudinally. And most recent data comes from the 2015 survey, and this is the data that is often described. The 15 to 19-year-olds report about 21% report use, 20 to 24-year-olds report about 30% use. When we look at this survey over the course of the past decade, the levels have been fairly unchanged. They've been relatively unchanged at those levels. I think to your question, the second part of your question about what confidence we have that in moving to a new control framework that we might see those rates decrease. I think the experience in Canada in terms of tobacco control is perhaps illustrative insofar as you have a fairly aggressive regulatory regime coupled with a number of other education and prevention and cessation and policy interventions.
Mr. Costin, that is theoretical, and what I was quoting is the World Health Organization and the Public Health Agency of Canada. They released it. It is the 2014 Health Behavior in School-Age Children Survey. So maybe you can take a look at that, but I'm not talking about a theoretical thing. We're worried about our kids. And that's kind of where I wanted to see how are you actually coming up with the statements that you're saying the status quo isn't working. So maybe just I'll move along here to Ms. Crampton. What happens today if I'm under 18 and I get busted for a couple joints? What happens to me? And if I turn 18, does that record get wiped or does it stay on forever? How does it work?
So legal might be better to answer with regard to what happens to a criminal record. But there is the option of charging under the Youth Criminal Justice Act. A youth could be charged with an offense of possession. However, there's always officer discretion involved in any charges that we lay.
What happens today, the officers do have discretion, but with the proposed legislation, I believe the amount was 5 grams. From age 12 to 17. And I don't know if you are aware, but 5 grams of marijuana, I think it can go for 10 to 15 joints, right? And this is not just high school. These kids are in public school, some of them. So maybe I will ask Justice, like what happens now if I'm under 18? I believe, Ms. Morrissey, you said that this is going to be something that stays with me my entire life, but I know people that have been charged in the past. I think at 18, doesn't it get wiped? Or it can get wiped, right?
Yes, records can. For youth records are dealt with, absolutely. They're dealt with differently, and they're protected against disclosure and after the sentence has been served. But in the sense of what your question was, I think was dealing with 2 aspects. What happens now when a young person is found in possession of drugs? Police have just discretion right now.
Yeah,
under
most
the
of the time they
Criminal
don't
Justice
charge,
Act, right?
right?
They can do
They can.
a warning, a caution, refer to a community program, where charges can be laid. Under C-45, that discretion would continue to apply where an offense is alleged to have been committed by a young person, but you were talking about the 5 grams.
Yeah.
Again, that would depend on whether a province has implemented a different approach to deal with the 5 grams under their non-criminal law
Well, I'm talking
powers.
about this legislation. Seems to be okay with 5 grams, and I'm just saying people in my community aren't okay with that. And
So if we can let her answer.
sure, yeah.
So I would just say that Bill C-45 is not promoting, condoning the use of cannabis, but it recognizes that a young person who does come into possession and uses a very small amount, 5 grams or less, would also be exposed to a greater harm that comes with the criminal records, which can affect their ability to for employment. It can affect other issues down. So there are harms getting involved with the criminal justice system itself, not just the record, but the whole experience of being involved in the system can also have a greater negative impact than what comes from a small use of a small amount of cannabis. But all of that to say as well that the government, as has been noted, is having a public education campaign to promote awareness not only amongst youth but amongst all Canadians about the harms of cannabis use, etc. So that would be part of the targeting for youth, not to have access to it.
Okay, thanks very much. Mr. McKinnon, welcome to the committee and look forward to your contribution.
Thank you, Chair. I guess I've got questions all over the map here, so we'll just dive in. First one is, I wonder if you can clarify. My understanding is that Canadian youth have the highest rate of cannabis consumption at least in the OECD countries. Mr. Costin, could you comment on that?
There are a number of different surveys that look to measure global use of drugs. There was a survey released by, I believe it was UNICEF, a number of years ago that put Canada as the top-ranked country in terms of youth use. There are other international instruments that look to measure youth use, and while the particular methods and the results vary, the results across the board show that Canadian youth do use cannabis at rates that typically exceed their peers in like countries.
Okay. How do we measure youth use? Do we do it by voluntary surveys, or how we?
Yeah, I think the different surveys use different methods, but typically it's a self-reported use. So they would ask a question about, have you used in the last year, in the last 6 months, and then the respondent would volunteer their answer, and that's typically how they're done.
Okay, thanks. I'd like to move on to the 5-gram limit. Ms. Bogdan, I believe you mentioned that one of the goals here is to protect youth, and one of the harms from which we are protecting them is a criminal record, having a criminal record. It seems somewhat counterintuitive then that we put youth into the regime, in the criminal justice regime, at a much lower threshold than for adults. So an adult doesn't get into the area of a criminal charge until they have 30 grams of cannabis in their possession, whereas a youth happens at 5 grams. That seems counterintuitive to me. I wonder if you could comment on that. And I'm wondering if there is a need for a lower limit for youth, or rather that within the same 30-gram limit, we just confiscate, fine, whatever, but no criminal record risk, if you could.
Okay, thank you for that question, Mr. Chair. I think I'll just start by saying that the legislation is very clear that young Canadians shouldn't have access to any amount of cannabis. I think that is, absolutely clear. And I'll ask my colleague Carol Morancy to explain again the reasons for that specific provision under 5 grams to try to answer the honourable member's question.
So, C45 proposes to prohibit providing, distributing, selling any amount of cannabis to a young person, proposes to prohibit using a young person to commit a cannabis-related offense. So the expectation with the framework for C45 is that youth should not have any amount of cannabis for use or possession. But the recognition, and that's based on the health as well, that's already been described by my colleague in terms of the objectives of protecting young persons against the harms associated with use of cannabis. But also, as has been noted, the reality is under a completely prohibited regime, youth in Canada still have high use and possession of cannabis. Recognizing that, Bill C-45 proposes to carve out a very small amount that if a young person is found to be in possession of 5 grams or less, Bill C-45 reflects the choice. Should that person be criminalized, even under the Youth Criminal Justice Act, which has a lesser, more restorative, rehabilitative approach, or should they be given a different way to be dealt with under the law? So it carves out that 5 grams from the criminal law perspective because it recognizes the greater harms of exposing young persons to a criminal justice system, not just the record, but the whole system, for that small amount, but leaves it, and the federal government has been encouraging the provinces and territories to take that 5 grams and decide how will they deal with it if they choose to do so within their areas of legislative competence. As I mentioned, Ontario has already announced that they would not allow any possession of any amount by young persons, so they would not allow the 5 grams under their legislative approach. And they would raise the minimum age from 18 to 19. So a different approach for youth altogether than adults, because adults are different than the level of maturity. The government C-45 is proposing to legalize, but strictly regulated for adults, and to endeavor to keep it out of the hands of youth altogether.
Moving on now to Mr. Weber.
Mr. Chair. I just want to talk about the production and the regulations around that. I had the opportunity to tour a licensed facility in Airdrie, Alberta, Sundial, a few weeks ago, and I was quite surprised, actually, to see the amount of security around the facility. Coming into the facility, the barbed wire, the razor sharp, it looked like a federal prison going into this marijuana facility. security, the buzzing you into rooms, but touring the facility also showed me the quality that they were producing there, and it was incredible. There was no doubt that this will be a safe product, not contaminated in any way, which is a nice thing to know. But the costs, the overhead costs to put this facility in place were immense, of course. And so with that, obviously the product will have to be sold at a high price as well. And of course, Canadians, I guess, are willing to pay a high price for a safe product, but I don't see it, the average Canadian being able to afford that kind of product. They will obviously will have to go to some other supplier, meaning organized crime. I don't see a displacement at all in the illegal market with the requirements that are already in place. You talk about in time that the illegal market will be displaced, but with these regulations that are in place right now, I just don't see it. And I just wonder, Ms. Bogdan, if you have any comments on that. Does the government plan on continuing with these strict regulations on all production of marijuana throughout the country?
Okay. Thank you for that question, Mr. Chair. So the requirements that are in place right now that govern production for cannabis for medical purposes are under the current legislative framework, where all cannabis, unless it's authorized by legislation, is prohibited, and thus there are stringent requirements around security to protect against diversion to the illegal market and a number of other measures. I would also say that there is considerable analysis that some of the product that is currently produced under the access to cannabis for medical purposes regime is actually competitive with some of the product that's available with the illegal market. That said, knowing very well that one of the government's most important objectives is to displace this illegal market, we need to be very conscious of that in creating regulations that will govern the production under the new industry. So I'll maybe ask my colleague, Mr. Costin, just to speak a little bit about the need to put in place regulations and the considerations that we're thinking about.
Mm-hmm. If I may even go back to the price question just briefly. The Parliamentary Budget Officer, in the report that they published a number of months ago, included quite an elaborate commentary on price, including providing a mid-range average of the current illegal market price, which put it, if memory serves, just under $9. And while I think the observation you've made is a very good one, as Ms. Bogdan just described, when we look at the reality of pricing amongst the licensed producers, the average midpoint price is only slightly higher at just over $9. So this is obviously is going to be a very dynamic marketplace, and price is going to be absolutely critical to achieving that second principal government objective. And I guess in terms of your question about regulations and the future of those regulations, as no doubt you've observed in C45, there are reg-making authorities across a whole manner of aspects of the new system, one of which is around security, whether it's physical security and security of the personnel. And just to echo Ms. Bogdan's comments, that the regulations that are in place right now really were kind of born in time, given the legal status of cannabis, and I think given all of the observations that have been made about the interest that the organized criminal organizations have in this marketplace, and so they were designed in such a way to create a system with a lot of integrity, so that we would, whether it's from a consumer perspective or from a government perspective, that the system wasn't being infiltrated by organized criminal organizations. So that, in some part, explains the stringency that you observed.
Mm-hmm. Oh, thank you. Mr. Ayoub.
Merci, Monsieur le Président. Merci à tous les témoins.
Thank you, Mr. Chair, and thank you for all
to all witnesses for joining us. It's a very important subject for generations in the future and even for the current ones. I will concentrate. I have a lot of questions, but I will concentrate particularly on the legislative side of things. The differences between the application of Canadian legislation in the provinces, and the government has a leadership role. That is what we're currently doing by discussing this important bill. How will we ensure that we create Canadian legislation that doesn't give a criminal record depending on the differences between the provinces? I hear some provinces will choose, like Ontario, to not allow for full possession, but in other provinces, if people travel, there are no borders. And, for example, there's Ottawa and Gatineau. How will this issue be managed? Can you please shed a bit of light on this issue? I'll start with Ms. Labelle.
Could take that question. Merci beaucoup pour votre question. Je vais répondre en anglais.
Thank you very much for your question. I will answer in English to
I give you a completely accurate answer. I think the legislation that is before this committee, recognizes and sort of flows from consultations and discussions with the provinces and territories, who identified, in their conversations with the task force and their conversations with the federal government, the desire to have a degree of flexibility in how they design how this system will operate in their jurisdictions. And that's a fundamental aspect of the way in which, this country is governed, is that there is flexibility that provinces can exercise, that they're closest, as municipalities are, we also recognize that, closest to their jurisdiction.
Je comprends très bien la nuance, mais là où je veux aller vraiment, c'est
I understand the nuance, but I really want to get to the application and the criminal record, if there is one. How will that be managed from one province when it has different regulations? I'd just like to draw a parallel between crossing the Canadian border at the American border. That's very clear. On the one hand, we know that it's illegal on one side, and in Canada we're working to make it legal. But how will there be legislation across Canada, within Canada, and that is applicable in all provinces? I'd like to speak about the legal aspect. If you would allow me, Mr. Chair, I will answer your question concerning the application of criminal law. The most important bans in C-45, the right remains the same, the law remains the same across Canada. Where there may be slight differences, and it might be slightly difficult to answer your question, well, it will depend on provincial legislation. And to look at that, we really need to see the details of each of the pieces of provincial legislation to know when there might be a penalty under provincial law and a penalty under the legislation proposed in C-45. It is something being studied. It will be studied when the legislation is drafted, and discussions between the provinces and the territories will be very important in this respect. And as Ms. Buckton said, we also want an approach that is based on the federal cooperation. It is important to recognize that the provinces wanted to have their say, and we need to give them this opportunity. This opportunity needs to be given to them to adopt rules that are tailored to their circumstances. When it comes to the application of the legislation, well, it's a bit theoretical right now. Well, the goal, if I can make one last remark, the goal is to legalize and decriminalize, in part, the use and production of marijuana. So this is the federal government has leadership role to play, and obviously we are working in collaboration with the provinces. But we need to ensure that all of this can be merged appropriately, and that everyone understands the goal towards which we are working. Yes, and we agree. And that is what we are working on in our discussions with the provinces and territories. Thank you.
Rounds, and now we go to the 3-minute round with Mr. Davies.
Thank you. Just to be clear, so this legislation sets a limit of federal limit of 30 grams possession, but you've confirmed the provinces may change that. So you could have one province that has a 28-gram limit, one that has a 25-gram limit, one that has a 20-gram limit. I understand you would look at that to see if it offends the fundamental premise of the bill, but we could end up with a patchwork across this country of different cannabis possession amounts. Is that not possible?
Yes, the approach in C45 is such that it allows for provinces to make a determination based on their local population and local needs as to the range of possession limits. They could not, I think,
violate the principle of the bill to the zero. So I get it. Thank you. Ms. Morency, you gave a very passionate and I thought cogent explanation of why this bill permits 12 to 18-year-olds to possess up to 5 grams, which is almost a quarter ounce of marijuana. And you explained that it's because the bill recognizes the increased relative harm of exposing young Canadians to the criminal justice system for simple possession. If that's the case, why is this government arresting those Canadians now? I mean, wouldn't it make sense then to not be enforcing the law right now and not subject those young Canadians to the stigma of criminal justice system presently?
I would just reiterate what the ministers and the Prime Minister have said on this point, which is that the law remains the law unless and until Parliament enacts a change to that law. And to that end, law enforcement, Crown deal with cases as they are presented, because that's the system that we have.
Thanks. To the RCMP, has the government given any direction to the RCMP to perhaps exercise discretion against charging Canadians, particularly young Canadians, until C45 is passed? Have you received any directions that way?
No, not at all, and I would expect that we wouldn't receive that kind of
Thank
action.
you. Ms. Bogdan, does this bill, once it passes, will it allow Canadians to consume cannabis by vaping?
That's a question that relates to the regulations. It's a good question.
Does anybody know?
I'll ask my colleague, Mr. Costin, to answer that.
So this is a continuation of the questions you were asking earlier about edibles and a range of products, which
well, no, this is about
vaping particularly. Yeah. So scheduled to the Act lists the types of cannabis that would be legal and sort of itemizes them. The question of vaping, in particular, speaks to the qualities of what is being vaped, and so to the degree that there are chemicals used to create vaping cartridges that are not included in the schedule, it would not be permitted at the time of issuance. To the degree that those types of cannabis listed in the schedule could be used in a vaping, then it could be possible.
One last question. Dr. Elfson asked a question about Canada-U.S. relations. Canadians know when they go to the border, U.S. border guards will often ask, have you ever smoked marijuana? They don't ask about convictions. They ask if you've ever smoked marijuana. Once this bill comes into force and it's legal in Canada, Canadians will be put in the position of either having to lie about that or tell the truth and risk lack of entry. So my question is the Canadian government right now engaging in discussions with the United States at the NAFTA table or otherwise to protect Canadians once July 1, 2018 comes, if in fact that's the date that cannabis consumption is legal in Canada?
Thank you, Mr. Chairman. I'll take that question. As I said earlier, CBSA will be working to make sure that Canadians are aware of the fact that it is illegal in the United States, and also that that it's illegal to import and export, continues to be illegal and prohibited to import or export. But also they'll be reminded that every country has the right to determine admissibility, as does the U.S. And they will be counseled on telling or responding truthfully to any questions asked by a border official. So we'll make sure that the information is available. We also talked about for ticketing where the record is maintained in terms of those judicial charges. And so we will try to get as much information out to Canadians as possible. With respect to your question of are we engaging with our U.S. counterparts, absolutely. We have been, and we continue to be engaged with them as the bill continues to progress through Parliament. So they are in discussions with us, and we're trying to communicate the objectives of legalizing but strictly regulating cannabis and why we're taking that approach.
We have time for another first round. Is it the committee's wish that we continue to ask questions based on round one, only instead of 7-minute questions, we have 5-minute questions? Do we have consensus on that? All right, we'll start again with the Liberal Party, 5 minutes. John?
Okay. I had a question about federally licensed distribution versus provincially territorial licensed distribution. So, as I understand it right now, when the bill is passed, a federally licensed producer can distribute through e-commerce provisions, can distribute to people that are buying online. It's delivered through Canada Post and shipped that way. So the province of Ontario, for instance, just came out with its sort of plan with the LCBO to be its main distributor. So how would that federally, first of all, is it true that a federally licensed producer can distribute through e-commerce in the provisions of this legislation? And what happens then to the provinces that think they sort of have their sort of hands on how it's going to be done, and there's this parallel federal system?
Okay, thank you for that question, Mr. Chair. So the legislation provides for provinces and territories to be able to authorize distribution and retail in their provinces, and that is that's the design of the bill. As it relates to the perspective coming into force of the legislation next in July, no later than July 2018, which the government has committed to do, providing the legislation is passed by Parliament, what you're referring to would only apply in provinces and territories that have not put in place a regulated retail system. So if provinces have, put in place a regulated retail system, then those rules would apply, providing, of course, that the legislation meets the minimum conditions that the government has set out in the federal legislation. And for those provinces that have been able to or have not yet put in place a system, the federal government will then authorize federally licensed producers to distribute in those jurisdictions.
So where do I find in the legislation the right of a federally licensed producer to directly sell? Otherwise, it looks like it's illegal.
I'm sorry. Thank you, Mr. Chair. It is both a policy and a legal decision. From a policy perspective, my understanding is that as provinces establish their own regimes for retail and distribution in the provinces, the federal government would then be satisfied that there's lawful access for adults in those provinces, and then could step back in terms of the online sales by licensed producers. There are various ways that the Minister of Health can address the licensing aspect by licensed producers. Where we might draw a distinction is with respect to licensed producers continuing to sell directly for medical purposes.
So how does that happen in real terms? Does the province then have to pass legislation that says we forbade any e-commerce shipping other than what we've envisioned through our permissions? Or is it, how do you actually police? And to me, it seems like a big, opaque, unclear aspect of distribution that it's hard to determine in the legislation how you intend to handle it.
I think what's clear, if we look at Clause 69, is that a province brings into place a statute that covers four important aspects. That they can only sell cannabis that's been produced by a person authorized under this act, in other words, a federally licensed producer. They may not sell to young people. They're required to keep appropriate records.
I understand what the province's requirements are.
And so once they have that legislation in place and they establish their retail sales system, whether that's online...
So do you then federally then forbid e-commerce into that province at that point in time?
It's not that it is forbidden. It is that the Minister of Health has the tools necessary to address the situation through the licensing of licensed producers and which jurisdictions they can go into. And Mr. Costa may wish to add to this.
So maybe to try and wrap this all up, I'm not a lawyer. So the policy intent behind this really is a recognition that on day one, that consumers in Canada have a legal option to purchase cannabis. The policy design of the entire system suggests that the ultimate retail environment will be designed and implemented and overseen by provincial and territorial governments. If on recognizing, as Ms. Bogdan said in her opening remarks, this is a transformative and complex undertaking. Recognizing it on day one, if a particular jurisdiction doesn't have a retail environment established yet, there is the option that at the federal level, a producer who is licensed by the federal government can sell directly to a consumer in a particular jurisdiction.
That option is a granted permission, or is it just there as a legal thing they can do as of?
It would be, I mean, there are a bunch of different regulatory mechanisms by which we could grant it, but it would be a permission given to the company. And it can be defined, that permission can be defined in a number of different ways. Does that help?
So for me, like I believe I could phone a winery in British Columbia, order wine from them, they would ship it to me, it would come through Canada Post, taxes would be paid. Why would you not be recognizing both that ability to ship from a local producer versus limiting it to prevent different provinces and different territories' distribution strategies? Why don't you allow that sort of Canada Post delivery system?
So just so I understand the question, you're asking why that provision would perhaps only exist as a transitional measure, and
no,
why wouldn't it be a permanent feature?
As an ongoing strategy for access to different markets.
And as the bill is designed, that possibility is allowable. It also just, again, it recognizes my comments kind of recognize, for instance, even the Ontario announcement, where as a part of their announcement, they described wanting to enable an online sales platform, much as you've just described, pursuant to their legislation. And so recognizing against the bigger policy design is the retail experience would be described by and defined by the provincial legislation.
Thank you very much. As interesting as this is, the time is up. Ms. Gladder.
I think my colleague brings very good points that are worth looking into, because I think it's illegal to buy BC wine and ship it to Ontario anyway. I want to talk a little bit about one of the outcomes Canadians wanted from this legislation. I think we were trying to, in some way, offload the huge number of possession charges that were clogging up the courts. And so in this legislation, I see a lot of protections that are trying to prevent trafficking and trafficking to younger people. But one thing I don't see, and maybe it's in here and I just haven't seen it, young persons are described as people between 12 and 18. There's really nothing in this legislation that prohibits people trafficking or being charged for trafficking to folks less than 12 years old. Ms. LaBelle, could you comment?
Thank you for the question. This is a criminal law policy question, and my colleague, Ms. Morossi, is best placed to respond to this.
So Bill C-45 prohibits distributing, providing, selling cannabis to any young person under the age of 18. A young person between the ages of 12 and 17 who would not be criminalized for possessing 5 grams or less could also share it. Similarly, right, wouldn't be criminalized with another youth at the same age. But the age of criminal if the age of criminal responsibility is 12 to below 18 under the Youth Criminal Justice Act. So anyone who gives it, an adult who gives it to any young person is criminalized, but the youth person is dealt with differently.
Yes, but the problem is that in the definition within the bill, a young person is defined as being between 12 and 18. So maybe the definition needs to be fixed, because otherwise there's no protection then for anybody under 12.
But no, but that's for the the age that you're referring to is for the purpose of charging a young person with a cannabis-related offense. The C-45 clearly prohibits any adult organization to provide, sell, distribute cannabis in any form to any young person.
Where is it defined that young people are everybody below 18 in the bill? Because that's what I didn't see. Anyway.
Well, if you look at the offense provisions in the Act or bill, so for example, Article 9, which deals with the offense against distribution, page 8 of the bill. It's an offense to distribute cannabis to an individual who is under the age of 18 years. It would be the same for the selling, etc.
Okay, very good. Thank you. So then the other thing I wanted to talk about was the possession quantities. So it sounds like a lot to me, 30 grams possession, which depending on how you roll it, and I don't have any experience in this area, but I'm told that that could be between 60 and 90 joints. That sounds like a lot. So I guess I'm interested in what would typically would we be finding with people that we think are trafficking? What's a typical amount, and how did we come to the 30-gram amount? And maybe I'll start with Ms. Crampton.
I wouldn't be able to, thank you for the question. I wouldn't be able to speak to how the 30-gram amount was established. I believe Ms. Bogdan would be best to answer that piece.
So the 30-gram amount that you find in the legislation is one of the recommendations of the Task Force on Cannabis Legalization, which this was one of the key design questions that the government asked the task force to consider. And after extensive consultations and careful consideration, and part of it was consultations and deliberation. I think the task force, as it noted in its report, also looked at other jurisdictions, measures that other jurisdictions had taken, such as Colorado and Washington, and its recommendation to the government was 30 grams was a reasonable amount that individuals could possess for personal purposes.
And one other question, and that has to do with packaging and regulations for cannabis versus packaging and regulations for the tobacco industry. It seems to me that there's a lot of similarities in terms of how we would want to, protect the public and use some of the learnings that we've had. We've spent billions of dollars trying to prevent people from smoking. We know that the toxicity of cannabis smoke is about 5 times as much. So, Ms. Thompson, perhaps you could comment on why there are differences in the legislation between how we package and regulate tobacco versus cannabis.
Yeah, that's. I think that would be more in Health Canada's jurisdiction. So the point that the honourable member makes is a very important one about the role that packaging and labelling, and in particular, or promotion and advertising the role that may play in encouraging youth to use these. Now, the legislation before the committee provides the government with the authority to establish regulations that would put in place additional controls around, for example, packaging, labeling, and other measures that, such as child-proof, child-resistant packaging that would better protect youth. And of course, the experience that we've had with the regulation of tobacco, we are continuing to learn important lessons about how to regulate these substances in a way in which that will discourage use among youth, and we will draw from those lessons as we develop those regulations for consultation.
And did the oh, sorry.
Mr. Davies.
Thank you. The statistics that we heard about 23,000 people being charged in 2016 for cannabis, 76% for possession, obviously leads to the conclusion that there are hundreds of thousands of Canadians who have convictions for cannabis-related offenses, many of which will this legislation will make legal. I'm wondering, does the Department of Justice have any plans to deal with some sort of streamlined pardon process for Canadians who have been convicted of offenses that will no longer be legal under this legislation? And I'm reminded of the fact that the previous Harper government raised the price of pardons to, it's over $600 to apply for a pardon, and you have to wait 5 years. So is there any contemplation or consideration to helping Canadians receive pardons for offenses that this bill would no longer make an offense?
Thank you, Mr. Chair, for that question. I would ask my colleague, Ms. Thompson, to respond to the honourable member's question.
Thank you, Mr. Chair. There is currently, as the honourable member noted, there is currently a process whereby Canadians who have been convicted of sole single possession can apply at National Parole Board for a pardon, as you indicated, 5 years after serving their sentence. That is the process that is currently in place. There are no plans at this time to introduce an automatic pardon, as suggested.
I want to go back to the sentences that are proposed under this legislation. If I understand correctly, there's the penalties for which someone may be subjected for a contravention of the Act range up to 14 years in prison. So if you have a 19-year-old who sells cannabis to a 17-year-old, am I correct that that would subject them to that potential penalty? They would have the range of being sentenced to prison up to 14 years?
So, as you've noted, the bill proposes a range of penalties for the offenses. The offense that you're referring to in terms of selling is currently under the Controlled Drugs and Substance Act. It's trafficking offense, and it carries a maximum of life imprisonment, and it imposes mandatory minimum penalties. Under Bill C-45, the offense of distribution or selling would be a hybrid offense, meaning that the Crown would have the right to elect to proceed summarily for less serious offenses and to proceed on indictment for more serious offenses. And on indictment, the premise is correct that it would be a maximum of 14 years. But on summary conviction, if it's an adult who sells, for example, to a young person, the penalty would be higher than for an adult, so maximum 18 months. But if it's an adult who sells to an adult, the maximum would be 6 months. So what Bill C-45 does is to provide greater flexibility to criminal justice system, including crowns, including courts in terms of sentencing, to proceed in a manner that best reflects the seriousness of the offense, with more flexibility for the courts at sentencing to deal with a range of possibilities in terms of just instead of an indictable only offense with a maximum of life imprisonment.
Thank you. In weighing the arguments for and against limitations on edibles, the majority of the task force on cannabis legalization regulation concluded that allowing edible products offers an opportunity to better address health risks. Edible cannabis products offer the possibility of shifting consumers away from smoked cannabis and any associated lung-related harms. So to our representative from the Health Department, why did the federal government ignore that recommendation?
Thank you very much, Mr. Chair, for the question. I think the legislation is clear that it contemplates a wide range of products, that it is important if we are going to meet the objective of displacing the illegal market, that we need to be able to provide, something that can actually compete with that, which would include a range of products. So it is the government's intention that edibles would be available. As I indicated, we will need a little bit of time to develop those regulations, to consult with industry and others before bringing those into force. But the intention is to do so as expeditiously as possible following the coming into force of the legislation.
Okay, thank you. Thank you.
Thanks very much. Dr. Olson.
All right, thank you. Now, there were some concerns brought up regarding cultivation at home, particularly with quality control. Where would be the quality control when someone's growing it themselves? What are the safety considerations? Now, for a very long time, people have been able to brew their own beer and wine at home. And can I ask how similar or different this provision would be from the currently existing ability to do those activities?
So I think I would say a couple things about cultivation at home. One is a point that the task force recognized in its report is that there are many circumstances where individuals grow a small number of plants and can do so safely at home. Of course, as the health regulator, we will want to do our part to make sure that Canadians are aware of the potential, risks associated with cultivating cannabis at home. Under the current medical access regime, there are provisions that allow people to grow cannabis at home for medical purposes. We undertake extensive education to try to help Canadians be aware of some of the precautions they should take. So just for example, we will want to actively encourage Canadians to take measures to protect children, right, to keep it, whether it's indoor or outdoor, to protect children from accessing it. We also encourage, Canadians to make sure that there's enough ventilation. If they're growing, particularly if they're growing indoors, you want to be able to remove, excess moisture on the plant, which could cause mold or in your buildings. If they're going to use chemicals, such as pesticides in the growing, we'll encourage them to have a look at the very important information that we have available. So those would be an active part, I think, in our efforts to ensure that if Canadians choose to do this under the new legislation, that they're well informed about the things they should take into consideration.
Okay, thank you. Is Health Canada aware of any widespread untoward events or widespread health problems regarding these pre-existing practices of making wine and beer at home?
I'm not in a position to answer that question that the honourable member has put.
Okay, no, that's fine. Thank you. Okay. Now, I had some, I had a town hall on this subject a number of weeks ago, and I was approached by some retailers in my riding who sell accessories used in smoking these products. In the vernacular, they're called head shops. They were worried whether, what, in regards to, legislation on the promotion of this, how might this legislation affect how they would do their business and what they might have to do differently under the new legislation?
So thank you for the question. So the question of accessories is dealt with in the proposed legislation. And I think the easiest way to understand what's being proposed is to say that there is no proposal that the government would regulate the production or the manufacturing of those products through this act. However, as it pertains to the sale, as well as the promotion and marketing of those activities, they would be captured. And so in many instances through the Act, you'll see the provisions, for instance, those that apply to advertising and promotion, apply equally to cannabis that will be consumed, as well as accessories.
All right, thank you. Thank you. That's helpful. Now, I just wanted to clarify something that I believe I know the answer, but I just want to make sure it doesn't get lost here. Now, let's say that any one given province just simply says, "We're not going to be ready by this time. We're not going to do anything. We're just out." Can someone in that province obtain cannabis through any online or mail order system?
Thank you for the question, Mr. Chair. So this is the question that we were discussing earlier. So the legislation, of course, is designed so that provinces and territories can occupy that space and be responsible for sale and distribution. In the event that they are unable to do so by the prospective coming into force of the legislation, we will put in place a mechanism whereby the federally licensed producers would be able to provide product directly to individuals in that province or territory. And I think the importance of that is that the government has recognized that it would be very important upon coming into force of this legislation, and that adults are allowed to legally possess cannabis, that there is a legal supply of quality controlled cannabis available to anyone, right across the country. So that we will have that ability to do so.
All right, thank you.
Okay, well, that completes our session. I want to thank the presenters. I think they've done a great job answering questions, and you've obviously put a lot of work and homework in this new evolution of our development. I think it's amazing what you've done and how you've answered the questions. I had two questions myself real quick. Back to households, the ability to grow your own. What happens if a family has two households? So they have a primary residence and a summer home. Does that qualify as two households, or is it one? Second question is, can you grow it inside or outside? Or any regulation about that?
So, Mr. Chair, I'll answer the first question and then perhaps turn to my colleague, Madame LaBelle, to answer the second one. The legislation would allow indoor or outdoor. Of course, I'll also acknowledge that provinces and territories or municipalities could exercise their own authority to put in place additional controls, which might restrict it to growing indoors. On your first question, I'll ask Madame LaBelle to answer that.
Bill C-45 proposes that adult individuals, be able to cultivate up to 4 plants in their dwelling house. That could be indoor or outdoor cultivation, as we've heard. And it has to be where they ordinarily reside. So this becomes a question of fact. If they ordinarily reside at their cottage for 7 months of the year, that may be where their dwelling place is. If it's in downtown Ottawa, where they normally reside for 7 months of the year, then that would be their ordinary residence.
All right, thanks very much. All right, with that, we'll again thank our presenters, and we're going to suspend the meeting until 10:45. And for the members, we have a room reserved just around the corner. Is it 4:15?
4:16.
4:16. Take a break, make some phone calls. 4:16. Now we'll reconvene 10:45. Thanks very much.
Yeah.
One down?
One down.
19 to go. 19 to go.
45, we'll reconvene in our study on C45, and we have a panel on federal, provincial, and territory representatives, as well as some representatives from the pharmaceutical industry. And certainly want to welcome everybody. I want to welcome the Honorable Anne McClellan, Senior Advisor for Bennett Jones, as an individual, and also Michael Spratt, criminal lawyer, and Mark Ware, Associate Professor, Department of Family Medicine, McGill University. From the Canadian Association for Pharmacy Distribution Management, Mr. David Johnson, President and Chief Executive Officer. From the Canadian Pharmacists Association, Dr. Shlita Dattani, Practice Development and Knowledge Transition. And my understanding is that the Honorable Anne McClellan and Mr. Ware are going to split your time. You have 10 minutes between you, and you can fight out how you want to divide it. But
Mr. Chair, we thought we had 10 minutes each.
It's okay too, because they're appearing as individuals, so they could do that as well if they want.
The clerk says it's okay. You can have 10 minutes each. See how easy we are?
Yeah.
We want to hear all we can, so we'll start with you.
Great. Thank you very much, Mr. Chair. Good morning, everyone. Let me say it is a great pleasure to be back in the parliamentary precinct. And I must say I am amazed at the transformation of Wellington. I must say, a very impressive building, which didn't exist in its current form, present form when I was here. As you've already heard, I'm Anne McClellan, and I served as chair of the task force on cannabis legalization and regulation. I'm here today with Vice Chair Mark Ware to share a brief overview of the work and the recommendations of the task force. Our mandate was to consult and provide independent advice on the design of a new legislative and regulatory framework. The outcome of this work is our report, a framework for the legalization and regulation of cannabis in Canada, which we provided to the Ministers of Justice, Public Safety and Health, as well as all Canadians on December 13th, 2016. Our report contains more than 80 recommendations. Our advice details safeguards we believe are important to achieve the objectives set out by the government to better protect the health and safety of Canadians by regulating access to cannabis. We spent 5 months traveling across the country and hearing from Canadians, including representatives of Indigenous communities, parents, youth, activists, growers, and patients who use cannabis for medical purposes. We spent time with experts and organizations who shared diverse perspectives and helped us to appreciate the complexities of legalization and regulation. We met with officials from provincial, territorial, municipal, and Indigenous governments who emphasized the need for close collaboration amongst all levels of government. We traveled to Colorado and Washington and spoke to officials in the government of Uruguay, the only other country to have legalized access to cannabis, to hear directly from those who have had first-hand experience enacting systems for legal access to cannabis. We also received close to 30,000 responses from experts, organizations, and Canadians who took time to respond to our online questionnaire. Through your committee hearings, you will, like us, hear a variety of thoughtful, informed, and passionate perspectives on myriad issues relating to legalizing and regulating cannabis. These perspectives will, in some cases, contradict one another. In considering the experience and expertise of those with whom we consulted, we sought to strike a balance between implementing appropriate restrictions in order to minimize the harms associated with cannabis use and providing adult access to a regulated supply of cannabis. Further, we wish to reduce the scope and scale of the illicit market and its social harms. We also concluded that it is appropriate to proceed with caution. We are only the second nation to move forward in this way, and we were told by those who have gone before to expect surprises. While there are important lessons to be learned from other jurisdictions, designing and implementing a national Canadian system is a unique undertaking. This balanced and cautious approach, with a focus on protecting public health and safety, helped dictate where the task force ultimately landed on some of the more controversial issues. I would like to highlight two issues that help illustrate our approach. It came as little surprise to the task force that setting a minimum age for the purchase of cannabis was the subject of much discussion during our consultations. The task force's deliberations on the issue reflected this, and we gave serious consideration to the various recommendations ranging from 18 to 25 years of age. We recognize the increased risks associated with use of cannabis at an early age. Research suggests that cannabis use during adolescence may be associated with negative effects on brain development. Yet, we also know that adults 18 to 24 are the segment of the population most likely to consume cannabis. Nearly 30% of that age cohort reported past year cannabis use in 2015. Setting the bar for legal access too high could result in a range of unintended consequences, such as leading young adults to continue to purchase cannabis on the illicit market, where, among other things, there are no quality controls. We heard that criminal prohibitions that exist today, and you discussed these earlier with public servants, criminal prohibitions that exist today and have existed for more than 90 years have had little success in preventing access to cannabis and dissuading its use. In 2016, 80% of cannabis-related offenses were for possession, which in turn led to 18,000 charges for cannabis possession. We also heard about the negative stigma of arrest and the potential lifelong consequences for those young adults who have criminal records for simple cannabis possession. In proposing a federal minimum age of 18 and respecting the interests of provinces and territories to set a higher age if they chose, we aim to balance the need to protect minors with the objective of reducing the illicit market. Based on our study, the task force also concluded that an age limit alone was insufficient to discourage and delay cannabis use. We recommended that robust preventative measures, such as sustained public education, along with smart regulation, would better control access and use by young adults and mitigate health risks. A second issue that garnered significant debate, with compelling arguments both for and against, was the issue of home cultivation. On the one hand, we heard concerns about the health and safety risks of home cultivation, the challenges of providing adequate oversight, in particular as it related to children, and the potential ease with which it could be diverted into the illicit market. However, it became clear to us that these concerns pertained most particularly, but not exclusively, to large-scale clandestine grow operations, not small-scale home cultivation. We also heard arguments in favor of allowing home cultivation, premised on the belief that it can be done safely and responsibly with appropriate limits and safeguards. Ultimately, the task force recommended allowing a limited home cultivation of no more than 4 plants per household, along with a prohibition on dangerous manufacturing processes, reasonable security measures, especially in relation to children, and oversight by local authorities. In our view, this recommendation accounted for the noted health and safety concerns and provided a framework for enabling small-scale cultivation for personal use by law-abiding adults, much like we currently see with the home brewing of alcohol. In no way should our recommendations on home cultivation be interpreted as condoning large-scale clandestine grow operations that we all have seen reported in the media and which cause significant risks to the health and safety of Canadians, including law enforcement and other first responders. On both these issues, age and home cultivation, we heard divergent and passionate views, as you will. Our recommendations reflect a belief that Canada, in embarking on this new path, must be both smart and pragmatic. We must also look to those who have already gone down the path of legalization, few though they are. It is encouraging to examine the experience of Colorado, one of the trailblazers in cannabis regulation. Colorado Governor John Hickenlooper and Attorney General Cynthia Kaufman recently wrote to U.S. Attorney General Jeff Sessions to provide a progress update that dispelled some of the misconceptions surrounding legalization. They noted that despite the fears of many, cannabis use among youth following legalization has seen no statistical significant increase, and I'm happy to report the same is true in the state of Washington when you look at their most recent stats. This was due in large part to strong regulatory provisions to help prevent use, such as age verification requirements and prohibitions on advertising, packaging, and products that appeal to children, and a robust public education campaign that highlights the consequences of use. Similarly, while initial data demonstrated a rise in cannabis-related emergency visits, the most recent data in Colorado shows a reversal in this trend. This reversal is again the result of targeted public education campaigns regarding the risk of use and the necessity for safe use and storage. For example, all edible cannabis product packaging in Colorado must be childproof and resealable. While there is no guarantee that Canada will experience similar outcomes, it is nonetheless encouraging to see that some of the concerns raised initially around cannabis legalization do not appear to be borne out by the most recent evidence in Colorado. Canada can learn from these experiences through sound policy, robust public education, and enforcement of the regulatory regime created. Many of the perceived risks of legalization can be mitigated. I have often said that it will be critical that the government remain vigilant and be prepared to course correct as evidence and experience indicate. There will be unforeseen challenges and unintended consequences. Only through careful and close monitoring and a willingness to be flexible and adaptable will it be possible to respond effectively to issues as they emerge. Thank you, Mr. Chair. I look forward to questions and comments.
Thank you very much.
Dr. Ware.
I'm sure you're going to get some good ones. Dr. Ware, yes.
Good morning, everyone. My name is Dr. Mark Ware, and I served as Vice Chair of the Task Force on Cannabis Legalization and Regulation. C'est un plaisir d'être en mesure de m'adresser aujourd'hui à ce comité dans l'espoir.
It's a pleasure to be able to address this committee today so that I can provide you with a few suggestions concerning the time when I was co-chair of the working group, in addition to my professional experience.
Can come from providing a researcher's perspective on the state of evidence surrounding cannabis, including its potential harms and benefits, outlining some of the challenges that the evidence may present to you as you explore some of the issues, sharing some of the considerations and conclusions from the task force's examination of how access to cannabis for medical purposes might be impacted following legalization, and finally highlighting the importance of research in supporting sound public policy. À titre de médecin clinicien, se concentrant particulièrement.
As a doctor focusing on pain management, I have been studying marijuana for medical purposes for a long time. I have been able to see myself the change of paradigm in Canadian culture that has brought us to the the point where we seek to establish a legal framework for marijuana. This is a truly remarkable change, but it is important to remember that this was a long process that started in 1996 with the legalization of hemp, and it goes to the regulatory framework on medical marijuana.
The task force has had with experts across Canada, it has become evident that there are a wide variety of thoughtful, often diverging, and at times very colorful perspectives surrounding cannabis. I have learned that no one has a monopoly on the truth about cannabis. This is a theme that Ms. McClellan noted, and it is something that I think is worth reiterating. As you venture through this week of hearings, you will hear many perspectives. Ideally, all of our clinical decisions, as well as policy recommendations, would be based on clear, well-documented evidence. However, the task force recognized that through our many conversations and readings, that cannabis policy lacks comprehensive, high-quality research in many areas. On many issues, there is little doubt that the evidence is often non-existent, incomplete, or inconclusive. This is why we framed our recommendations as evidence-informed rather than evidence-based. This is particularly evident when examining the harms of cannabis use. You will hear reference to studies that demonstrate associations between frequent cannabis use and mental illnesses such as psychosis, other studies that speak to the short-term effects on memory, attention, and psychomotor function. Yet there is also agreement that many individuals suffer from a variety of serious medical conditions that may derive therapeutic benefit from cannabis, especially in relation to pain management. In the course of the next few days, you will hear a great deal about associations between cannabis and a number of health-related outcomes. You will probably have already your own prior perceptions about some of these issues. You will no doubt rapidly become aware that for many of these associations, there is uncertainty, even among the scientific community, that there is debate around the strength and the directions of these associations. One aspect that I have been particularly struck by in considering the evidence on cannabis use is the lack of consistency on quantifying use. We talk of frequency of use, daily, weekly, monthly, but rarely of the potency of the cannabis itself. THC content varies enormously in cannabis preparations and yet is rarely considered in epidemiological and research studies. And yet is hugely important in terms of understanding the effects on the brain and other behaviors. This is where legalization and regulation is likely to have an important impact. We will be able to accurately quantify cannabis use, knowing what people actually use and allowing us to learn the language of cannabis potency, concentrations in terms of THC or CBD, percentages or milligrams per dose. This will allow for more informed research and, as a result, a more informed public. Cette tension entre les risques et les avantages potentiels est un
This divide between the potential risks and advantages is something that the committee should take into account when it evaluates a variety of topics while you examine all of the various points of view that you will be made aware of. You will discover that there is no one solution to clarify all of these points of view. The reality is that currently the research will not lead you to a consensus, and it is important to understand this and accept it.
Medical purposes is a notable example of divergent views. On the one hand, there are those, notably patient groups, with a view that a separate system for medical cannabis is necessary to preserve their relationships with healthcare practitioners and their access to specialized medical cannabis products. They stressed that they use cannabis out of necessity, not choice, and that they feared that their needs and access rights would not be accommodated under a single system. On the other hand, we heard primarily from representatives of the medical community that there was no need for a dedicated medical cannabis system, as the end of prohibition will mean that those who need access to cannabis for medical purposes will be able to do so through the general cannabis market. Given the lack of evidence and concerns about being responsible for authorizing the use of a substance that is not an approved medicine, they did not want to play the role of gatekeeper moving forward. Others pointed to the challenges of administrative and enforcing a dual system. Ultimately, weighing the different perspectives and using the principles of caution and balance, the task force determined that the most reasonable course of action was to preserve the medical system in its current form and reevaluate its need in 5 years once the legal system has had a chance to become established. The lack of consensus in different areas highlights the need for more research and ensure systematic monitoring, evaluation and reporting, not only to better understand and mitigate risks associated with problematic use, but also to understand the potential benefits of use. The task force heard compelling accounts from patients who told us of the benefits they experience from cannabis use, and from researchers and the medical community who call for more evidence to better understand its therapeutic potential. Both physician and patient interests would be served by advancing science and clinical research on the therapeutic uses of cannabis and associated cannabinoids. There is tremendous strength across Canada in terms of research capacity, from plant sciences to psychiatry, from neuroscience to nursing, from clinical trials to community practice. The Canadian discussion about cannabis legalization has already fostered communities of researchers to discuss the research and education agenda needed to support and inform the changing policy. There is an opportunity for Canada to take a leading role internationally in addressing questions that are of global importance. Le Canada s'engage sur une
Canada is moving down a new path, a path that will offer opportunities to conduct additional research to better understand the disadvantages and advantages of cannabis. While the number of scientific evidence is the amount of scientific evidence is increasing and is better understood, we can implement these lessons learned within our programs and policies to better protect the health and safety of Canadians. I feel that this is a unique opportunity and an exciting one for Canada to become a world leader in this field.
Course into account. We provided our report to the ministers, and I provide my comments to you today with the conviction that Canada is well positioned to undertake this work carefully and safely. Thank you.
Thank you very much for your comments. It outlines our challenge quite nicely. Mr. Spratt, 10 minutes.
Thank you. It's an honor and a privilege to have been invited to make submissions before this committee. My name is Michael Spratt. I'm a criminal defense lawyer. I'll leave that in terms of an introduction of myself. I have a more verbose introduction in my written submissions, which should be translated and distributed to you all shortly. On February 21st, 2010, while a young man named Michael Swan was watching Canada's gold medal hockey team play the United States, 3 young men from Toronto were driving down a dark highway towards Ottawa. The Toronto Three, as they would come to be known, had a plan to make some easy money. They were going to steal Mr. Swan's marijuana. Swan was murdered later that night, killed by a single bullet that pierced his lung and tore apart his heart. There was nothing particularly unique about Mr. Swan. He was a typical teenager. He came from a good family. He had a tight circle of friends. And like almost half of Canadians have done, he smoked marijuana. He also sold it, mostly to his friends, but rumors of his large pot supply had reached Toronto. I represented one of the Toronto Three. Like Swan, he was 19 years old. He had no prior criminal record. Now, he didn't shoot Swan, but he was there when Swan was shot, and he was convicted of second-degree murder, and now he's serving a life sentence. Some cases stick with you. That's an occupational hazard of being a criminal defense lawyer. Often we remember cases because of the result, the unexpected victory or the wrongful conviction. I remember the Swan case because it was tragic. A young man was killed, 3 young men were sentenced to life in jail, and a family was destroyed. Sadly, this kind of tragic story is not an isolated incident. The simple fact is the criminalization of marijuana kills. But that's not all it does. The criminalization of marijuana is a drain on court resources. It diverts law enforcement resources away from truly harmful activities. The prosecution of marijuana offenses unduly stigmatizes otherwise law-abiding citizens through the imposition of criminal records. The criminalization of marijuana disproportionately impacts individuals who are young, marginalized, members of over-policed communities, or racialized. In our drug laws, there are indeed echoes of racism and bias. The government should be commended for taking a tentative first step towards a rational and effective drug policy. And there is promise in Bill C-45, but there are also some serious flaws and rooms for improvement. Bill C-45 contains no measures, for example, to address the tens of thousands of Canadians who have been stigmatized through the war on drugs' counterproductive imposition of criminal records. Now, the Criminal Records Act was first introduced in 1970 to augment the discretionary royal prerogative of mercy. The Act detailed the manner in which persons convicted of criminal offences could apply for forgiveness for past wrongdoings. With the enactment of the Canadian Human Rights Act in 1985, offences for which people was pardoned could no longer be used as a discriminating factor by employers, and similar human rights legislation has been enacted provincially. It is in the public interest to have a robust system of pardons. It is in the interest of society to reintegrate people back into society after they have committed a criminal offense. The logic is that even a partial removal of stigma of the conviction will aid in reintegration. It is well documented that the continued stigmatization of an offender is ineffective in reducing recidivism and reoffending. Those who have criminal records are less likely to be able to obtain employment, housing, less likely to be able to cross international borders, and less able to fully engage in educational opportunities. Bill C-45 does not offer any measure whatsoever, such as an automatic, expedited, or subsidized pardon to individuals who are convicted of activities that will now be legal under Bill C-45. Nor does Bill C-45 take the opportunity to amend the currently unconstitutional sections of the Criminal Records Act that retroactively increased pardon ineligibility periods. These retroactive amendments were found to be unconstitutional and in violation of the Canadian Charter of Rights and Freedoms by courts in Ontario and British Columbia. And I was counsel in the case in Ontario. And both courts declared those amendments, the retroactive increase in pardon eligibility periods, to be of no force and effect. However, that unconstitutional pardon provision remains in force throughout most of Canada. So if you don't live in Ontario and you don't live in BC, you're subject to an unconstitutional law. Bill C-45 should amend the Criminal Records Act to remove the unconstitutional retrospective application of the pardon ineligibility period. It should restore pre-amendment waiting periods, and a further reduction in waiting periods should be available for individuals convicted of marijuana offenses that will now be legal under Bill C-45. So currently, an 18-year-old first-time offender who is convicted of simple possession of marijuana the day before Bill C-45 comes into force will be required to wait 5 years before they're even eligible to apply for a pardon. Bill C-45 must remedy this situation. Bill C-45 is also an unnecessary, complex piece of legislation that leaves intact the criminalization of marijuana in too many circumstances. An adult who possesses 30 grams of marijuana in public is a criminal. A youth who possesses more than 5 grams of marijuana is a criminal. An 18-year-old who passes a joint to their 17-year-old friend is a criminal. An adult who grows 5 marijuana plants is a criminal. An adult who lets his 1-meter-tall marijuana plant grow an extra centimeter is a criminal. This continued criminalization is inconsistent with a rational and evidence-based criminal justice policy and will only serve to reduce some of the positive impacts of this bill. The disproportionate effect of continued youth criminalization is an anathema to criminal justice policy. Nowhere else in the criminal code is a youth criminalized for an act that would be legal if committed by an adult. A century of failed drug policy has demonstrated that criminalization is a flawed and ineffective mechanism to discourage drug possession. Simply put, there's no reason to believe that making it a criminal offense for a youth to possess 5 grams of marijuana will deter youth from possessing marijuana any more so than the current criminalization does. The distinction between illicit and illegal marijuana and the asymmetrical criminalization of marijuana will only serve to perpetuate the disproportionate enforcement of laws on the young, the marginalized, and racialized members of our society. Even under the new law, marijuana will still be criminal in many circumstances. Only now, the government's vice squad will need to carry rulers and will need to learn to divine the difference between identical legal and illicit forms of marijuana. Bill C-45 also creates a statutory mechanism for police officers to exercise their discretion to issue tickets in the place of criminal charges for certain offenses. Now, this is well-meaning, but it's problematic given what we know about the exercise of police discretion. Remember, police discretion now currently operates disproportionately against a variety of marginalized groups. The ticketing option relies on discretionary police action. The choice of whether to lay a criminal charge is also discretionary, and the results have been manifest in much of the discriminatory impacts of the current law. There's no reason to believe that's going to change under this ticketing option. The discriminatory impacts of police discretion should be eliminated through full legalization and strict regulation. Now, to its credit, Bill C-45 does attempt to reduce the prejudicial impacts of this ticketing option. And there's provisions designed to prevent the public disclosure of judicial records. But that is dependent on the offender's ability to pay a fine. If a ticket remains unpaid 30 days after a conviction is registered, there is no corresponding right to privacy in a judicial record. I think the problem's obvious. In other words, if you are poor and can't pay a fine, you are further stigmatized through a public record. If you are well off and can pay the fine, your record is sealed. That judicial record is non-disclosable. Given the research on the impacts of the disclosure of judicial records, the inability of the poor to purchase privacy rights, and the disproportionate enforcement of marijuana that's experienced by marginalized groups, it's quite likely that this ticketing provision in Bill C-45 will be found to violate the Canadian Charter of Rights and Freedoms. Canadian drug policy and legislation is in need of reform. The war on drugs has been a complete and abject failure. The social and financial cost of criminalization outweighs any illusory benefit. Every year, scores of young men and women are killed over relatively small amounts of marijuana. Killed because marijuana is illegal. Bill C-45 may limit, but it does not end this problem. Continued criminalization imposes unreasonable penalties on a relatively low-risk activity. In the real world, a drug record means limited employment, opportunities to travel, and other devastating collateral consequences. Only full legalization, decriminalization, and regulation of marijuana will truly protect society and remove the unfairness, racism, and over-intrusion by the state into an activity that, in the context of existing criminal law, is relatively harmless. Be happy to answer any questions this committee has.
Well, thank you very much. We appreciate your perspective, and it certainly leads us down some other roads. So if we could now go to the Canadian Association for Pharmacy Distribution Management, Mr. David Johnson, President and Chief Executive Officer.
Thank you very much. My name is David Johnson. I am President and CEO of CAPDM, which is the Canadian Association for Pharmacy Distribution Management. CAPDM represents Canada's pharmacy supply chain and counts with its members the pharmaceutical distributors, self-distributing pharmacy chains, prescription and non-prescription drug manufacturers. CAPDM was founded in 1964, and several of our distributor members have safely and comprehensively been distributing pharmaceutical products in Canada for over 100 years. I'd like to start with a statement, and the statement is distribution is not retail. Effective coordinated wholesale distribution will be an essential element to the successful and safe legalization of cannabis. I'm also going to suggest that distribution has not yet been appropriately addressed by the federal or provincial governments in their current planning activities. Now, let me start by providing some background information on the pharmaceutical industry. Greater than 95% of pharmaceutical products pass through a pharmaceutical distributor. It is a system of choice of government and industry in Canada for the distribution of pharmaceuticals. As a result, products ranging from over-the-counter headache medications to the most potent controlled substances are delivered to over 9,000 community pharmacies and 900 hospitals every day. An order placed one day is on the shelf the next day, regardless of the pharmacy's location. From a distribution point of view, the cost is the same regardless of destination. Consequently, in Canada, there is no disadvantage, no difference from a distribution point of view if you access your medicines from a small pharmacy in a rural town or a large chain in a downtown urban environment. This safe, secure, and efficient system is a global gold standard, and compares very favorably to other countries and jurisdictions. Pharmaceutical distributors are also a buffer against drug shortages, helping to smooth out supply and demand between pharmacies and manufacturers by holding several weeks of inventory in their facilities and working with manufacturers and governments to closely manage supply during times of constrained product. The industry is highly regulated through Health Canada with multiple licenses, and our members are subject to strict auditing and reporting requirements. And for our last point in this overview, pharmaceutical distributors support a two-way system. Not only do they distribute, but they also track the products and have protocols in place that will allow recalled products to be back out of the market and back into the distributor within 36 hours. Now back to that opening statement of distribution is not retail. Distribution is the movement of product between the producer and the access point. Between, in this case, the licensed producer and whatever that public access point will be within the various provinces. Effective distribution is essential to the successful legalization of cannabis. Discussions to date have been focused on production and where legalized cannabis will be sold. In fact, in the 52 times the word distribute and distributing appear in Bill C-45, with little exception, they refer to selling and retailing, not the specific activities of distribution. The word distributor does not appear in Bill C-45. With this background, I would suggest that distribution needs to be an active discussion point, and the pharmaceutical distributors are the natural partners for the distribution of both medical and recreational cannabis. By leveraging this proven and highly successful system, regardless of the final retail point, whether it be a government-controlled retail outlet or a licensed private retailer, Canada will avoid the pending hazards that are looming by not addressing distribution that have been dramatically and negatively experienced in other jurisdictions. For example, just recently, in Nevada's legalization experience, retailers ran out of inventory in the first 2 weeks after launch because a buffer was not provided by a wholesale distribution system. With less than 10 months till cannabis legalization, this is a crucial moment for the federal, provincial, and territory governments as they wrestle with many complex issues. The provinces are deeply concerned by the short and some may say unrealistic time they face in preparing for legalized cannabis. From experience, we understand what the provinces face. There are daunting complexities and enormous investments associated with establishing a new regime that incorporates best practices for a highly regulated, secure, and cost-competitive supply chain, mandated to safeguard public health and safety that by its competitiveness will reduce the prevalence of black market cannabis. The final report from the Federal Task Force stated, a well-functioning distribution system where the chain of custody is well controlled is critical to the overall success of the new regime, and we couldn't agree more. Today, the direction is to have the responsibility of cannabis distribution in the hands of the provinces and the territories. With the regulatory demands we experience every day in our Canadian pharmaceutical supply chain, we cannot imagine a functional and cost-competitive cannabis distribution environment that is built upon a patchwork of varying provincial models and regulations trying to incorporate the federal mandate for tracking, reporting, and recall measures. Our questions are, why reinvent a system in each province and territory when a proven one already exists? A proven system that is well established and will require minimum government investment. A proven system that already fulfills all of the requirements defined by the federal government and has an existing oversight and audit system. A proven system that is cost effective, therefore allowing legal market to outcompete the black market on price. The adoption of a ready-made cannabis distribution model will deliver a turnkey solution that is ready to go and that relieves significant system stress as the pharmaceutical wholesalers already have secure infrastructure and processes in place for the safeguarding cannabis from diversion. An efficient, low-cost distribution services, therefore keeping cost structures competitive to thwart black market cannabis. A channel-agnostic distribution model that will service a wide range of retailers, whether it be government-controlled retail outlets or other channels. A model that is already vigorously regulated via national standards and inspected regularly by Health Canada. Provisions for shipment data on a timely basis, providing government full transparency of product movement. and next-day delivery capacities means that retailers can maintain low inventories, thereby minimizing losses from theft and diversion. As well, a quick and efficient execution of product recalls. So CAPDM and its members recommend, first, that distribution be recognized as essential to the success of legalized cannabis, and that effective distribution become a key deliberation point for both federal and provincial governments. Two, that a national perspective for cannabis distribution be established to avoid an inefficient and potentially dangerous conflicting patchwork of distribution systems. And three, that the safe, secure, efficient, cost-effective, and comprehensive distribution network of the pharmaceutical distribution industry be evaluated as a turnkey option for a national system. Finally, to return to my opening line about distribution is not retail. For the legalization of cannabis to be successful, strong production, distribution, and retail models are all essential. There are thousands of decisions to be made in the legalization of cannabis. For the essential element of distribution, the pharmaceutical distributors have a turnkey and proven solution to the safe, secure, comprehensive, and cost-efficient distribution of cannabis. Thank you very much, and I would be happy to answer any questions.
Thank you very much. Now we'll go to the Canadian Pharmacists Association, Dr. Shalita Tantani.
Good morning, everyone, and I thank you for the opportunity to be here today. My name is Shalita Tantani. I'm a practicing pharmacist, and I'm the Director of Practice Development and Knowledge Translation at the Canadian Pharmacists Association. I'm here today on behalf of Canada's 42,000 pharmacists who are medication experts and whose job it is to ensure drug therapy is safe and appropriate for our patients. Every day, pharmacists act as medication stewards on behalf of Canadians. We make sure that each patient's medication and dosage is the right one for them. We check for and resolve potential drug-related problems, and we work with patients to ensure that they understand their drug therapy. We also address side effects, interactions, and we monitor our patients' progress throughout their therapy. We've seen more and more patients using medical cannabis over the last decade or so, and pharmacists have become increasingly concerned about the health and safety of these patients, especially those who are using cannabis in combination with or instead of other traditional medications, often without the oversight of a pharmacist. And our concern for patients in the medical cannabis stream further increases as we move towards legalization of recreational cannabis. We recognize that Bill C-45 focuses mostly on legalizing cannabis for recreational purposes, but it's important that the government understand how the proposed legislation could impact patients relying on medical cannabis as part of their treatment plan for pain, epilepsy, MS, and other conditions. We want to focus our concern around three areas: the separation of medical and recreational cannabis, the role of pharmacists in medical cannabis, and the use of medical terms like dispensary in recreational sales. As of March 2017, Health Canada reported over 201,000 patients registered to obtain medical cannabis through licensed producers or personal production. These patients have unique needs that differ from recreational cannabis users. Medical users might need strains and forms to alleviate symptoms and minimize intoxication, like those available through cannabidiol or CBD, whereas recreational users might be seeking euphoric effects in strains with higher THC levels. Medical cannabis users also require the clinical oversight that comes with any medication therapy. Other jurisdictions have moved to legalization of cannabis, such as Colorado and Washington State. They have maintained different streams by restricting product strains and forms, establishing distinct access channels for medical cannabis, and treating the medical stream as unique. We're pleased that the Canadian government has signaled its intent to follow these best practices by maintaining two distinct streams once recreational cannabis is legalized in 2018. But we're concerned that current shortcomings in the medical regime could be exacerbated with the move to legalize cannabis if there aren't policies and practices in place to clearly differentiate between medical and recreational streams. One clear example of this is around costs. If the cost of recreational cannabis is more attractive than medical cannabis, or if access is less restrictive, patients may choose to go that route, and they'll be left without medical oversight, which could increase health complications for high-risk patients. The safety of our patients is paramount, and we need to ensure that medical cannabis users are supported and protected through a medical stream once recreational cannabis is legal. Another consideration is the securing of medical cannabis strains from the recreational market to ensure enough supply of unique medical strains to meet patient needs. Medical cannabis users are often vulnerable patients who may have tried multiple other therapies before turning to cannabis or found only one unique strain of cannabis that provides them with relief. The medical cannabis stream must be protected from the recreational market in order to safeguard against shortages of these particular strains for those patients that use medical cannabis, as other colleagues have said, out of necessity versus choice. Finally, there are the more systemic benefits of maintaining a separate medical stream. Separation of the medical cannabis stream would facilitate more clinical research and understanding of this complex drug. And so it would create a more robust evidence base around the therapeutic benefits and risks for healthcare providers to inform them in the management of patient care and in the further development of guidelines. In order to reduce harm, particularly for those who use cannabis for medical purposes, government must take steps to clearly differentiate the two markets before July 2018. A logical first step would be to ensure pharmacists' clinical oversight and dispensing of medical cannabis in Canada. Across Canada, pharmacists, just like myself, are regularly asked by our patients about the use of cannabis for a variety of different conditions. But as the medication experts on a patient's healthcare team, we don't currently have a role in dispensing medical cannabis. Health Canada attests to the complexity of cannabis and its potential interactions with other, more traditional medications. Given these risks, we believe it's essential that patients have as much support as possible from qualified healthcare providers to strengthen patient safety and health system accountability. As the system works now, patients consult with their physician who may issue a document for medical cannabis. Supply is then managed through mail-order distributors or patient-grown cannabis. None of these options include consultations with medication experts at the point of dispensing to ensure that patients understand why they have been prescribed the medication, to discuss the best route and dose of administration for the patient, and to discuss potential side effects. Also, as I've said before, for many patients, medical cannabis is a third or fourth line treatment, and these patients are often on a number of other medications. For example, veterans using cannabis to control post-traumatic stress disorder symptoms or patients with mental health conditions are also likely to be on a number of other medications, including psychoactive, anti-anxiety, and hypnotic medications. The potential for drug interactions in these patients is considerable, and the need for pharmacist oversight becomes even more important. With over 10,000 community pharmacies in rural, urban, and remote locations across this country, pharmacists are patient-centered practitioners who are well-positioned to dispense medical cannabis and provide the required clinical oversight. Canadians think of us and their relationships with their local pharmacist when they consider where they will get their medication and who will counsel them and guide them on their medication therapy. Pharmacists work with controlled substances every day, and they have the framework and the ability to ensure the safety, security, and tracking of the products that we dispense every day. We regularly use our clinical expertise to detect possible drug therapy problems, and we're able to mitigate the potential risks associated with medical cannabis, including contraindications in patients with a psychotic illness, for example, or in pregnant patients. Further, we're often able to identify potential addictive behavior which could lead to misuse or abuse. We should learn from our experience with opioids and the significant potential for addiction to psychoactive medications. And we shouldn't make the same mistake by underestimating the need for clinical oversight with medical cannabis and all of its unique complexities. While CPHA doesn't endorse any specific production or supply system for recreational cannabis other than a regulated process with health promotion as a priority, we believe that for medical cannabis, it's essential that patients have as much support from qualified healthcare providers as possible. Patient safety should be the primary consideration. For this reason, we urge policymakers to include and to support pharmacists in dispensing medical cannabis and ensuring safe and effective use by patients in the medical cannabis stream. Finally, in line with our call for separate streams for medical and recreational cannabis and the need for pharmacist oversight in the medical stream, our position is that recreational suppliers and retailers of cannabis be prohibited from using pharmacy-related terms such as dispensary or symbols such as a green cross. Since the government announced its intention to legalize cannabis, we have seen a proliferation of so-called dispensaries across the country that claim to sell medical cannabis. As medical cannabis is legal in Canada under certain conditions, many Canadians are unaware that these are, in fact, illegal operations. The use of the term dispensary along with pharmacy symbols further compounds this misconception. We would urge the government to restrict the use of dispensary and pharmacy terms and symbols for non-medical cannabis retail sites. These promote the notion that recreational cannabis has health benefits or is a medication, that the retail site is a pharmacy, or that the site has professional oversight from pharmacists. This regulation is particularly important to ensure public safety and to further distinguish between the recreational and medical cannabis streams. Thank you again for the opportunity to represent Canadian pharmacists today. Pharmacists are committed to ensuring that our patients have access to appropriate medication therapy and that their therapy is both safe and effective. As we move forward with the legalization of recreational cannabis, we're asking the committee to endorse the clear differentiation between the recreational and the medical cannabis streams, to recommend restrictions on the use of pharmacy-related symbols in the recreational stream, and to help strengthen clinical oversight of the medical stream by supporting pharmacists in dispensing and managing medical cannabis in the care of their patients. Thank you. I'd be pleased to take your questions.
And thank you very much. Now we'll start our 7-minute round of questions. And I'm going to do the same thing as last time. If the witnesses are answering the questions and we go beyond time, I'm going to allow them to complete the answer. But I'd ask that members don't interject and add extra questions after the time period is over. So we're going to start questioning with Ms. Sidhu.
Thank you, Chair. Thank you, all the panelists. For clarification, Mr. Spratt, you said that people unable to pay tickets are criminalized. In fact, Clause 55 states that ability to pay is a clear consideration in ticketable offenses. If you cannot pay, you won't be further punished. I just wanted to begin by the clarification.
Jailed, but the Act's quite clear that the judicial record won't have the same privacy protections as someone who can pay. So the punishment that I speak of isn't incarceration, but it's the devastating impacts that are well documented of disclosure of judicial records. That's how they're punished.
And, thank you. We know that the aim of the legislation, in large part, to keep cannabis out of the hand of young Canadians. The federal law has some mandatory measures in place, but also doesn't go into the provincial, territorial, or municipal jurisdiction. How is this legislation similar to existing law on alcohol and tobacco use? This question's to Mr. McClellan, if you answer that.
Sorry, pardon me?
We know this legislation, in large part, of the keep cannabis out of hands of young Canadians. The
Yes.
federal law has some mandatory measures in place, but also doesn't go into provincial, territorial, and municipal jurisdiction. How is this legislation similar to existing law on alcohol and tobacco use?
Well, the legislation obviously has similarities to tobacco regulation in that, and keep in mind, my colleague Mark Ware and I are here to talk about the task force report and explain why we made the recommendations we did. Then government chose in C45 and C46 to accept some, but not all, of our recommendations. But as it relates to, for example, tobacco regulation, we looked at tobacco regulatory provisions, especially around marketing, advertising, branding, and sponsorship, and felt that the approach that's been taken there is a reasonably good one in terms of the promotion of public health, and especially as it relates to young people, but not exclusively young people. Therefore, what you see, as I understand it, reflected in the legislation, is a desire not to be in the business of permitting promotion promotion or lifestyle advertising in relation to cannabis when it's legalized. And in that respect, it's quite similar to the tobacco regulatory regime that you see presently at the federal level. In relation to alcohol, I think it's fair to say that a lot of the regulatory regime that you see around alcohol, whether it is in relation to public education or prevention outside the driving milieu, is largely within provincial jurisdiction.
Why did the task force feel that a seed-to-sale tracking system was required?
Well, because you want to prevent diversion out of your legal regime, your regulated regime, into the illicit market. And the best way to do there are many aspects of preventing diversion from the regulated market to the illicit. But one of the best ways to do it is through tracking seed to sale. And this is something that Canadians are familiar with. They're familiar with the language of gate to plate, for example, in relation to much of the food that we consume. And seed to sale is something that we saw in place in states like Washington and Colorado to prevent diversion into the illicit market. And we saw it at work in licensed producers, which we visited as a task force. And you can trace that seed from the seed through growth to whatever form it ultimately appears in the retail market. And it's not only a health promotion and safety mechanism in terms of understanding where that product came from and the quality controls in that particular producer or manufacturer, but it also then helps law enforcement in terms of if that barcode is not there, that will tell you, it should tell you in a regulated system that you're dealing with illicit product. Or it will tell you if you find that product with a barcode being trafficked that in fact it has been diverted.
Thank you. Task Force has also recommended that the staff be well trained and knowledgeable. What kind of training should be given in relation to sale of cannabis? What elements important in you think in that type of training?
Well, I think there might be others here who might offer views because it depends how you approach the training. We've heard, for example, from our friend from the Pharmacists Association that in fact they would argue very strenuously for training in terms of the medicinal stream, and obviously they're trained as professional pharmacists who can offer all the kinds of advice, adverse effects counseling, and all those kinds of things that one would expect. But I think in terms of retail behind the counter, what we recommend is that yes, there be training for those people behind the counter, as there is supposed to be in the sale of alcohol across our country. I think the exact nature of that training is something that the provinces will decide in conversations with the provinces. They have indicated that I would say it's fair to say some of them probably, maybe all of them, struggling with the exact nature of what that training should look like. And that was not something we at the task force level got into that degree of granularity. But what we saw looking at other places that have legalized and in discussions with many and our overarching objectives around public health and public safety, you do need people behind your counter at retail who are trained.
Thank you.
Dr. Carey.
And my first question is for Ms. McClellan. The task force recommended that the production of cannabis and its derivatives, including edibles, be regulated at the federal level. As a former minister, you're aware that regs don't require parliamentary oversight other than for the Tobacco Act. Do you believe that regulations should have parliamentary oversight in regards to the production of cannabis and its derivatives, yes or no?
Parliamentary oversight. Well, it would seem to me that probably at the end of the day, you as parliamentarians in this committee can choose to bring before you anyone and any minister, based on my experience, and demand answers and call for oversight. But I think it's, if your question is more in line with whether or not edibles should be addressed in a federal legislation. Absolutely. Should edibles be provided to the market? Absolutely. The task force was very clear in relation to that.
Yeah, no, that wasn't my question.
No,
my question
I know.
was your opinion.
Yeah, well,
no, you've been a minister, and you know that regs don't need parliamentary oversight except for tobacco, and now we have this product, cannabis, that you've been on the task force. Should it have parliamentary oversight, its derivatives and cannabis itself?
I have not thought, which is quite obvious, a lot about that. But as I say, I am generally one of those who believes that you're elected to do a certain job, and oversight by elected officials is important.
Okay. I guess that's yes, right?
You heard what I said.
I sure did. All right. My next question for Mr. Spratt. I've understood some of the things that you've parlayed about the task force, and I was wondering, Ms. McClellan did say the task force, what she wanted to do is provide independent advice. Do you think the task force advice was independent?
I'm not in a position to comment on whether it was independent or not. It seems the mandate was. The recommendations, the task force recommendations aren't reproduced line by line in this legislation. So the difference between the recommendations, edibles being one, and this legislation might speak to how independent or not the task force was.
Yeah. Did you have any challenges with Ms. McClellan's association with Bennett Jones at all?
I think that that is something that needs to be considered when looking at this issue. What we've come off of is a century of criminalization, prohibition, and incarceration of individuals who were involved with marijuana. What we're seeing now is large corporations and other entities trying to get some skin in that game legally. The composition of people who are involved with those large organizations may lead to some concern about the fairness of that.
Okay, so is there, with this legislation, the way it's written, does it favor certain, like for example, there's large companies out there now in the medicinal marijuana field. Does it favor those big organizations versus maybe new entrants? As you said, your term was new skin in the game.
It very well might. And I mean, one of the things that I've talked about is people who have been affected by criminal records for what will now be a legal activity. And that's one of the considerations that can be given to rejecting applications by those individuals. And of course, your question also touches on some provincial jurisdictions and touches on some business considerations that are well out of my expertise.
Well, it just interested in your opinion on independence and basically who benefits from this this new legislation, if there is obvious challenges out there with the legislation.
What I can say is that the young, marginalized, racialized individuals who I have represented and I have seen in court who have been criminalized because of past legislation or current legislation with respect to marijuana, there is not much benefit for them in this legislation to either redress their situation, improve their situation, and I think that that is something that the committee should look at very closely.
Okay, Dr. Wire, I have a question for you. I'm going to challenge one of your comments saying that you know, it lacks high quality research, and I can see that in some ways, but we've been getting briefs, for example, from the Canadian Medical Association saying that the research is very clear for people under the age 25. There are clear associations with psychological problems and damage due to cannabis use. The Canadian Pediatric Society says the association also is very, very clear. Could you clarify what you mean lack of high quality research? I know the science isn't there for a lot of this, but as far as damage, would you agree that the evidence is very clear that people under the age of 25, there's clear evidence that it can cause psychological problems and sometimes permanent impairment?
So I think this raises the challenge of trying to interpret any evidence of risk. And I think you need to be careful when you make assumptions that the evidence is clear that there are risks. It's not just whether or not there's a risk, it's the magnitude of the risk, and it is the factors that contribute to that risk. So in the case of mental health, what became clear to us from a number of positions, the CMA, the pediatric societies being one, but the psychiatric associations, there are other public health, there were other perspectives that were taken into account, that the association between cannabis use and mental health issues on a wide range of scales is attenuated by a number of other things, not just the cannabis itself. And I've already talked about potency issues, which are not factored into many of these discussions. But the age of onset, the frequency of use, the modality of consumption, and then the socioeconomic factors that are surrounding the individual who is using cannabis at an early age, those all contribute to elements of the risk equation. And different studies factor these confounding elements in different ways. And so even when you speak to the experts, the medical associations and the pediatric associations are looking at a broad evidence base and summarizing, and the danger is summarizing into one line, a very complex body of evidence, but they're summarizing things and making position statements based on a review of evidence. When you speak to the people who actually do those studies themselves, you very quickly realize that they are themselves limited by the interpretation of some of those findings because of the differences in methodology, the difference in reporting, who uses, who reports use, how do they report the amount of use. So with all of that said, that's what I mean by the lack of high-quality evidence and why it's so important that we get a better handle on what people are using, how much they use, when they use, and that we build our education programs to minimize those risks, not just of the drug itself, but of the socioeconomics and the social determinants of the people. Why are they choosing to use cannabis when they're 13 years old? That is something that we need to be looking at.
But is it safe to? Oh. Okay. Mr. Davies.
Thank you to the witness for being here. Ms. McClellan, if I may start with you. The task force recommended that edibles and concentrates be legalized and regulated. Can you please tell the committee why the task force made that recommendation?
Because they are products that are readily available. When we discussed legalization in states like Colorado and Washington, and as someone earlier mentioned, it's a growth area in the cannabis marketplace. And obviously, if you're concerned about public health, you want to move people away from smoking product into enjoying their cannabis, or if it's for medicinal purposes, their therapies in non-smoking forms. The edible market is one, as we've mentioned, and we mentioned in the task force report, is growing. It is varied. And also, we know there's a demand. And if you want to move from the illicit market into a regulated legal market, then you have to offer the quality and choice that the illicit market can provide. And we heard that, I think it's fair to say, Mark, over and over again from a wide variety of people we talked to, that there are public health reasons and public safety reasons why you would want to authorize or allow edibles in various forms, and the forms in which they come are only limited by one's imagination, we have discovered. Now, I do think it's fair to say that we heard a note of caution. Coming out of Colorado and Washington, what was their single biggest surprise out of the box? It was how much demand there was for edibles. So one of the things they told us was, you've got to be ready for that. You need edibles in your regulated market, but make sure you're ready. Make sure that you don't make the same mistakes we did, which was have somebody eat a whole chocolate bar, because when you're eating an edible, it takes longer if you're looking for the high. So 30 minutes in, some guy has, I'm not looking at you, Michael. Some guy has consumed 2 squares of chocolate and is saying, oh, I don't feel anything, eats the whole bar. So Colorado had to go back in and fix all that, and their private sector weren't very happy about the additional cost. So you do want to be cautious. You want to make sure that you get the edibles piece right, because it is possible to make those kinds of bad judgments or mistakes. In terms of consumption, you need to make sure your labeling is accurate, that your warning labels are there, and all of that. So I would say you need to be cautious around edibles out of the box, learn from what we've seen in other jurisdictions, but absolutely they have to be part of the consumer choice going forward in a regulated market.
Right. And I think, as you pointed out, I think it's been mentioned time and time again that one of the prime focuses of this bill is to take production of cannabis away from the illicit market, the black market, the organized criminally controlled market, and move it into the regulated world. And clearly the government hasn't taken that advice at this point. I want to point to what the task force said about Alaska. Quoting from your report, it says, the government may want to consider the approach taken by the Alaskan government, which prohibits the manufacture and sale of any cannabis product that closely resembles a familiar food or drink item, including candy, or is adulterated with additives or sweeteners. We are confident that with clear guidance to industry by the regulator and vigilant and predictable enforcement, this is not an insurmountable barrier, end quote. So it's taken 2 years for this legislation to come before Parliament. We have the example of the Alaskan government. There are other jurisdictions who have proceeded with edibles. Are you concerned that by passing C-45 without having a regulated environment for edibles, that we will continue to leave a large and, as you say, growing segment of cannabis to the black market, unregulated from a health point of view or a legal point?
I think you've answered your own question.
Thank you.
Right?
Thank you.
Mark, I don't know. Did you want to say something?
That's okay. I'm going to move to Mr. Spratt. I take it that your answer was in agreement with me. Mr. Spratt, picking up again from the task force, that another recommendation was that they recommended that offenses with respect to exceeding the possession limit should be dealt with through graduated administrative penalties, tickets, seizures, and fines, except where there's evidence of intent to traffic. I want to focus on the graduated administrative penalties. There's a 14-year maximum that's conceivably applied to a 19-year-old selling marijuana to a 17-year-old. Now, I understand that courts will use discretion, but it's theoretically possible. That's far in excess of what would happen from a 19-year-old giving a cigarette to a 17-year-old or a 19-year-old bootlegging alcohol to a 17-year-old. In fact, the 14-year maximum is equivalent to leaving Canada for the purposes of committing terrorism or producing child pornography. Is that an example of a proportional offense? Do you think that that's justified under this legislation?
No, it's not. And you're quite right that in the circumstances that you've outlined, I would be shocked if a court ever imposed a 14-year sentence. But what we know from history, what we know from studies of the impacts of criminal records, it's the imposition of a criminal record, not the imposition of custody, that presents the biggest obstacle for young individuals to advance and become productive and pro-social members of society. So by leaving the option to impose a record at all in those situations, considerable harm will be done. And what we also know is that it's not a white kid from a Tony neighborhood who's going to get in trouble for passing a joint to a 17-year-old friend when they're 18. These will be already individuals who are marginalized, disadvantaged, and discriminated against. Those are who will end up in court facing charges like that. And there's nothing in this legislation, apart from a faith on discretion for ticketable offenses, that mitigates that problem.
Do you see any issue? The government has clearly said that it does not want to decriminalize now. The NDP has been pushing the government to do so. Do you see a mechanism for doing that? What would be the appropriate policy in terms of applying the criminal law right now, given that we're moving towards legalization?
It would be appropriate now, and it would have been fair and just long ago to craft a federal policy to urge prosecutors to use discretion in diverting these sorts of charges from the criminal justice system. It is an offense to possess marijuana now, but we know that that will likely soon change. It is an often and common misconception that right now people aren't arrested for marijuana offenses, and that's not true. People are. They're brought to jail. Mostly and largely, those people already suffer disadvantages or are from racialized minorities. They end up in our courts, and people do indeed get criminal records and receive criminal sanctions for simple possession of marijuana. It happened 2 weeks ago in an Ottawa court, where court time was spent dealing with a young man who possessed half a gram of marijuana. And in the age of judicious use of court resources and Jordan principles, with charges being thrown out of court, that is something that should not be tolerated and something that can be easily fixed through a directive to public prosecutors.
Okay, thanks very much. Now we go to Mr. Oliver.
Follow up on that last comment you made. Easily fixed. We'll be reviewing obviously the bill and going through clause by clause. What would your fix be for that? Is that's not part of the legislative direction then? That's more of a
a policy directive to prosecutors, but what this bill could do is it could ameliorate some of those consequences that have arisen historically and have continued to arise while this bill is before Parliament, to allow people who have been convicted for simple possession of marijuana to easily apply for pardons on an expedited basis. Perhaps the fee of over $600 that, again, disproportionately and sometimes unfairly limits the availability of pardons to only wealthier members of society. This bill could deal with that directly, and it would be a prime chance to fix some of the unconstitutionality in the record suspension process that currently exists.
Okay, thank you. So a lot of my, coming in later in the questioning here, a lot of them that I had have been asked already. So I was going to focus just on the pharmacy presentation for a bit here. So I was a little bit confused. So we're here dealing really with recreational marijuana, Bill C-45, but you were making a strong case for pharmacists to continue to sell cannabis for under medical prescriptions. I was a bit, pharmacies stopped selling cigarettes a long, long time ago because of the negative health consequences of them. Do you not see, are you feeling a conflict at all with your association in trying to sell medical marijuana, which is primarily going to be smoked?
Sure. Thank you for your question. First of all, pharmacists are not currently involved in dispensing or selling medical marijuana to patients at all, just to clarify. And secondly, I agree with you. Pharmacists are concerned, as others are, about the potential risks of smoking marijuana and all substances and the toxicity associated with that. As others on the panel have mentioned, there are other forms of marijuana that are available, that are the research is evolving around them.
But just to be clear, you are here to make the case for pharmacists selling medical marijuana. Is that
for pharmacists dispensing medical marijuana.
Dispensing medical marijuana, okay. And how do you reconcile that with the CMA's position that medical marijuana should be eliminated now that this bill is coming forward?
I mean, we, like other medical professionals and patients, I think we're all aligned in the fact that we agree that there needs to be an increase in the level of robust evidence around the therapeutic effects and risks of marijuana. In spite of that, we've noticed over the last number of years that patients are deriving benefit from these medications. I've heard these stories anecdotally when I work at the neighborhood pharmacy. I've talked to many patients when I've worked in hospital who have told me about the compelling benefit that they've received. Currently, these patients, in spite of the lack of evidence and regulatory approval, are still using these medications without any medical oversight. They may be getting a document from a physician. They're having their marijuana then mailed to them through a mail order pharmacy. I'm not aware if there's consultation with healthcare professionals at those, not mail order pharmacy, mail order distributor. I'm not aware if there are healthcare professionals there, but there is no face-to-face contact with a healthcare professional as pharmacists provide. So in the interest of patient safety, we feel that it's important for us to be a strong part of that circle of care.
Okay, thank you. And just coming back to the distribution system, so my understanding is the legislation would leave that with the provinces and territories to license the distribution and retail strategies. So in Ontario, it's just been announced that the LCBO would be has been selected to do about 150 stores, I think. So they would have a distribution network and retail system. So I'm sure other provinces have like structures in place. What made you feel that the pharmacy distribution system management would be better than, say, the LCBO?
I would say that, first of all, the other provinces, many of them have considered their alcohol distribution systems and have backed away from them because they recognize there's a lot of retroactive investment that will have to be made into it. And I think that when it comes to the movement of the products, I think that where the pharmaceutical distributors industry stands out is its ability to already track the product, but it's also its ability to recall the product and get it back in as quickly as we do. And I think that the level of controls and the level of security around the products is second to none. And the question I always like to ask people is, can you think of the last time you've heard about pharmaceutical products being diverted in Canada? And the answer is you can't, because it's such a closed system, and greater than 95% of the products go through this system. So I think the main reason we present that is that it is so strong, it is so secure, it's so comprehensive, remembering as well that we deliver to many small many small communities where there aren't LCBOs.
Yes. Okay. Thank you for that. And I just wanted to thank the co-chair for the study that's been done. So I guess my question to you is a sort of an open-ended one. We're here to study the legislation. We've talked a bit about edibles and concentrates. Is there anything that you feel the legislation missed? If you think about the three goals, to protect youth, to combat organized crime, and public health and safety thoughts in the production and of cannabis. Is there anything that you think has been missed in the legislation that you would very much like to have seen added or included?
You've already heard from me on edibles.
Yeah, I've heard, so edibles.
But let me say that it is my understanding the government is going to move on edibles.
Yeah, we heard this morning
it is just that they need time to do some equivalency testing and other kinds of things. But you've heard me on edibles.
Correct, and that was
I
the
gave you
testimony
30 seconds to think about it.
Yeah.
Thank you. It's challenging. I think time was the key word that Anne used. What we all recognized was the complexity of implementing a legislation like this is enormous. And the more you scratch it, the more you realize how deep it goes into every sector of society. We all know that whatever measures are put forward initially, whether they be federal or provincial, will be starting points and will need to evolve. I think what I missed was the strong feeling that there was an engaged network of research and science to help inform these. You will run into this time and time again, this evidence base, and we have the capacity to do that. And I'd like to have seen a bit more support for that network to be able to inform this, recognizing that this is an organic program, that this will evolve, that this has to reflect and respond to changes, as we saw it had to do in other jurisdictions. So while I don't think it was legislated, I think that's something that I'd like to see a lot more support for.
And sir,
time's up, and that completes our 7-minute round. We're going to go to 5-minute rounds, starting with Mr. Weber.
Thank you, Mr. Chair. I'll address most of my questions to a fellow Albertan, Honourable McClellan, as well. We know you well in Calgary.
Yes.
Actually, I think the time you were elected, we lost our Curry Barracks to you up in Edmonton because of the fact we didn't elect any Liberals down in Calgary. So we blame you for it. Anyway.
Yeah, but just remember the oil sands.
Sure. Okay. Anyway, on another note here. I'm very interested in your travels and your experience down in Colorado and in Washington.
Right.
You mentioned a progress update that they've released down there through the chair and to the clerk. If we can get a copy of that progress update, that would be very helpful, I would hope that we can.
I think I can provide that. It was a letter provided by the Governor, Hickenlooper, and his Attorney General in response to a letter from Attorney General Jeff Sessions requesting certain information in relation to concerns that Attorney General Sessions had. Mm-hmm. So I think it is the most up-to-date information that the state of Colorado probably has provided.
Great. Well, that would be certainly useful. You mentioned in this update that they had said that there was no significant increase in the use of marijuana in these two states after legalization.
In Colorado, but then more recently, Jeff Sessions, not surprisingly, wrote the same letter to the governor of Washington. Mm-hmm. And I understand, although I haven't seen it, they did respond as well. And that but if you look at all their work over the past 3 years, and it is only 3 years, that statistically it would indicate that there has been no statistically significant increase increase in youth use.
In youth use?
Yes.
Okay. I find that hard to believe, but I'd like to see how they got those numbers.
And actually, the longitudinal studies that back that up are available.
Good.
And Colorado actually has done detailed work from, I think they use a minimum of 5 different studies, some in their own state, some from the national level, in which they are looking at use. It's they, I would say, have a fairly sophisticated method of testing and kind of double testing, right? Using sources from different places.
Sure.
And I would think we could probably learn something from that.
Okay. With respect to the black market, how has it been affected down there in these 2 states? Has there been a decrease in crimes, for example? Has there been what has been the impact with the black market down there and the sale of illegal marijuana? Is there any stats there?
I think the illicit market continues to be a challenge in both states. And they have a problem that Canada will not have, in that what you see there are people coming into Colorado and Washington, but certainly Colorado, and growing for diversion into other states. Because keep in mind, is that you've got Kansas, right? Yeah. They haven't legalized. So what people saw the opportunity to do was go into Colorado, grow, and then move that product across the border, which is why now state troopers in Kansas and other places, they're at the border.
I see.
And they are starting to pick this stuff up because it's moving by the truckload, or was. Okay. And that is a problem that we are not going to have in this country because we are legalizing on the national level. So, as I understand it, that has been a large, not exclusively, but a large part of the illicit market in Colorado and Washington is diversion to other states where it's not legalized.
Interesting. With respect to pricing between legal and black market, did you look into that at all? Did you find out, is there any differences there, or are they pretty equal?
Mark, you were in Colorado. I was in Washington. We've talked to Oregon. I think it's fair to say that Washington, I think it was Washington, out of the box, went tax heavy, and they weren't competing with the illicit market, right? And their numbers, when I was in Washington last year, were pretty staggering in terms of the amount of purchase that was still in the illicit market. And they learned a very serious lesson from that and moved very quickly to change the price point through taxation in terms of product that was available for sale. Price point here is going to be key in terms of what you see in the illicit market and how effective the legal market is at moving people over. Quality control, the guarantee your product isn't cut with something like fentanyl or whatever else, that's also important. But price point moves consumer demand, and I think they have learned from experience, both retailers and the states, that taxes cannot just be layered on and on and on, and retailers understand, but costs are coming down in these states. It's a competitive marketplace, and costs have come down dramatically. So I would say on any given day, retail, the legal market and the illegal market cost per gram is pretty similar.
Is that right? Okay. Interesting. Okay.
Dr. Elson, 5 minutes.
All right, thank you. Thank you. Dr. Ware, I particularly like your comments about needing more research. We know that more research needs to be done on this, both on the recreational effects, but also on the medicinal effects. You gave a good example on this link between mental illness and, psychiatric disorders like schizophrenia. In my medical career, on more than one occasion, I've diagnosed schizophrenia in patients who had consumed a lot of cannabis, only to find from their histories that, in fact, their psychiatric symptoms manifested before their use, and they were self-medicating. That being said, the plural of anecdote is not data. and we need more research on this. Do you foresee, now that it's legal, that more researchers will be willing to take this on, and there'll be more willingness on funding agencies to fund research into this?
So absolutely, yes. I think we're already seeing that. We're already seeing large national funding agencies start to look ahead at what the research requirements will be, and are already starting to plan for the mechanisms and the facilities to provide infrastructure and funding support for research, from the public health all the way down to plant sciences.
Mm-hmm. That's good to know. Yeah, I was on a trip with. I'm also on the Veterans Affairs Committee, and we were talking to at some medical facilities and post-traumatic stress disorder. And whenever you mentioned cannabis down there, they just looked uncomfortable and changed the subject. They just said, yeah, no, we just can't touch it. We can't talk about it. There's no research on it down here.
So I think that speaks to the second issue, which is the availability of funding. But you also asked about, does legalization mean more researchers will be interested? And I think that probably does start to change the stigma associated with studying the substance. That up until now, if you were interested in cannabis, and certainly when I began 18 years ago, I was sort of the laughing stock of my research community because I wanted to study smoked cannabis, and that's changed considerably now because people recognize the importance, and we're moving away from smoking. And I just challenge the comment that medical cannabis primarily smoked. It's actually primarily being used in oil and edible formats now, not smoked. So some of these impressions that we have are being challenged by the realities. So I think researchers are more interested. There are new methods of access to cannabis products, and I think patients are interested in participating because they realize the importance, and that probably will extend to the general public as well. I think people want to contribute to the knowledge base.
Thank you. It's good to hear. Yeah, Mr. Spratt, you mentioned some of the problems that are with our legislation, and I understand those challenges, and I agree. How do we? Again, we need to balance safety, but also. The rights of everyone involved. This is analogous to what we struggled with when we introduced our medical assistance in dying. There were some that were very opposed to it. Others that once we passed it thought it was far too restrictive. Now, like medical assistance in dying, we're in basically a uncharted territory, as it were. There's a few jurisdictions, but we're among the first. We're only the second nation on earth to do this on a national level. Although we see these problems, do you think that what we're doing here at this stage, with where it is criminalized, where it is not, is it at least a good first step?
It's a good first step. Unfortunately, the continued criminalization that you see in Section 8 and Section 9 of this bill will often run contrary to the purposes and principles of the bill, will reduce some of the benefits that are derived from this bill and aren't supported by past history or research. Take, for example, the continued criminalization of youths who possess marijuana, 5 grams or more. I take it that that's included because the government wants to discourage youths from possessing marijuana. Doing that through criminalization, the last 100 years since the Opium Act has shown us that hasn't worked. If full criminalization of marijuana doesn't deter a youth from possessing marijuana, a half measure such as that won't do that either. So a measure like that isn't going to deter a youth from possessing marijuana, and I gather that probably with more liberal access to marijuana after this bill, it's certainly not going to do that. And at the same time, it imports many of the problems with wholesale criminalization, and it diverts resources, it allows the misuse of discretion, it allows those systemic discriminatory factors to be put in play, and ultimately it's pretty expensive. And the same is true when you're looking at the difference between, illicit and licit marijuana, if licit's actually a word.
It is.
Oh, there we go. So, I mean, that sort of distinction, the 5 plants versus 4 plants, the individual who goes away for the weekend and their plant grows a centimeter taller and they're all of a sudden a criminal. It's expensive, and it can be very cumbersome to deal with that distinction. And that distinction is only necessary because there's a continued reliance on criminal sanctions to advance policy.
So I think that I understand why there is some reluctance, but we've seen that this sort of criminalization doesn't work, and there could be more benefit if that is rolled back out of this bill.
All right, thank you.
Time's up. Ms. Gladue.
Thank you, Chair. We see that there's not a lot of countries in the world rushing away to legalize marijuana. I think Uruguay was the only other one. Could you comment on how long it took them to actually legalize?
The country of Uruguay? Well, they used a phased approach. Once they made the decision to legalize, they introduced it, if you like, in stages, and their system is quite top-heavy with government control, if you like. I don't think it's a system that would fit nicely or easily with the expectations of Canadians.
It took them longer than a year and 2 months.
Oh, well, I think it's fair to say that they have for a number of years, and also because of changes in government and an election, and we all know how elections intervene and might change things up a bit. But yes, to your point, to get where they are today, it has taken them some time.
Right. And so one of my concerns, of course, is that by allowing the provinces all to do something different, which I think will be very confusing for Canadians, you know, what's the age here, what's the age there, how much am I able to use here, and the time frame of having 290 days left. It seems to me that when I hear testimony about medical marijuana, which seems to be extremely well controlled, it seems to have very good quality control. They seem to be able to market that down to the organization or individual in multiple forms, including the oil and including pills. If that was opened up to be the mechanism of delivery for recreational marijuana, that would eliminate a lot of the concerns that we're hearing about the homegrown thing, where 5 inches more can turn you into a criminal, or 5 plants versus 4 would be a problem, and there's no control of potency and all of those things. So would the price point of the medical marijuana system be competitive if that was opened up to be the recreational model? And I let anybody comment that wants to.
Maybe I'm misunderstanding, but I think that's exactly what is being proposed. The licensed producers will evolve to inform and to provide to the legal market, non-medical market.
Well, but they're also going to allow homegrown. And so, to me, that there's so little control on the quality and the potency, and whether you're putting fertilizer on, and whether you have more plants or not, and whether your kids are having access. I mean, you've got people that essentially are breaking the law today, smoking it, and you're trusting them to be responsible in the way that they're doing it. I think the homegrown is the part that is problematic, and the other distribution is better.
I mean, I'll weigh in with a perspective that we heard several times from the task force, and that was that people choose to grow cannabis for many reasons, and it's an easy plant to grow, and there are probably very many people that will continue to do it whether it's legal or not. The reality was that if people were able to purchase cannabis through illicit supply at a reasonable cost and reasonable access, that the choice to grow your own cannabis would actually disappear or reduce, because it was easy to obtain through illicit supply. And we were told and shared ideas that you're allowed to grow your own tobacco, you're allowed to brew your own alcohol or beer and wine, and there are some people who choose to do that, and they do it for their own benefits and give to friends at Christmas, who then put it away and never touch it. But the idea is that it exists, and leaving that framework in place was considered reasonable, given the fact that if there was sufficient access elsewhere, that the actual demand for that would reduce considerably.
All right, Ms. McClellan, one other thing. I mean, in addition to trying to make sure that we keep cannabis out of the hands of children and control public safety, to get people ultimately not consuming cannabis, because we've seen that there's harm, there should be some kind of prevention. What do you think about the prevention part of C-45?
Well, I think the most important part of prevention, which we have learned from tobacco and alcohol, and probably some other things, I might include gambling, is public education. And that's the lesson you hear over and over again in states like Colorado and Washington. You have to have robust public education. You need it out of the box early. And we heard from parents, from school boards, when we did our roundtable discussions, virtually everybody in this piece, they all agreed on one thing, which was we need good public education. Parents wanted to be able to have fact-based information they could share with their kids. School boards and teachers, the same thing. And I think we've learned from tobacco a number of reasons why that tobacco use has dropped dramatically, even from the time I was federal minister of health, or dropped somewhat. I shouldn't say dramatically, I suppose. A lot of that is around public education. Yes, it's price too. And again, that goes back to the conversation we had, Mr. Weber. Price point is important here. But public education, understanding the risks, understanding why you shouldn't start to use early, and if you do, don't use heavily, right? Use casually in moderation. These are the things you need to watch for. Don't use and drive. Public education, I think, is the best preventive strategy there is. Then there are lots of other things you can add to that, whether it's a price point, whether it's labeling, restrictions on marketing and access. But at the end of the day, I think the more public education you have, and to Mark's point, we need research to understand what we should be telling people, right? I mean, you need good information, which you then convey to the public at different demographics, different age cohorts. You provide that information so they can make an informed choice.
Thanks up. Mr. McKinnon.
Thank you, Chair. My question is for Ms. McClellan and Dr. Ware as well. So the task force recommended personal cultivation with a limit of 4 plants and a maximum height of 100 centimeters. I was wondering, what is the reason to start with for the maximum height?
Do you want to start?
It had to do with fence heights and outdoors and not being visible from outside of so there's a privacy concern around if you're growing this outside, you can't be seen, you're not having trees that are growing above your fence. We looked at existing legislation in other states where they had numbers of plants, and we just considered that this was a reasonable way to allow people to cultivate cannabis for themselves.
So it wasn't to limit the amount of psychoactive substance that could be produced. It was really to keep it out of the public view. Is that the point?
Primarily, unless I'm not recalling an additional.
We also heard from experts. We consulted experts, especially in the United States, who told us that they felt 4 plants 100 centimeters high would provide adequate supply for a moderate/reasonable user of cannabis.
So my extensive research on Google here indicates that 100 centimeters, you can get a lot of product out of a smaller plant, as well as a taller plant, so that in terms of controlling the amount of product that can be produced, the size doesn't really correlate. So I guess I'm wondering why those experts would have made that recommendation. But I understand this point of visibility, although I'm wondering why we would use the criminal law powers to limit the visibility like that. That seems to be something that the provinces might be better placed to regulate. Would you like to comment on that?
I recall we did suggest that provinces and municipalities specifically could consider mechanisms to give permits for people who wish to grow. That's something that we left to the municipalities and provinces to consider. So they would register as somebody who has a plant. They would at least have a permit that said that they were allowed to do so, and that would be a municipally.
Except it's still in this law 100 centimeters, which would put a criminal penalty on a higher height, when really the objective is not. It doesn't seem to me to be a criminal
But there are gradation. I don't have the legislation in front of me. I see, Mr. Spratt, you do.
I do.
You came very well prepared.
I try.
But I can't find it right now, but I think that there would be a gradation, and that would be the anticipation. And I think in our report, we talked about the fact that you could have so-called administrative penalties. You could confiscate, if somebody's growing 100 plants, for so-called personal use, that one might use the criminal law there, especially if you had other evidence around the number of plants. The plants themselves would not suggest prima facie evidence. Mr. Spratt, I would think of trafficking, but there might be other baggies and all sorts of things in the home that might lead to a prima facie evidence case for trafficking, in which case you would clearly use the criminal code. But if you simply had a few plants over and above 4, you might very well use a ticketing regime. You might confiscate the plants with a warning. That's what we, I think, thought would be pragmatic and reasonable as we worked through this.
Okay, thank you.
Could I interject just
Yes.
for a minute?
The criminal law power is a very blunt tool to deal with social problems. It's an even blunter tool to deal with gardening problems. And when you look at the rationale that has been disclosed for, the criminalization of that 1 extra centimeter, looking at fence height, not looking at yield or potency or problems with distribution, that could very well lead to some charter problems with respect to the rationality of that sort of somewhat arbitrary benchmark.
But we did, in our report, discuss some of those things you've just mentioned. In terms of why, and it's certainly in our discussion with experts from the United States. Why? Because every state that's legalized that allows personal cultivation, Washington does not, but everybody else has established a limit around home cultivation and has thought through the reasons why they have established that limit. And we heard from people in the United States and also here in terms of what would be a reasonable home cultivation number in terms of moderate user, product, and so on, right?
Okay, thank you. I understand. So I'd like to move on a little bit if I have time.
Sorry.
No time, okay.
No time. Mr. Davies.
Thank you. I'd like to talk about a national e-commerce platform. Like Mr. McKinnon, I did a lot of vicarious research this summer. And this is what I've discovered from what I can remember. No, I'm teasing. The illicit market is ubiquitous. It's coast to coast. There's a variety of products, imported and domestic. There's distributors, dealers everywhere who are trusted. Their prices are acceptable to the marketplace. The marketplace is sophisticated. I'm told there were at least 12 websites that are making illicit cannabis available. There's home delivery mechanisms. The C.D. Howe Institute has stated that the licit market must be able to compete with the illicit market for this whole scheme to work. And that it isn't just about price, it's about convenience, it's about choice. And I'm told, though, that there is nothing in C-45 about an national e-commerce delivery platform. One of the major medicinal cannabis producers in the country told me bluntly that in the recreational regime, if we don't have a permanent, robust e-commerce platform, this bill is not going to work. And I noticed in the task force that I believe, quoting from it, says, consideration should be given to ensuring that online retail sales have appropriate consumer safeguards to accommodate those who may not have access to storefronts, for example, small communities, rural and remote locations, mobility-challenged individuals. A direct-to-consumer mail-order system for non-medical cannabis should be considered. My sense is that in order for a producer in Ontario to be able to mail product to BC, it would have to be federally regulated under at least 3 heads of federal competence. It's a scheduled product. This is interprovincial commerce, and it's the mails. Yet this bill, C-45, doesn't explicitly address that. I'm just wondering, Ms. McClellan, do you have any recommendations about maybe where we might want to look to improve this bill in that area?
Well, I think the points you've raised are important ones. I have always believed that the way you compete with the illegal market in this area, as in some others, is with quality, choice, and price. And I think that it's going to be interesting, and it will take time, and it's going to take time, more than a few months, to develop a stable, normalized retail market in whatever form provinces choose to put that in play. But the world in which we live is one where people are used to ordering online, buying online, and therefore, and we've seen with medicinal that in fact that platform works. Now, some, and I certainly take your point in terms of lack of direct input from a pharmacist in many of those transactions, although everybody should have a doctor who has authorized the product. Anyway, all that to say that I think e-commerce going forward will be important, which is why you see Ontario specifically including an e-commerce platform in their proposal on Friday as it related to the province and ordering from their retail and wholesale distributors. I think it will be interesting as this market evolves to see whether or not some form of national e-commerce platform will be an important complement to that which is presently being recommended in the legislation. I think you need to remember it will take time. We will learn what this marketplace needs, both in terms of safety and health, but also trying to get the black market or illegal market out of this space. And we're not naive. We're not suggesting that you're ever going to reach nirvana in terms of that there won't be any illegal sales. We still have illegal sales of tobacco and a little bit of illegal sales of alcohol, although very little in terms of total consumption. All that I would say is that e-commerce will be, I think the task force would say that e-commerce will be an important part of this market going forward. How that happens and when it happens probably requires more conversation between the Government of Canada and the provinces and territories.
Time's up. That's a great way to finish up, and I want to say on behalf of the committee, thanks very much for all of your contribution to help us understand the different permutations and combinations that we're going to run into. But this is the very beginning of this study, but you've certainly provided us with a lot of information. So I want to thank you very much for this. And with that, we're going to suspend the meeting until 1:45 to 2. Yep. So 1:45 to 2, we'll reconvene back here for 2 more sessions. Okay, thanks very much. Meeting suspended.
Well done.
All right, we'll reconvene our 64th meeting of the Health Committee, and we welcome a new panel of witnesses, and we have with us today from the Canadian Medical Cannabis Council, Philippe Lucas, Executive Director. From the Canadian Hemp Trade Alliance, Keith Jones, Chair, and Robert Ray, Director. We were wondering if it was Bob Ray, but it's not, it's Robert Ray. And from Saskatchewan Minister of Justice, we have Dale Tesarowski. Close enough. Thanks very much. Executive Director, Corporate Initiatives, Performance and Planning. And from the Cannabis Canada Association, Sebastian Saint-Louis, Member of the Board of Directors, and Colette Rivette, Executive Director. So I believe each one has 10 minutes to start. Yes, and we'll start with Mr. Lucas. I understand that you have a presentation that you're going to forward to us later.
I will. Thank you very much. I'll be speaking to it today, so the notes will come to you shortly thereafter. I'm here representing the Canadian Medical Cannabis Council today. I also want to share that I'm a research affiliate with the Centre for Addictions Research of British Columbia and Vice President of Patient Research and Access at Tilray, one of the licensed producers here in Canada, located in Nanaimo, BC. I've been working personally on medical cannabis for about 22 years now, so this is an area that's somewhat familiar to me, and it's a pleasure to be here to be able to share some of the work and knowledge and research that we're doing with you here today. I want to tell you a little bit about the Canadian Medical Cannabis Council. We're an industry association representing 7 licensed producers and approximately serving about 40,000 patients from that group of 7 licensed producers. And one of the distinguishing characteristics of the Canadian Medical Cannabis Council is putting a patient-centered lens on our policies and practices. And to that effect, we have a patient advisory committee made up of national organizations that include the Arthritis Society of Canada, the Canadian AIDS Society, Canadian Cancer Survivors Network, the GI Society of Canada, a number of other organizations that help advise us when it comes to the policies and that we put forward and our lobbying positions as well. Some of the CMCC priorities include lowering the costs of medical cannabis and improving access to patients. And to that extent, we've been urging the federal and provincial governments to maintain a clear separation between medical and recreational cannabis markets through differential taxation. And what I mean by that is we feel that medical cannabis should be treated like all other prescription drugs in Canada and not be taxed. And certainly that's one of the things I hope to be able to discuss with you guys as we take questions today as to why medical cannabis should be zero-rated like other medications in Canada. I'd also like to share that we're working with private insurers to help improve and increase the insurance coverage for medical cannabis patients as a precursor to getting provincial coverage for patients in Canada. Today I'm going to share some results from a national patient survey that we conducted in January. It's the largest patient survey ever conducted in Canada with 2,032 responses, and I think it'll help illustrate some of the ways that end users are using medical cannabis in Canada, because there's a lot of overlap between the patient population and the recreational cannabis population as well. So the average age of this particular population was 40 years old. So we actually see that it's actually middle-aged individuals typically who are seeking medical cannabis. A lot of the time they've had treatment failures, and they're seeking alternatives to their current prescription drug use. In terms of primary conditions, we find that mental health, which is a grouping of insomnia, mental health, and post-traumatic stress disorder, is actually the #1 reason why patients are using medical cannabis. That covers 40% of all patients in Canada. And that's closely followed by pain, which is a grouping of arthritis, chronic pain, and headache, which represents about 37.5%. So what you see is about 80% of patients in Canada are currently using cannabis as a treatment for pain or for mental health. In terms of average use, we see that patients report using on average about 1.5 grams per day, and that 78% of patients actually use 3 grams or less per day. So you're not seeing large patterns of use here. That data is consistent with research that's been done in Canada and the US, as well as in Europe over the last few years. It shows that most medical cannabis patients use between 0.5 and 1.5 grams per day. In terms of primary method of use, I have good news to share because I've been doing this kind of research for the last 10 or 15 years. And in this survey, we find the primary method of use reported is vaporization at 31%. It actually beats out joints and pipes and water bongs that might have been more popular in the past. So this is a really health-conscious shift that we're seeing from a medical cannabis population. But I also think it has policy implications as we move to regulate even the vaporization of products in Ontario and throughout Canada. The kind of key focus area of my research is cannabis substitution effect, which is the way that patients as well as recreational users consciously and subconsciously use cannabis instead of using other substances. So I'll share a bit of data on that from this survey today. We do find that out of this survey, which once again is by far the largest survey of Canadian cannabis users to date, 69% of patients report substituting for prescription drugs. So they're using cannabis in order to reduce their dependence on prescription drugs. But we also find ad hoc substitution for alcohol by 44%, substitution for tobacco by 31%, and substitution of illicit substances by 26% of the population that had previously used these substances. Now, I like to get a bit more granular with my data, and so when patients say they substitute for prescription drugs, I ask them, well, can you name 3 prescription drugs you're substituting for, or up to 3? And it should be no surprise, knowing that patients are using cannabis for pain and mental health, that 35% of the substitution is for prescription opioids. Now, that's closely followed by antidepressants at 21%, and then non-opioid pain medications at 10%. We also see very high rates of substitution for benzodiazepines, which are nearly as problematic in our society as opioids are in terms of dependence and public health impacts. I wanted to get even more granular than that, so when patients cite that they substitute for opioids, I ask them, are you substituting at 25%, 50%, 75%, or are you giving up opioids altogether? And what we found is of the 458 patients that cite substitution for 610 total opioids, understanding some patients use more than one type of opioid, a full 60% were given up altogether at 100%, and a further 18% were self-reported to be given up by 75% or more. In terms of alcohol, we get similar data. 513 respondents who substituted for alcohol, 31% of those say they gave up alcohol altogether, just as a kind of ad hoc effect of introducing medical cannabis into their course of care. Now, I want to use that as a segue to look at some of the research that we've seen come out of the U.S., both in terms of medical cannabis states and the recreational cannabis states, because I think it can help inform what we can expect here in Canada. Over the past 20 years, over 20 states, as you know, have legalized access to medical cannabis, and right now 8 states have also legalized recreational adult use of cannabis. Now, this has led to significant impacts on public health and safety. That includes a reduction in opioid overdose deaths. And in fact, there's a study published in the Journal of American Medical Association that showed a 25% reduction in opioid overdose deaths in medical cannabis states compared to the neighboring states. And the longer the medical marijuana program was in place in the state, the greater the effect. We also see reductions in alcohol-related automobile fatalities, reductions in violent crime and homicide, reductions in suicides. And I heard this answers one of the questions we heard today. We also see a decline in teen use of cannabis. And in fact, there was a report that came out for a national survey just last week that reported that teen use of cannabis has now declined to a rate, it hasn't been lower since 2002. So we're seeing a significant decline in the teen use of cannabis. We are seeing a slight increase in the use of adult use of cannabis, but interestingly enough, it's also accompanied by subsequent decrease in the use of alcohol and associated harms. Now, all of the harms that I've mentioned that are reducing right now, whether it be violent crime, homicides, suicides, or otherwise, the researchers suggest are being reduced because of that substitution of cannabis for alcohol. Now, other impacts include that great impacts on taxation. Colorado now makes more money on the sale and taxation of cannabis than they do on alcohol. This in the home of Coors. And also on job creation. In 2015, Colorado created 18,000 jobs and generated $2.4 billion in economic activity through their cannabis policies. That leads me to a discussion that I think is important for this committee to consider, which is the importance of brands when it comes to defeating the black market. We've heard today in previous speakers talk about the fact that right now, if you go online, you can order cannabis from 20-plus different sources online across Canada. None of those are legitimate sources of cannabis, and it'll be incredibly important to allow Canadian consumers to differentiate between the illicit market and the new and emerging licit market. And one of the ways that they can do that is through the importance of brands. So the rationale for responsible branding directed to adults includes eliminating the confusion between the illegal and legal markets, to allow professional companies to separate themselves from less scrupulous competitors, to differentiate high-quality products from low-quality products, and to provide an opportunity to educate consumers about responsible consumption. Now, this has started an initiative that's taking place right now between a number of the licensed producers in Canada. In fact, 16 licensed producers representing 90% of the medical market right now, and both industry associations, Cannabis Canada as well as the Canadian Medical Cannabis Council. This is an initiative that we're doing with Advertising Standards Canada to develop a self-regulatory regime to allow responsible branding to adults when it comes to the recreational access to cannabis. Now, the principles of this initiative are that marketing by licensed producers will only promote brand preference, will not attempt to influence adult non-consumers. The marketing by licensed producers will not be directed to persons under the age of 18 or whatever the limit is at the individual provinces, be it 19 or higher in individual provinces. That all advertising messages will contain responsible use statements, which goes much further than what we see from the current alcohol industry. That licensed producers may voluntarily obtain pre-clearance of advertising campaigns in order to ensure they meet these guidelines, and that licensed producers agree to adhere to provisions of the Canadian Code of Advertising Standards. So in conclusion, I'd like to say that medical cannabis, as I've reported, is primarily being used in the treatment of chronic pain and mental health. The medical cannabis patients commonly self-report substitution of pharmaceutical opioids, of alcohol, often leading to complete abstinence of the substances identified. And the branding can not only reduce the harms associated with legalization and regulation of adult use of cannabis, but can also maximize the potential public health and safety benefits. Thank you very much for your time today. I really appreciate it.
And thank you for your information. The report that you're going to submit will be available when?
We're going to be submitting it by the end of the day,
okay.
And I think we're going to make use of your translation services here to be able to translate some of that. We're also going to be submitting a brand new publication from a study that I've done called Rationale for Cannabis-Based Interventions in the Opioid Overdose Crisis. I'm happy to speak to that today if there are any questions regarding the use of cannabis and opioids, and another study as well that I've done on substitution of opioids as well. Thank you very much.
Thank you very much. Now from the Canadian Hemp Trade Alliance, we're going to have Mr. Jones, or will be making the presentation for 10 minutes.
Thank you very much, Mr. Chairman. We very much appreciate the opportunity to appear in front of the Standing Committee. My name is Keith Jones. I'm on the Board of Directors of the Canadian Hemp Trade Alliance. And my day job, I'm a general manager of Roland Farms, which is a large farm in southern Alberta. We've been growing hemp since 1998, when the industrial hemp regulation was first put in place and it first became legal to cultivate hemp here in Canada. With me is Robert Ray, who's also on the Board of Directors of Canadian Hemp Trade Alliance. Robert is with Canada Hemp Foods, which is one of the hemp products distributors that's operating here in Canada as well. And Robert's business involves exporting hemp products to a number of countries around the world. Canadian Hemp Trade Alliance is a member-based organization that has 250 farmers as members, as well as processors, distributors, plant breeders, and researchers. And we're an industry association, a not-for-profit, volunteer-driven association. And we had the opportunity to reach out in Ottawa earlier this spring, and we're invited to review the cannabis legislation, Bill C-45, C-45 when it came out, and consider making a presentation to the committee if there were some unintended consequences that may arise out of the legislation for the hemp industry. We're here today because we are concerned that as drafted, Bill C-45 jeopardizes 1,200 jobs in the Canadian hemp industry today for two specific reasons. One, the current legislation does not differentiate between hemp, cannabis, and marijuana. And related to that, the current legislation provides responsibility for regulating the production, transportation, and distribution of all cannabis products with the provinces and the municipalities. That is going to create a tremendous burden on the current hemp industry. Our own farm, we operate in 5 municipalities, and so to try to bring the regulators up to speed, it will probably curtail our business for a couple of years based on that requirement right now. Our proposal back to for the committee's consideration is, in order to prevent the unintended consequences of derailing the Canadian hemp industry, is to exempt hemp in the legislation as item 5 under Schedule 2 exemptions by exempting whole hemp plants from the legislation, and because that exemption would then be in place to carve hemp out of the CDSA, the cannabis regulation within CDSA. So that's our request. I'd like to, Mr. Chair, provide a bit more background in support of our request. Hemp is very different from marijuana and from cannabis in that hemp varieties originate from plant breeding that's been done to reduce the total THC in the hemp plant down to below 0.3%. So you can't get high from smoking hemp unless you were to smoke a telephone pole of it, which would be very difficult to do. It is from the plant cannabis sativa, but through the experience of the industrial hemp regulation over the last 19 years, Health Canada has approved a list of cultivars that are known to be hemp. They're confirmed to consistently have no more than 0.3% THC in them. So the definition of hemp, Health Canada has done a lot of work since the industrial hemp regulation has come forward and has those definitions readily at hand. Hemp is proven safe. In 19 years of cultivation, there have been no reported public safety risks associated with hemp cultivation and transportation, and there have been no reported incidents of criminal activity associated with the hemp industry. At the time the hemp regulation was first put in place, there was a lot of learning to be done, but 19 years has given us a pretty good track record for proven safety. Our farm produces hemp specifically for the food market. So we grow a hemp plant to harvest the grain at the top of the plant. We're currently prohibited from harvesting the leaves or the buds of the hemp plant as part of the industrial hemp regulation. We can harvest the straw for fiber, but as yet, a fiber industry hasn't developed in Canada. In Canada, the Canadian industry is known as the global leader in the food use of hemp. Canada is known for having the biggest hemp industry supporting safe food use of hemp. In 2016, Canadian industry exported $145 million of hemp food products to other countries around the world, as well as today you can walk into most grocery stores in Canada and get a bag of hemp hearts, because again, dehulled hemp and hemp hearts have a fantastic nutritional profile, known both for the high omega-3s in the oil profile, as well as a very appealing plant protein profile. So hemp is becoming a very popular food product. The potential of the hemp industry is really strong as well. We've grown to 100,000 acres of production. The Canadian Hemp Trade Alliance forecasts that with some modernization of regulation associated with hemp, we can grow the industry to over $1 billion industry within the next 7 years. We've just barely started working on the feed market on the fiber market, and on the natural health products market. So there's great opportunity for the hemp industry going forward. In December, the Federal Cannabis Task Force, in fact, in their report, recommended a relaxed regulatory regime for hemp. And so we're appreciative to see that recommendation. In terms of our specific ask or our proposal, we're really specifically looking to see hemp exempted from Bill C-45 by including it in Schedule 2 under exemptions. We are seeking, and I'll provide to you the specific definition, which again draws on the Health Canada definition of hemp. We'd ask that hemp and hemp plant parts, including the whole hemp plant, be exempted under Item 5 under Schedule 2 exemptions, with hemp to be defined as cannabis plants grown from certified seed of Health Canada's list of approved cultivars, and those are the cultivars that are confirmed to regularly produce an absolute maximum of 0.3% THC. The definition of hemp has been well established in the experience that we've had in Canada with the hemp industry. Canada is positioned to build on its leadership, global leadership in the food industry by also working further with a modernized regulation on the feed, the fiber, and the natural health products marketplace. There's tremendous interest in CBD as another health constituent or health component. The Europeans are working extremely aggressively on this, and the FDA has an open comment period seeking input on CBD. CBD, when you breed THC out of hemp, you naturally get more CBD, which is why hemp is looked at as a very good source for CBD, and the medical industry is looking at a number of different uses for and potential medical benefits arising from CBD. Whole plant use of hemp would enable the access of a number of people and Canadian patients and others around the world to a very low cost source for CBD itself. And so we think that's a real benefit that can come from the hemp industry as well. Thank you very much for your attention. Robert and I will be very pleased to answer any questions that we can going forward.
Well, thank you very much. And now we go to the Saskatchewan Ministry of Justice, Mr. Tezarowski, for 10 minutes.
Thank you very much. Thanks for the opportunity to state a few words regarding Bill C-45 and the likely legalization of cannabis in Canada. In case you're counting, we have about 292 days left before July 1st of 2018. I actually found a website that has a counter on it. I apologize as well in advance for asking more questions than answering questions today. We've just engaged Saskatchewan residents in an online survey respecting the various provincial responsibilities. And once we get our results, we'll have a better idea on where to go from here. Over 20,000 people have completed surveys over the last 3.5 days. So it's a staggering number, which only points to the importance of what we're doing today. The other point I'd like to make at this time is that legalizing cannabis, or really legalizing certain people who are over a certain age, who have used, share, or grow certain amounts of cannabis, wasn't something on our provincial agenda. While we're not being dragged kicking and screaming to the dance, putting on our dancing shoes wasn't something that we had planned on doing. There are a lot of responsibilities that the federal government's put on our provincial plates, and not a lot of time in which to get things ready for implementation. Amongst other things, the province is responsible for designing and licensing the distribution and retail sale in their respective jurisdictions, and carrying out associated compliance, taxation, and enforcement activities. Setting additional regulatory requirements to address issues of local concern, such as setting a higher minimum age or a more restrictive possession or personal cultivation limit. With municipalities establishing zoning rules for cannabis-based businesses, restricting where cannabis may be consumed, and amending provincial traffic safety laws to further address drug driving. To name a few, license suspension for drug impairment by new and experienced drivers and zero tolerance for any drug use by new drivers are already existing Saskatchewan laws. We must engage with our people, businesses, communities, partners, and other stakeholders regarding these issues, and eventually be able to implement processes and practices before July 1, 2018. We must be ready to implement or deal with a minimum age of purchase, legislation, regulation, and statute changes, regulating personal cannabis cultivation and potency rates, or the quality control really at the point of sale. We need to ensure that what the consumer is getting is what they're supposed to be getting and not something that might be harmful. We have to regulate distribution, retail sales, consumption, and possession, and by that I mean where cannabis may be permitted, how it may be consumed, etc. And of course, taxation and pricing. A taxation framework for cannabis must carefully consider the distribution model and methods of administration and enforcement to ensure tax is appropriately applied and collected. In setting a rate of tax to be applied to cannabis, the government must consider a rate that is high enough to deter the use of cannabis from a social acceptability perception, but not so high that individuals choose to purchase it illegally to avoid payment of the tax. I call this the sweet spot. In addition, we must address issues such as engagement, public education and awareness strategies, occupational health and safety, workplace safety issues, drug-impaired driving laws. We have to engage regarding regulation of cannabis sales and distribution to and from our First Nations communities, municipal authority respecting zoning, licensing, taxation, and fees, and completing interjurisdictional collaboration and analysis regarding age, retail models, taxation, and pricing in particular. We want to have a landscape that's as familiar across the country as possible so that we don't move from Sparta to Greece to different city or province states that all have different laws. The real question is can all this be done in time? We hope so, but as you see or hear from me today, there is much to accomplish in a very short period of time. Having 12 to 18 months post-royal assent would have been an easily attainable time frame. Instead, that was reduced to 14 months post-introduction of the bill. One of the problems that we have in Saskatchewan is that we have set legislative sessions for the spring and the fall and a relatively strict timetable for introducing legislation. We give notice in January, get approval in the spring, and then actually introduce the legislation in the fall session. Any bill is then debated and voted during the following spring session. Cannabis legalization as proposed takes us so far away from this timetable that they're complete strangers. We must go outside our normal practice rules in order to meet the July 2018 deadline. Although we're doing our best to do so, there are no guarantees we'll be able to meet this federal deadline. In addition, we've had to begin our processes without a federal bill in its final form. While we know today what Bill C-45 says, will it look like this by the time it gets to royal assent? There are innumerable examples of other bills where changes, sometimes significant ones, are made during the legislative approval process. Canadian jurisdictions, however, are being asked to proceed without a safety net in the expectation that there will be no major changes en route, or that we'll have to be flexible enough to be able to respond to those changes once we embark on our own implementation strategies. Saskatchewan has some concerns about cannabis legalization. To name a few, ticketable offenses, enforcement and regulation generally, public education, awareness, prevention, and treatment, minimum age, labeling and packaging, workplace safety, and would a phased-in or staged approach work better? With respect to ticketable offenses, Saskatchewan agrees that a cannabis ticket, as set out in Part 2, is a criminal matter. A conviction for such an offense is a criminal conviction, and that is where the issue lies. We appreciate the effort at increasing justice efficiencies by using a ticket, but because of that format, is an individual being led to believe that their payment of a fine is the end of the matter? Is it like a traffic ticket? Do they appreciate that they would then have a criminal conviction that would affect their ability to cross a border, for example? The ticket itself must make this very clear. And we, as provinces, are engaging in discussions with our federal colleagues about these issues. Perhaps sections 51 sub 3, 52, or 53 should also include a provision that a conviction is a criminal one. A second issue, and perhaps a more important one about ticketing, concerns section 52B, respecting its requirement that the judicial record kept by a province must be separate and apart from other judicial records. As the conviction is a criminal one, we don't see the need for this requirement. Should we have to create a separate record-keeping system for just these offenses, not only will Saskatchewan have to redesign our system at great cost, it will take considerable time to do so. And for what purpose in the end? An offender must still disclose the conviction if they cross a border. The conviction will still show up in a criminal record check. With respect to enforcement and regulation, while laudable, cannabis legislation is being implemented without enough scientific foundation. And I think we heard from Dr. Ware this morning in that respect. Is there a consistent blood drug concentration that equates to an individual's impairment? Can all of the toxicology experts agree that at X nanogram % of THC in blood, everyone is impaired? They can with alcohol. But my discussions with the toxicologists have suggested that they aren't at idem on that point. We're designing a criminal law system through the interactions of Bills C-45 and 46, yet the science hasn't quite caught up to us. We're also concerned that drug-impaired driving will increase due to legalization, and significantly higher numbers of standard field sobriety testers, SSFT, or drug recognition evaluators, DREs, must be trained and in the field when legalization takes effect very soon from today. Not only does it take time to train officers, doing so comes at significant cost. While in Saskatchewan we're reducing these costs as much as possible by doing the DRE 2 weeks classroom training at home. We're doing that in Saskatchewan. We still have to send our officers to either Florida or Arizona for the 3rd week of training, and that's expensive. Moreover, roadside testing is still at its infancy. Recognized practice rules are not yet in place, nor are there any approved roadside devices. And again, our scientific friends and those in the Department of Justice are working very hard in that respect. We're 292 days away, and we don't have any instruments that are being approved at this time. The costs of these devices are likely to be significant, and our law enforcement and municipal officials are very concerned that the combination of training needs, device procurement, and the ongoing per test and analysis cost will be much greater than they can absorb. Let's put this into perspective. Recent funding announcements from the Public Safety Canada will help. They've offered $81 million over 5 years for provinces to share. But what does that mean? There's $81 million over 13 provinces and territories. That's $6.231 million each over 5 years, which is $1.246 million per year per jurisdiction. To put that into context, we estimate the cost for a device, an approved screening device, will be $3,500. We also know that it costs us about $3,500 to send an officer to Arizona or Florida for the weeks-long training. It costs $1,000 to train an officer for SSFT. and I'm not an accountant, so forgive me, but if we take 1.246 million divided by 3,500, that comes to 356. So we can purchase 356 devices or train 356 officers or some combination of both with the money that's being offered. We'll have to absorb the rest. On another point, by requiring blood analysis, and we see the scientific reason for having to do so, are our laboratories capable of handling such a large influx of samples? Are there enough labs? Are there enough lab techs to conduct testing in a timely manner? We're left with a situation where a sample may be taken one day and it takes weeks or months to be analyzed. Lastly, our police authorities are concerned that enforcing a 4-plant grow provision, personal grow provision, will be very difficult, especially if the cultivation is being done inside or away from view. There's virtually no way to regulate this, and our officers are very concerned about this. With respect to public education, awareness, prevention, and treatment, we found a position shared across ministries and agencies in Saskatchewan is that the primary focus for this topic has to be youth and young adults. Safe use and awareness of potential consequences caused by the drug must be addressed, and although this is an area of joint responsibility, the federal government must lead the way well before implementation. We know that cannabis use by young people is amongst the highest in the developed world in our country, yet our youth appear to be ill-informed regarding its dangers. For example, the Canadian Centre for Substance Abuse's recent report, Canadian Youth Perceptions on Cannabis, noted that youth consider cannabis less harmful than alcohol, yet cannabis use significantly increases the risk of injury or death in vehicular accidents. The health risks associated with cannabis are also little known. We can likely expect, however, that there will be increased demands for our health resources from addictions, mental health, and medical perspectives.
It's important information, but we've gone over the time limit, so if you could wind up so we could get to some questions.
Certainly. The last point I want to make is the very last one. Would a phased-in or staged approach work better? And we're already starting on that road with respect to edibles. We're saying we're not doing edibles now. We'll consider doing it. We'll do it appropriately. So let's take a staged-in approach with respect to the balance of this. Let's get it right from the start. Let's start small. Let's get it right, and then let's move forward from there. Thank you.
Okay, thanks very much. Now from Cannabis Canada Association, Mr. Saint Louis.
Refer to our Executive Director, Colette Rivet.
Thank you, Mr. Chair, for inviting Cannabis Canada. We really appreciate the opportunity to share some of our perspectives as well. I'll tell you a little bit about our association. We have over 20 members actually, of licensed producers, and they've been licensed by Health Canada. And we have a patient committee that tries to help give feedback to our members. We also have a committee on regulations, which we interact with the Office of Medical Cannabis on a regular basis to try and improve the regulations even better and to make it more quality products that we have. We also have a communications standards committee as well. And we are just about to continue with discussions with the Secretariat. Hopefully we'll be able to assist them as well. And since 2013, Canada's licensed producers, large and small, have been effective partners in the establishment of this strict, well-regulated system for the production and distribution of medical cannabis. That's the envy of the world. It's for this reason that the Government of Canada is entrusting Canada's licensed producers to be the foundation of the production system for legalized adult-use cannabis. Licensed producers are eager to work in collaboration and compliance with the federal and provincial governments to quickly establish effective, low-risk distribution and retail models that are well-regulated, highly secure, and tailored to the needs of each province. Bill C-45 must include measures which will allow the legal industry, though, to compete with the black market. notably in relation to price, and with regard to the branding and advertising within well-regulated parameters to help eliminate confusion in the marketplace about legitimate sources and guide Canadians in their use of a new and complex product. The medical cannabis system must be protected also for the benefit of Canadian patients. Since 2013, as I said, we have been involved as trusted partners for the government, and we want to continue to do that with the provincial governments as well as the federal governments. Licensed producers have proven they can deliver on a state-of-the-art, sanitary, secure, and professionally operated production facilities, products packaged and labeled to protect children and ensure that adults have information to make informed choices. A proven distribution and retail system that ensures products reach their intended recipients with no diversion to the illegal market. Production and retail without impact on the surrounding communities or co-location with alcohol. Eliminating the black market is one of government's main objectives for legalization. There are a number of factors that will impede the ability of the new legalized system to compete with the firmly entrenched black market. Governments need to be mindful not to impose pricing or taxes that will make it impossible for licensed producers to compete with the black market. The Parliamentary Budget Officer of Canada pointed out in his November 2016 report that the higher the premium for legal cannabis over the illicit price, the more Canadians will purchase cannabis on the illicit market. Using the same research, the C.D. Howe Institute estimates that with a relatively modest dollar premium per gram, would result in about 35% of the market remaining unregulated. There's also the question of branding and advertising. Licensed producers need to be able to differentiate from and compete with the black market. Indeed, if governments are serious about undermining the black market and want to do it as quickly as possible, they need to ensure that legal businesses have the opportunity to distinguish their products from the illegal. Moreover, consumers need information from a knowledgeable and experienced source about an unfamiliar product to help them to have a safe and consistent experience. There are a wide variety of cannabis strains with different potencies and effects according to their THC and CBD levels. The THC is the hallucinogenic part of it. You can have it very, very low, like 0.0, as we were just mentioning before, 0.01 or 5. And also CBD, it can be mainly CBD levels as well. Characteristics, the odor, the product form. For instance, now we have not only the dried flower, we have also we vaporize it. We also have oil, and we have capsules. We're trying to find different product forms to help people ingest the product in a different format than smoking. It is important that the legal industry be able to properly communicate the features of each one to inform both consumer choice and safe and responsible use to reduce potential harm. And you'll also be aware that there's ample confusion in the marketplace about the legality of different sources of cannabis. Canadians need to be able to easily distinguish between what is a legal product and what is not. They need to know where, how, and from whom to get legal, safe cannabis. Branding and advertising within agreed-upon parameters, for example, no targeting of children or youth, provide consumers with the signposting that they need to distinguish legitimate products and sources. So adult Canadians better understand where they can go purchase their product in a safe and the highest quality. It would be unfortunate if Canadians continue to be exposed to messaging from illegal sources and silence from legal businesses. Without the ability to brand and advertise, the burgeoning legal industry will be handicapped in its efforts to dislodge well-entrenched black market. Cannabis Canada Association hopes that the Health Committee will champion the need for responsible and strictly regulated branding and advertising of cannabis to adults. Finally, given our mandate and commitment to Canadian patients, we would ask that the committee also lend its support to the preservation of the current medical cannabis system. With the advent of legalization, policymakers need to ensure continued proper access for patients. As ruled by Canadian courts, without a medical system, Canadian patients may lose insurance coverage, public or private, making their prescribed medication inaccessible. Important distinctions between medical and non-medical use of cannabis include medical use continues to be overseen and prescribed by healthcare professionals. Healthcare insurance plans can continue to include medical cannabis in coverage. Patients, including young patients, have access to the strain, potency, amount, that manages their symptoms as per their physician's prescriptions. Patients can access their medication in specified public places in all non-smoked forms, including vaping. Medical cannabis is affordable, zero-rated for taxation, accepted by drug formularies and public and private insurance. In conclusion, Bill C-45 seeks to prevent young persons from accessing cannabis to protect public health and public safety by establishing strict product safety and product quality requirements, and to deter criminal activity by imposing serious criminal penalties for those operating outside the legal framework. Cannabis Canada fully supports these objectives. Cannabis Canada has unparalleled expertise and practical experience in how to distribute safe, quality-controlled cannabis and ensure that only those who are eligible to access it do access it. In the interest of advancing the government's objectives and dislodging the well-entrenched black market as rapidly as possible, Cannabis Canada Association respectfully recommends Bill C-45 take into account the need to ensure that the legal industry is in a position to compete with the black market in terms of price, that a certain amount of branding and advertising within strictly regulated parameters is allowed, both in terms of the need to differentiate legal products and sellers from black market products and sellers, and to guide Canadians in their use of a new and unfamiliar product, and that the current medical cannabis system is preserved, or at least that necessary protections for patients are put in place, including the right to vape their medication. We want to continue and assist the governments both federally, provincially, and continue to protect the public safety and to protect our patients. We are committed to helping the governments for the distribution or for the regulations, et cetera, and we will continue to work very hard alongside you, and we do not want to lose your trust. Thank you.
And thank you. Now we'll start our questioning. We have a first round of 7 minutes, and we have questioning in French and English. So if you're not bilingual, you might want to put on an earphone and switch your speaker to French. So we're going to start off with Mr. Ayoub.
Thank you, Mr. President, Mr. Chair. Bonjour à tous. Merci de votre.
Good afternoon, everyone, and thank you for being here. 7 minutes isn't a lot to ask all of the questions that I have, so I'll be focusing on some aspects. Now, when you have a panel like the one before us today, I see that there's a great deal of expertise, social conscience, and also different approaches. I'd like to start with a question for Mr. Tosorowski with respect to the approach that is underway in Saskatchewan. Now, you talked about not putting on your dancing shoes. You talked about a bit going against the flow. Now, that's not the approach of the other panel members. They are looking into what to do and how to collaborate as much as they can to achieve a situation where we can legislate and enact legislation that will be safe for all of our fellow citizens. I greatly appreciate your remark at the outset, especially with respect to public education and awareness, because you talk about young people, about an increase in use of cannabis. Now, I'd like to understand what you're doing, what you've done, and why did you wait so long, in fact, to consult residents and to not come up with some concrete solutions earlier? Because, as we all know, this legislation isn't new. It's been under consideration and on the table for a couple of years now. Now there is a date, to July 1st, 2018. But there are ways that can prepare. So I'd like to hear from you why these steps weren't taken ahead of time, and what are the stumbling blocks that you continue to face or that will, in fact, prevent you from meeting the date of July 1st, 2018?
Well, let me begin by saying that I had a little trouble with the 10-minute limit that I had to begin with. So I appreciate your 7-minute concern. It's hard to engage your people until you know what you're talking about, and until the different responsibilities were set out in the legislation in April. I don't think any province was in a position to move forward with any kind of public engagement. Having said that, in my own province, we've had some changes at the top in terms of our provincial leadership, and we were unable to proceed with any public consultation until given permission to do so. And over and above that, we also had a by-election that was smack dab in the middle of all of that, and it wasn't until the day after the by-election that we were able to proceed publicly with our survey. Having said that, we are doing our darndest to catch up. We've had a series of task groups and working groups working very diligently over the last number of months, certainly predating the introduction of the legislation. But the list of what we have to do is just vast, and it's a mammoth undertaking. And our province isn't alone in the issues that we have to address. Each province and territory is addressing the same issue, and we are doing our best to meet the deadline.
Merci pour la réponse. Je souhaite en tout cas que vous puissiez atteindre.
Well, thank you for the answer, and I hope that you will be able to meet your objectives as other provinces appear to be able to do. Now, from the medical perspective and the supply of medical cannabis and recreational cannabis, I'd like to hear you, perhaps Mr. Lucas, Mr. St. Louis, Madam, comment on where these products should be obtained, the medical cannabis. If it can be found in two separate places, would that be a solution to address the issues surrounding branding and quality when it comes to the taxation system? Because Mr. Lucas is talking about having a zero tax rate on medicinal cannabis, but a tax on the recreational cannabis. So what type of solutions would you see there? Would the products be sold in two separate places, or what would your solutions be?
Je crois que c'est une partie de la.
Well, I think that would be part of the solution, in fact. I think that for medical distribution is something that's done using e-commerce. And there's no doubt that it'll end up in pharmacies and drugstores, and I think that that's perfectly appropriate. Not necessarily the buds or the cannabis flowers, but extracts like capsules and oils. So I think that would be well placed in pharmacies, where there are distributors who would be educated on the specific use of medicinal cannabis. So we agree with that, and I have no doubt that that's the way it's going. With respect to recreational cannabis, clearly that will separate the markets. However, we need to have more than just a location, if you will, to describe it.
Right now, if we did a comparison of the beer industry right now, let's say we had a beer industry that only allowed white labeling of beer, and so the label would only say the alcohol level, and that would be in. I wouldn't presume to know what the members of this committee like to drink, but if you're someone who favors a smaller batch brewer or a higher quality beer, there'd be absolutely zero incentive for that brewery to continue making high quality product, because everything would become Old Milwaukee. And the reason it would become Old Milwaukee is because there'd be no reason for anyone to focus on quality if there'd be no way to differentiate the quality of one product from another. And so I think it's so important that we realize that if we want to support smaller growers, if we want to encourage quality products to be produced out there for Canadians, then we need to be able to allow some limited branding to adults in order to encourage those distributors, those producers, to focus on a quality product. If it's purely white labeled, people are going to be growing fields of very low-quality cannabis, and that's all that's going to be available to Canadians in the coming months. Merci beaucoup.
Ms. Gladue.
Thank you, Chair, and thank you to all of our witnesses that are here today. Mr. Tesarowski, I agreed with many of your comments about how rushed this legislation has been, and certainly, I mean, I know that Canadians knew that the federal government had this as a campaign promise, but I think they would have expected the federal government to say how it should be implemented and to fund it. So I took your comments there well. But when I think about testimony we heard earlier today, I think it was Professor Wales that had talked about how the expectation was we were going to use the medical marijuana system because it's well quality controlled and well distributed to implement this, and so that would help address some of the timeliness. But that doesn't seem to be true when we consider that Kathleen Wynne has just said she's going to create a cannabis council and an LCBO type structure, which would be different again. Now, my problem with that is this. With the LCBO, I don't know, I'm in a rural place, so 9 to 6 are the hours, and I can't see that competing with Hell's Angels on price or availability. So I wondered, Mr. Tesarowski, if you and Ms. Rivette could comment on that.
We haven't made any final decision on a retail model yet, and that's one of the questions that we're seeking our views from our citizens in that respect. Over and above that, though, not only are hours, but availability in rural and northern communities. In a lot of those places, the only establishment in town is also the post office, it's the liquor store, it's the insurance seller, it's the drugstore, it's the grocery store, it's the place where you go to buy the parts for your car. So it's a real challenge to be able to address that kind of market and still avoid the illegal market.
I think on that, if I may, and thank you for the question, the Cannabis Canada's primary goal in addressing you here today is to make ourselves available to solve some of these challenges. So the group of licensed producers that we at the table represent, or the majority of the ones in the country, have served over 200,000 Canadian patients in the last 4 years. Those 200,000 Canadian patients have been served with near zero diversion. They have been served in rural areas across the country. Some of the companies that comprise our membership offer a 24/7 support line to help those patients. And we are already proceeding to verification beyond what would be required under an adult use model. So when we start with the adult use model, we think address verification, diversion prevention, age verification. We have those tools in place today. And we have them to verify the prescription, for example, the verification of the good standing of the doctor with their college in their respective provinces. Going to something like age verification is something we can implement today, on day one. And so where we're excited in continuing to engage with the various provinces, including, of course, Saskatchewan, is in seeing if we can provide that type of partnership. And that will take a format depending on the will of the people in those provinces. We have the tools to implement on day one, and we're looking forward to continuing that conversation.
Very good. Question I have for Mr. Lucas has to do with possession limits. I think that you said that when it comes to people that are receiving medicinal marijuana, 78% of them are using less than 3 grams a day. And so within C45, the possession limits for personal possession have been set at 30 grams, which would be 10 days of, like I would consider, a fairly serious marijuana use. What do you think of those limits? Do you think those are reasonable for personal possession, or would you like to see those reduced?
I think that that this is a fine starting point in the absence of available data on how much individuals might use. I think that this would cover a few days of use, perhaps someone who's traveling who had a particular who wanted to access product at of a certain quality out of a certain outlet. I think that 30 grams seems like a reasonable limit. I don't think that we want to encourage people to be going into cannabis stores on a daily basis in order to pick up their product any more than we would want people to pop into the beer store on a daily basis. The evidence suggests that when it comes to the recreational use of cannabis, it'll be quite different patterns of use than medical. With medical, when we're talking about chronic pain and mental health conditions, these are chronic conditions, and they usually end up seeing chronic use. And in fact, with medical cannabis patients, the survey I just shared, 74% of patients use daily. With recreational use, I would expect it to be more towards weekends, and in fact, for that use to be lower than what we're actually seeing right now with medical use. And you can actually reduce use considerably by encouraging vaporization and also the use of extracts, which are much longer lasting. So extracts and edibles would further reduce that use.
Excellent. One more question. When it comes to the bill and it's talking about being able to promote cannabis, I see a real difference between people that are engaged in the medical marijuana industry, which is growing globally. Tilray has moved into my community with a facility that exports to 5 countries. And I would think as a product, you do need to promote and brand, and to be free to do that on your webpage and in other countries. And it looks quite restrictive in C45 that would not be allowed for medical marijuana producers. I can understand why we don't want to encourage that recreationally to make it look sexy or wonderful for younger people. But could you comment on whether you think that's limiting?
Sure. We are currently limited, like all prescription drugs in Canada, in terms of our branding already. And in fact, that branding is much more restrictive than we see for alcohol and tobacco as it stands right now. No advertising. You won't see a magazine ad or otherwise promoting Tilray or any of the licensed producers in Canada. We do feel that it's important, however, for patients to be able to make informed choices, for us to be able to reach out with public health-centered campaigns and provide information, particularly for the recreational users who might be coming into this system and not know how to safely use products, whether it be the difference in, between smoking or vaporization edibles, and also being able to encourage people to stay away from smoking where possible. So I think that it's very important that we're able to get some of that messaging across. And I just want to share one concept that's very important for us to consider in this. We are talking a lot about reducing the harms of cannabis, which is absolutely appropriate because that's one of the concerns as we move towards legalization. But as an academic researcher, if you're doing research on humans, you have a joint responsibility, and they're equally responsible when you're developing a new drug or introducing a new product. You have to reduce the harms to end users, and you have to maximize the benefits. And I think that this committee has a chance to do both, not only reduce the harms associated with cannabis as it's introduced in a legalization, but reduce the impacts of course, prohibition, but also maximize the benefits of this adult access. And I shared some of the benefits in the reduction of alcohol use that we've seen in the U.S. states as well, and of course the reduction in opioid use as well. Thank you.
All right, time's up.
Okay.
Mr. Davies.
Thank you, Mr. Chair. Thank you to all of the witnesses for being here and sharing your experience with us. Madame Rivet, I'd like to start with you. You gave some, I think, very interesting testimony on the branding and advertising provisions of this bill, which are contained in Section 26. Would it be your view that the provisions as they stand now are too narrow?
So, Mr. Chairman, I'll take that one. We do need to learn more about the specific regulations that will be overlap between provincial and federal. And in terms of combating the black market, it is critical, as my colleague has raised previously, that the legal supply, licensed producers, and the legal distribution are able to differentiate between what's currently available in the black market. We often forget sometimes, and I would invite this committee to remind themselves that even walking here through Ottawa, there are multiple illegal storefronts with fully branded products, vapable, edible, basically however you want to take your illegal cannabis. You can walk in the door in any one of these stores and you can currently purchase that, and it's completely uncontrolled. So I think where this committee needs to spend a bit of time is balancing that demand to combat the black market while allowing safe, responsible advertising from the licensed producers that have been trusted partners under the medical regime.
Well, thanks for that. I think you've expressed the problem or the issue well. I've been told from many producers that as you've said, we need product differentiation, enough information, not only to distinguish the products from the illegal market, but from within the legal market, there will be different products that will be produced by different producers which have different characteristics. Then there's the need for sufficient information on the packaging so that the customer actually knows what it is they're taking and knows what it's for. And finally, as you said, to compete effectively with the illicit market where there will be no rules whatsoever on how they brand. So I'm going to turn to you, Mr. Lucas. Do you have any feelings on that? I'm looking specifically for your views on what is currently in C45 contained in Section 26, because it is a very narrow set of restrictions on the labeling and advertising right now. And again, I'd like your advice on whether you think it's too narrow.
I worry that it might be, and once again, it's with the idea of maximizing the benefits of the step that we're taking here in Canada. I understand the cautionary approach. We're the first Western nation to be moving towards this. But the evidence that we have out of the U.S., the evidence that we have out of other jurisdictions, including Portugal, that have decriminalized, evidence out of Holland that's had coffee shops for a long time, is that we keep considering this as an add-on to alcohol and tobacco, and we're using a similar lens. Should we regulate like alcohol and tobacco? I need to remind committee members that this is not either. That if we look at any of the research, not one side of the research versus another, any of the research that's looked on the public health impacts in terms of healthcare utility, in terms of public safety impacts of cannabis compared to alcohol or tobacco, let alone the illicit substances, shows it to be a much, much safer substance. That doesn't mean we should be championing its use, but it does mean that we shouldn't be disadvantaging it when it comes to access compared to alcohol or tobacco. We think that Ontario's taken some interesting first steps to start getting cannabis and be ready for July of 2018, but we're talking about 60 shops perhaps at the onset. There's over 600 outlets in Ontario where you can purchase alcohol. I'm obviously not counting every restaurant and bar also, which would put it in the tens of thousands.
I don't want to get into distribution yet. I want to stay on branding and labeling. You made a very interesting, you raised the issue of should this be regulated more like tobacco or alcohol or maybe neither. Some have advised me that they think that cannabis should be regulated in terms of advertising and labeling more like alcohol, because unlike tobacco is a uniform substance, whereas cannabis, like wine, for instance, has different characteristics. The CBD and the THC levels, particularly combined with the toluenes, make it almost, there's a panoply of different effects and types, and that this is important information both for customers to differentiate and to compete with the illicit market. So I'm reminded, like, this legislation says that you can't set out a depiction of a person, character, or animal, whether real or fictional. And I'm thinking you walk into a liquor store and you can have Wayne Gretzky Winery. And I'm thinking of the way people differentiate between wines, which is also a product that you keep away from children, that there are a lot of restrictions around what can be said on it. And I'm just wondering if that's a more appropriate analogy for us than a plain package of tobacco.
I think that you're absolutely right. What we're supportive of are bans on lifestyle branding. We don't want to celebrate cannabis use. We don't want to see anyone being depicted taking any risks, doing anything, overly athletic, etc. So that kind of lifestyle branding, we would not support at all. But we think that where adults only can congregate, such as the equivalent of liquor outlets, the equivalent of bars or consumption sites, we feel that there should be some ability to be able to speak to those adults, to be able to share messaging on different products and product effects, and that can be done through brands as well.
I want to turn a bit just to products. I'm a little bit confused in my mind. Now, in the medicinal cannabis world right now, are patients using non-smokable products in any kind of extent? Are they using creams and patches and sublingual tablets, oral sprays, capsules? Is that common? And if so,
To what extent?
Yeah. It's about 50% of patients out there in Canada right now that are using as a primary method of ingestion non-smoke methods of ingestion. So about 31% use vaporizers. That's the most common, the most popular form of use right now is vaporization. That's closely followed, though, by edibles, which makes up just under 20% as well. So edibles would be, I don't want you to picture cookies or anything. It's drops or extracts. It's oral ingestion.
Is there a danger of having two different parallel systems here? Because under C45 in the recreational world, none of those are legal.
No, they would be. I think caps and oils would be legal. They would just not be consumed in the form of edibles. So caps, extracts, oils would be legal, but not with a strong concentration. So we understand that those would be legal. They just wouldn't be mixed into a brownie, for example.
Yeah, I'm not sure that's the case yet with C45, but we'll look at that. To Mr. Tesarowski, blunt question, is Saskatchewan going to be ready by July 1? And number two, I think, Mr. Ayub, there was a suggestion, if I heard him correctly, that Saskatchewan's the only province that is expressing difficulty meeting that deadline. Are you aware of any other provinces that may struggle with the July 1, 2018 deadline?
Every province is struggling with the July 1 deadline. Some are publicly saying they're going to be ready. Everyone is saying we're going to try and be ready. And that's certainly what we're doing in Saskatchewan. It's just that it's a very long list of things to do. And
So
we wanted to get it, and we want to do it right.
Are you going to be ready?
We hope to be.
Time's up. They're not ready. Ms. Sidhu.
Okay. Mr. Tarowski, thank you for joining us today. Within this legalization, provinces, territories will have the ability to enact their own accompanying legislation with some additional restrictions if desired. Just turn all over. Earlier this year, Saskatchewan implemented a new impaired driving law across the province. Many provinces have enacted similar strict law against impaired driving, and this has resulted in the lowest rate of impaired driver across Canada since 1984. So what lesson can be applied from impaired driving legislation in order to maintain public safety once cannabis is legalized?
One of the things we've tried to do in Saskatchewan is to treat alcohol and drugs exactly the same. For example, we have zero tolerance for new or drivers in the graduated licensing program. So if you have any alcohol in your system, there's going to be a consequence. If you have any drug in your system, no matter what the drug, there's going to be a consequence. So we're trying to follow what we know and to apply it to this new situation as much as possible.
Thank you. My next question is for the medical cannabis industry representative here today. Some people have voiced concerns that legalizing recreational cannabis will result in the reduction of available medical cannabis. Others have said that allowing more producers will be benefit for medical users. What benefits or medical users do you see coming from this legislation?
Well, I think the first benefit, hopefully, and we've heard some messaging from the federal government, this will give an opportunity to reconsider the taxation of medical cannabis. And right now, medical cannabis patients pay provincial tax as well as federal tax. And we feel that that's inconsistent with the current use of medicines in Canada. So that'd be the first benefit. I think the second benefit is going to be a destigmatization. We feel that the legalization of recreational use of cannabis will actually allow the medical community to consider the medical use more fully and more comprehensively. And the quicker we can get it in the pharmacies, the more normalized the use of medical cannabis will seem. So we actually think that these steps forward to legalize recreational adult use will help in the normalization or destigmatization of medical cannabis as well. And also we're seeing a lot of funding going into studying recreational use right now that I think will be beneficial in terms of looking at long-term patterns of use for medical cannabis as well. We heard from Dr. Ware today about some of the research he's hoping to do. I'm involved in a number of research projects, clinical trials on PTSD and examinations on cannabis as substitution for opioids. And I think that that research will help us better understand, once again, the potential harms associated with cannabis, but also the potential benefits of legalizing adult recreational use.
Oh, thank you.
Thank you.
Following task force recommendation, the government will maintain the medical cannabis regime for people who have authorization from the medical professionals. The task force also recommended that this be reviewed in 5 years of new law, which the government intend to do. How will medical patient benefit by maintaining separate access for their use?
Well, I think that there are certain types and preparations of cannabis, and we've heard from our friend Mr. Jones about the benefits of high CBD cannabis strains. CBD is non-impairing. It's not something that we would expect recreational users to typically be seeking out. If you've heard about the medical use of cannabis in the treatment of pediatric epilepsy, those are all high CBD preparations, and in fact, Tilray, my employer, is involved in a clinical trial at Sick Kids looking at high CBD extract products as a treatment for pediatric epilepsy. So those products, without maintaining a strong and robust medical cannabis program, will likely disappear from the recreational program because they're simply not impairing. They won't get you high. So there'll be not a lot of motivation for that production of those. So protecting products like that, as well as the use of capsules, orally ingested products, in order to discourage the smoking of cannabis, I think is going to be a very important part of what we can expect in the medical system. I do want to also suggest that you asked a very important question. Will patients still be able to access medical cannabis when recreation comes around? And there's certainly some companies that are clearly hedging their bets more on recreational cannabis and that are advertising or marketing themselves even today as more as recreational cannabis companies. But there are those of us who are determined and focused on the medical cannabis patient, putting money and research into medical cannabis. And we'll continue to try and meet the needs of patients across Canada as best as possible through legalization into the future.
Thank you. Mr. Rich, you said Canadians need more guidance from legal source. What kind of guidance Canadians need to be given in regards to product form and production so they can be differentiated from black market and legal and illegal products?
There needs to be a knowledge about the product itself, and currently the ones that have the most experience and expertise are the licensed producers from Health Canada. They also are working very ardently in trying to find different product forms to be able to get people not to smoke the cannabis, as well as there are information that you need to know. Like, for instance, if you're vaporizing, you will feel the onset much quicker. It won't last as long. However, if you're using an oil, it will take a long time. So don't go and within 2 hours keep taking oil, and then you're going to have quite a bit of product in your system. So all of these things have got to be explained. Also, every person, every individual reacts differently to the medical cannabis, to the cannabis. So again, all of that has to be explained to make sure it's a good experience that they receive, and that they do not go back to the black market, where the black market cannabis could be very well and is usually contaminated, and it's very dangerous for people to be using that.
Time is up, Mr. Chair.
We still have another little bit.
Okay. And could you please expand on the quality insurance measure the industry has in place to protect Canadians?
Of course. Maybe Sebastian, you could answer.
So we've seen our quality across industry, and this is not an industry that has been without faux pas. The licensed producers have had quality issues stemming from contamination around pesticides. What's more important to focus on is that we've been able to issue next-day recalls cross-country. We've been able to protect consumers. We've been able to communicate with those consumers and fix those process gaps which led to the contamination events. So as we keep moving forward, I think what we've seen in the industry is a system that works, that is beginning to work, and of course, from any of the people involved, of the stakeholders, no one at the licensed producers wants to see pesticide or contamination events. We don't want to have quality issues. However, as we grow up in a very fast industry, these are things that have happened because of poor processes, and we have proof now that this system works. So this is something we need to roll out in the future, which Bill C-45 contemplates to continue having that good, robust quality control that we've implemented on the medical side.
Okay, time's up, but Mr. Lucas, you have a comment?
I just wanted to add to that, to be very specific. We do testing on biological impurities, yeast and molds, heavy metal concentrations as well. Pesticide testing is also mandatory as well. And so I can say with some tremendous confidence that the international community right now looks to Canada as the safest, most consistent supply of research as well as medical grade cannabis anywhere in the world. We're currently providing cannabis through the Special Access Program for pediatric patients in Australia, for clinical trials in Australia on cancer-induced nausea and vomiting. We're distributing cannabis extract capsules in Croatia. A number of companies in Canada are exporting to Germany right now within their strict and very medicalized system. So we are really truly an example for the world in terms of the highest possible quality product. And a number of our members, not just of CMCC, but also of Cannabis Canada, are now GMP certified, which stands for Good Manufacturing Practices. That's the same high level of quality being used to manufacture pharmaceuticals all around the world. It's an international standard that supersedes the GPP regulations that we're governed in here in Canada. So I have great confidence in the safety and security and quality of that supply.
Okay, thanks very much. And that completes our 7-minute rounds. Now we'll go to 5-minute rounds, starting with Dr. Carey.
Thank you very much, Mr. Chair, and I want to thank the witnesses for being here because I think at the end of the day, we really want to focus on the health and safety of Canadians, and for me, particularly our kids. I don't think there's a lot of argument out there about medical marijuana and adult, responsibility. But I look back at the Prime Minister's rationale for doing this, and I asked witnesses today, it keeps coming out, he keeps repeating the status quo is not working. And I really want to thank witnesses this afternoon. I think it was you, Mr. Lucas, who quoted some well-available statistics that has shown it's trending down, and depending on which ones you want to quote, as high as 50% of boys in 2002, I believe, to down to 22% today. So the Prime Minister's rationale saying the status quo doesn't work, I find it quite interesting that Ms. McClellan, who's a former Liberal cabinet minister, was almost giddy here today saying, well, we got a letter from Colorado saying that it hasn't gone up. Well, guess what? Legalization in Colorado hasn't shown to decrease child or the use of cannabis with kids. So I think this is really important that we dig into this a little bit more and also dig into the provincial jurisdiction. And I found it a little bit rich that the federal Liberals were criticizing the provinces on this because there's so much science that still isn't known. So much of the heavy lifting is with the provinces and territories. So I want to take this opportunity to thank Saskatchewan for actually showing up here today. We've invited other provinces and territories. I think you're the only one that's shown up. I know my own province of Ontario just passed a little preliminary thing. They don't even want to show up here and answer some questions on it. So with you taking all the heavy lifting, I was wondering, can you go over some of the concerns that you may have with controversial things like home cultivation and legal age of possession as well? If you could just mention, you mentioned in your opening the drug levels and the levels in blood and how controversial it is. Are we going to be seeing a lot of court challenges on these things as far as enforcement?
Absolutely. If anything, impaired driving is a testament to how creative the criminal defense bar can be. There are going to be challenges coming out of the yin-yang with respect to most of this, and the better we can prepare for that, the better we'll be able to answer it. And one of my mantras when I deal with my federal colleagues is clear evidence of parliamentary intent. If we can establish clear reasons why Parliament is moving in a certain direction, let's put that on the record. Let's do that at committee. Let's do that in speeches in the House and in the Senate and in the Senate committees, and let's be clear about what we're doing and why we're doing it. And that will assist later on when we have to address charter challenges.
I think intent, like I said, the Prime Minister's been clear the rationale is the status quo is not working, and particularly for our kids, but the evidence suggests something opposite, and even the early results from Colorado show the exact opposite. So one of the things I hear in Oshawa is this whole thing about home cultivation. And can you please comment on, number one, how are you going to enforce this? How much is it going to cost? How is that going to make it so that kids have less access to marijuana?
Well, in fact, that was one of the questions I was asking you people. I met with the chief of the Weyburn Police Service last week, who's the president of the Saskatchewan Association of Chiefs of Police, and that's one of the association's fundamental concerns is how are we going to enforce this? And as I said in my comments, especially if it's out of view or inside a residence, it's only going to be by happenstance that we come across an individual who's cultivating. There's no requirement that they be registered. For example, I don't think a province would be very interested in requiring registration. What we can do is assist landlords and condo associations in dealing with the health risks that are associated with cultivation and things. But from an enforcement point of view, it's a very large concern. How much that would cost, I have no idea. But if you really sort of can't pierce that veil, there's nothing you can do, so there's not much of a cost.
Have you had any conversations like within this legislation? The youth is like 12 to 18. In other words, can have up to
17
or 17, or up to age 18, up to 5 grams. And we've heard quite clearly 5 grams, that could be 10 to 15 joints. And I'm thinking a 12-year-old, that's grade 6. This is the top of the hierarchy. These are the old kids in public school. Have you had any conversations with educational professionals or police on how will you handle that? And do you think there's a possibility for diversion from 12-year-olds to 10-year-olds to 8-year-olds? Because a lot of these younger kids look up to the older kids.
You ask very good questions, Doctor. It's a real concern amongst our educators. But we have to keep in mind that we already have drug problems in our schools. And one of the purposes behind this legislation is to mitigate that or restrict it as much as possible. It may very well be that a province has to establish some kind of provincial scheme to address some of these issues and to change the limits so that we can better address those situations.
Ken says quite clearly. Oh,
Mr. Oliver.
Thank you, and thank you very much for your testimony. I just wanted to, there's been some suggestion that the use of cannabis is on the decline in Canada. The Canadian Tobacco, Alcohol and Drugs 2015 summary, which is the most recent one, found that the prevalence of past year cannabis use was 12% in 2015, which was an increase of 1% over 2013. And while it hasn't changed in males, there's been a significant increase in cannabis use from women from 7% to 10%. So I guess I come back to, we kind of, we're sort of referencing this, that there's already a problem with the youth, and I assume with prevalent rates of 21% of youth reported using cannabis and 30% of young adults, that those are typically Saskatchewan numbers as well. So in your identification of problems in Saskatchewan, one of them was the cost of detecting impaired driving from drug use, and the cost of that, and the training required, and the equipment that you needed. But I would have to assume that with a pretty steady state in marijuana use, cannabis use, that you've already got those problem drivers on the road. So without this legislation, was nothing going to happen, or would you not have had to move forward in Saskatchewan as others are? I have a second question. I'll ask it now and then let you respond. The second thing, we heard this morning that if a province or territory wasn't ready, that the legislation does envision an e-commerce model where people could buy cannabis from registered licensed producers, and they could have it delivered by Canada Post, sort of what the current model that's there for medical marijuana, I think. So what would Saskatchewan's reaction be to that, where if you were unable to deliver legislation, then people in Saskatchewan would still be able to procure it just through a model that's not under your control? And for the hard, like for the poorer communities, the more outreach communities, like where it's going to be very hard to get distribution, I mean, they're going to need some kind of e-commerce model as well. You can't have a store in every hamlet. So those are my two questions, I guess, for Saskatchewan.
I'll address the second one first.
Okay.
because it's the easiest one. An online mail order type of process might very well be part of our response. It's certainly a process that works relatively effectively for medical marijuana users. Interestingly, one of the concerns that's been expressed to us has been that for a medical marijuana user in a senior's home, for example, gets the courier coming to the door. Well, everyone knows why they're there. And one of their preferences might be to have a less anonymous approach and have the ability to maybe go down to the pharmacy, for example, and pick up their product, or have the drugstore delivered, because that's a more normal kind of process. But it may very well be part of our retail solution. The first question with respect to problem drivers, let me say first that this is all very, very new. That roadside detection for impaired drivers from an instrument perspective or a machine perspective is very much in its infancy in Canada. And it's something that we likely would have gone down the road for anyway. But when you exacerbate a problem by making it legal, then it just makes it worse.
Thank you for that. I think we might have heard testimony, I'll have to go back and check my notes, that other than sort of an initial bump, that it doesn't typically change usage rates. So the problem you had is the problem you will have, I think, if that's how I heard the testimony. I had a question for the hemp producers. So is there a reason why, it sounds like a pretty easy request, you have a non-THC, a plant that doesn't have THC in it. Were you given a reason why that wasn't included in Schedule 2? Like, that sounded like a pretty logical thing to have done.
Thanks for the question. As we understand the history of the industrial hemp regulation, there was precautionary principle applied to keep hemp within the CDSA schedule, just until there could be enough learning about why.
Transitional issue for you then?
It seems to have been, and we've had some dialogue with Health Canada about it. The issue is...
I have one more question I want to ask, so thank you for that. I just want to be sure it wasn't a flat no, and if there was a valid reason for the flat no. So it's that there is a lot of transitional issues here, and we've heard we need to be careful. Last question, Philip. So I think I heard in your testimony that I've heard that one of the biggest complaints or concerns that's in my writing that I've heard, not that I've heard a lot, but is that this is a gateway, and that cannabis is a gateway to harder drugs. But I think I heard you say that actually it's an exit strategy from harder addictions and more difficult drugs. Could you just elaborate on that a bit?
That's correct. No one on this committee would dare say that cannabis is completely without harms, so to be clear. But the level of certainly dependence on cannabis and the severity of that dependence is limited to about 9% of the population that use it on a regular basis, and the severity is much less than you would see in terms of dependence levels with tobacco, alcohol, or otherwise. More and more research is starting to suggest that not only is it not a gateway drug, that's been disproven over the last 20 years, it's not a stepping stone drug, but that for many it can be an exit drug to problematic substance use. In some cases, it's very conscious. We have doctors prescribing cannabis deliberately for the treatment of chronic pain to deliberately reduce the use of opioids by patients. But in other cases, it's completely subconscious, like we're seeing in Colorado right now, the only state in the U.S. where you didn't see an increase in beer consumption last year because of legalization efforts. So it happens at the population level. And just to clarify, because I heard earlier some information, I just want to clarify. In Colorado, there is research suggesting that youth use has gone down. It's moderate, it's about 12%, but it has gone down. And I also wanted to mention, because you mentioned women increasing the use of cannabis, we are actually seeing women and seniors being the largest group right now coming into the medical cannabis program. And that alone may account for the statistical bump that we're seeing in terms of women using cannabis as well. As you've suggested earlier, we might see initially on legalization a 2 to 4% increase initially that'll flatline once again and go back to regular use. What you'll typically see is that those who are using will continue to use, but right now the law is not dissuading a lot of use, and that's one of the challenges when we talk about youth right now. The law is not controlling black market distribution to children. If I could add just one more thing, I'm a former high school teacher. I once asked a grade 11 class, what drugs can you access in the next 24 hours? And they listed off LSD, and they listed off mushrooms, and they certainly listed off cannabis. And the two toughest drugs for them to access in a 24-hour period were alcohol and tobacco. Now, I'm not so old that I don't recall ways that we circumvented that, even those regulations. But once you take cannabis out of the black market, once you take a drug out of the black market, you put in age restrictions and ID and take the power of the black market away from distributing that drug, you can really impact rates of use. And so I think that we can expect, actually, those youth rates to actually go down post-legalization, despite the fact that it may seem counterintuitive in many ways.
Thank you. Ms. Glad?
Yes, point of order, Mr. Chair. Just wanted to correct the record. The places that have implemented legalized marijuana, like Colorado, have seen a 32% increase in impaired drug driving. So I just didn't want you to be left with the impression that there wasn't an increase.
That's not a point of order, but you have the floor.
Oh, no, it's his turn.
Oh, Mr. Webb?
My turn.
Okay.
And I get a full 5 minutes, correct?
Correct.
Okay. Quick clarification. Mr. Jones, Mr. Ray, in the hemp industry, you're here today to lobby that, of course, hemp is exempt from this legislation. You're concerned that the bill doesn't differentiate between hemp and marijuana, and I'm trying to do a little bit of trying to differentiate that as well. I understand that hemp does not have the THC content that marijuana does, but it is, in fact, a marijuana plant that has been breeded to a strain of non-THC, but it is a marijuana plant, correct?
The basis of the plant, the species of the plant is Cannabis sativa. That's the plant species. Okay. But hemp has been created by plant breeders breeding out the THC content. And so so it's the same species, but it's a fundamentally different product.
High in CBDs as well.
Yes.
Okay, which is a good thing for medicinal use, although it's used mainly in food products. Is there an actual prescribed medical hemp pill out there for people who are seeking it, like people with schizophrenia, people with these pediatric issues?
I just want to differentiate. I'm sure that Mr. Jones would agree with this. There's a difference between hemp oil, which you can buy to the store right now, which is a great health supplement filled with antioxidants, omega-3, 6, 9, and CBD oil, which is actually made from the flower, the trichomes on the flower. The first one, the hemp oil, is made by pressing of seed, and the other is made from the trichomes or cannabinoids in the flower. Now, hemp does contain, some hemp does, has higher CBD content, and certainly could be used in the production of CBD medications, as it is in the U.S. and in Europe as well.
Okay. Now, the hemp industry, is it as tightly regulated as the marijuana licensed producers? Do you have the security issues that you have to deal with and such? And you mentioned that the buds and the leaves, you cannot harvest that at all?
Right.
You have to incinerate them and
right.
That?
We have to apply for a license every year as a licensed cultivator of hemp, as do all the farmers who grow hemp, as well as do all the processors that we can sell to. So we can't sell our hemp seed or our hemp grain except to processors or buyers who also have a Health Canada license. So we apply every year for a Health Canada license. Today, under the industrial hemp regulation, we cannot collect the buds or the trichomes or the leaf bracts or the flowers of the hemp plant, because they are what tend to contain a higher level of any cannabinoids, whether it's THC or CBD. The challenge that's created is we're already producing a lot of CBD on our farm. We actually have phytosanitary standards, plus as a certified organic producer, we have a number of inspections, certifications, and we have to adhere to a number of standards and processes. The hemp crop we grew on our farm this year produced likely in the area of 10,000 kilograms of CBD, but we had to spread it on the ground as chaff. We're prohibited under the industrial hemp regulation from harvesting the portion of the hemp plant that contains the CBD.
Interesting. Very quick question to Ms. Brevet and Mr. St. Louis. You mentioned that pricing, we have to be low in pricing in order to compete in the black market. I just can't see that happening with all the regulations that are in place right now with licensed producers and the costs involved with that. The only way I can see you bringing those prices down is to have some type of government subsidization in order to compete with the black market. Would you not agree?
Not entirely. So in terms of costing, we've already seen a huge decline in existing licensed producers' cost to produce. So when we started about 4 years ago, the lowest price posted in the industry was about $2.55. Currently, you have the lowest price posted in the industry at $1.17 per gram. And this is in terms of cost, which does include quality control costs, which are part of the regulatory regime. However, you do touch on a point I do agree with, that there could be a second look over time with our hardworking regulators at loosening some of the regulation. For example, camera and video footage requirements, that on a single site a licensed producer can have upwards of 500 cameras, etc. So there are some low-hanging fruit that I think we could look at, while always keeping, of course, public safety and diversion as a top priority. But we will be able to get sub $1 cost per gram over the next little while as an industry. And of course, as we talk about the benefits to the medical community as well, a larger, more robust industry, which includes both medical and adult use market, will see us at much larger scale, which you get some nice economies there as well.
Mr. McKinnon.
Thank you, Chair. My first question is for Mr. Jones. So hemp is cannabis sativa. It's the same genus, species. How do we tell it apart from the stuff that's producing all the fun and games for everybody?
So Health Canada has done a lot of work over the last 19 years since the industrial hemp regulation was put in place, including annual inspections of every field. As a licensed producer, we've actually submit every year up until this year, actually, samples from our fields to confirm that the plant we're growing is in fact a hemp plant and not a marijuana plant, and to confirm that the variety we're using, which is on the list of approved cultivars, is actually what we're growing. So that we grow a variety called Finola, which happens to be on the list of approved cultivars that Health Canada has done the work and confirms consistently contains no more than 0.3% THC. So Health Canada has already done the work to actually create the definition that differentiates between industrial hemp as authorized under the industrial hemp regulation and other forms of cannabis which may have higher levels of THC.
Is this a distinction that can be made by lay people? Do you have to be a botanist to be able to tell the difference?
If you physically look at the plant, you can't tell. By looking at the plant, you can't tell. It's the same species, but the breeding has been fundamentally different. So the visual distinguishing characteristics of the physical plant, you couldn't tell the difference. You couldn't tell them apart.
So if we had a field of hemp blowing in the breeze, we can't tell if it's hemp or marijuana, correct?
Yeah.
Okay.
Sorry, Robin?
Well, there's a very big distinction between the two in that a field of marijuana would only be female plants. If you have any male plants in a marijuana crop, you're not going to have a very good crop. So it's counterproductive to try to do that. The other point I just want to make is that when the industrial hemp regulations were first created back in 1998, there were some concerns because of the flowers and the buds. They tend to have higher THC levels. The plants nowadays have a lower threshold than what is required for the entire plant. So this point that Keith just made about having to throw the CBDs out in the ground is quite a waste under the circumstances, because the whole plant is safe to use.
So would adding hemp to Schedule 2 not take it out of the licensing regime as well?
as we understand it, it would remain under the industrial hemp regulation. And so the industry would continue to operate within the paradigm of the industrial hemp regulation, which we support.
But I believe this legislation is going to replace that legislation, the industrial hemp legislation, is it not? I believe.
I don't think so. I think the industrial hemp regulations are mentioned in the bill.
Well, I'll have to check on that. Thank you. I'm going to move on to Mr. Lucas. So there's a lot of talk about access to medical marijuana or medical cannabis versus access to recreational cannabis. It's as if they're two different things. So are they really two different things, or are we talking about just cannabis for medical use versus cannabis for recreational use?
Well, I think it depends in the preparation. The answer is yes to both of those. They are different in that, as we've discussed, CBD would typically not be desirable from a recreational point of view. That's not why people use recreational cannabis. And in fact, the reason that we're only starting the research on CBD over the last 5 or 6 years, despite the fact it was discovered first over 40 years ago, is because there were no high CBD strains that were available in the recreational market initially. And it's only the establishment of the medical system here in Canada and in the U.S. that's motivated people to breed and to develop these high CBD strains that have become so efficacious for so many people now. So that is a distinctive characteristic in many ways of medical cannabis. Now, that's not to say that THC doesn't have therapeutic properties. It's a powerful analgesic, anti-inflammatory. It has a number of therapeutic properties in and of itself. So the same strain can be used for recreational purposes that can be used for medical purposes under some circumstances, but I think that there are quality control methods of ingestion, for example, that might be more distinguished for medical use versus recreational use. If you want a long-lasting, even effect, then oral ingestion makes the most sense for that. But for example, for someone wanting rapid onset of effect, let's say you're suffering from a migraine and you're starting to get the auras associated with migraines or the nausea associated with migraines, oral ingestion isn't going to make much sense. So vaporization in those cases, or maybe an oromucosal spray would make the most sense. There's also ongoing product development, for example, for patches that would be usable in terms of slow delivery of medicinal cannabinoids into the system as well. So a lot of the research right now being done not just by licensed producers in Canada, but by pharmaceutical companies around the world are looking to modulate the endocannabinoid system that we all have in ourselves. And that's quite different than the recreational use that we see where people are, for example, making high THC gummy bears.
Mr. Davies.
Mr. Lucas, I want to ask a question about supply. The Parliamentary Budget Officer has studied this and said that in 2018, Canadians aged 15 and over will consume an estimated 655 metric tons of cannabis. By 2021, this could rise to 734 metric tons. I'm just wondering, in terms of the present medicinal cannabis production, that's the only legal production, are we going to have enough producers licensed to meet demand legally in July 1, 2018?
I think I don't think anyone would ever tell you we're going to meet demand on July 1st, 2018. The licensed producers that are established right now, and there are 55. At this time last year, there was probably 25. So we are getting more and more folks online, are expanding rapidly, moving into greenhouses in order to increase supply. But as was discussed this morning, one of the biggest challenges that we saw in Washington State and Colorado, despite a long lead time for legalization to be in place, was a shortage of supply. We've seen the same thing in Nevada recently as well. I would expect to see some initial supply shortages and then a regulation or a flatlining happening a few months down the road as well. I think one of the bigger concerns is whether we're going to be able to incentivize people currently using the black market to move into the illicit system. And if it's taxed too high, or if access is in any way more inconvenient or less affordable than it is through the black market, then I think that we're going to have a lot of trouble convincing people who are currently buying from the illicit market to move into the illicit market. And that's part of the task, I think, and responsibilities of this group and of the current government to make sure that accessibility is not an obstacle to access.
I was going
Is there a risk that we could divert medicinal cannabis so that medicinal cannabis users are not getting access?
I think that's ultimately up to the individual companies who are moving towards medical and recreational. The company that I work for, Tilray, will remain a medical brand. We're not going to have a recreational brand at all under Tilray's heading.
Thank you.
Thanks.
Mr. Tezarowski, a couple things. In the task force final report, it recommended that the federal government work with provincial and territorial governments to determine a tax regime that includes equitable distribution of revenues. Have any discussions or agreements been reached, as so far as you know, with Saskatchewan?
Those discussions are ongoing.
Okay.
They've been ongoing for some time, as I understand, and will continue until they come to a conclusion.
Okay. And I had a question about the Constitution. The way I understand it, C-45 will require all producers to apply to the federal government for a license. Now, we know with beer, I come from British Columbia, there's a lot of small craft producers. I believe they're regulated provincially. Are there any constitutional considerations? Let's say you have a local Saskatchewan producer that just wants to grow and sell in Saskatchewan. Do you see any constitutional challenge there in terms of a usurpation of provincial a jurisdiction over property and civil rights? Has that been discussed or thought of?
Gosh, that's a good question. It's one that we have toyed with, but aren't looking at, given the time frame that we have.
Okay. And one final question, if I can quickly. Again, the task force recommended that the federal government conduct the necessary economic analysis to establish an approach to tax and price that balances health protection with reducing illicit market. Has the federal government shared that economic analysis with the province of Saskatchewan?
I'm not in a position to answer that. That's something that they're having discussions with our finance people about.
Okay.
And they don't always share.
That's it. Oh, sorry.
Thank you, sir.
That's it. Well, thank you very much for the panel. I appreciate your input and your contribution to our study. We're continuing to learn as we go, and but you've been very helpful. So with that, we are going to suspend until 20 minutes, or we'll be back at 4 o'clock for our next panel. o'clock, I call the meeting to order for our meeting number 64 of the Standing Committee on Health. I welcome our new panel. And on this panel, we have from Canada Border Services, we have Jennifer Lutfala, Director General, Enforcement Intelligence. Thank you very much. We have the Canadian Medical Association, Dr. Laurent Marcoux, President, and Dr. Jeff Blackmer, Vice President, Medical Professionalism. And from the Department of Public Safety and Emergency Service, we have Trevor Boopsing, Director General, Law Enforcement and Border Strategies. And by video conference, we have, on behalf of the Vancouver Police Department, Martin Bruce, Inspector, Organized Crime Section, and Bill Speem, Staff Sergeant, Organized Crime Section as well. So I understand that Canada Border Services is not making an open statement. Is that opening statement? So we'll go right to Canadian Medical Association for 10 minutes. Dr. Marcoux, the floor is yours.
Merci, Monsieur le Président.
Well, thank you very much, Mr. Chairman. My name is Dr. Laurent Marcoux, and I'm very pleased to be here in my role as President of the Canadian Medical Association. I'm joined by Dr. Jeff Blackmer, as you said, who is Vice President of Medical Professionalism at the CMA. As a national organization representing over 85,000 physicians and physicians in training, the CMA has long been concerned about the health risks of cannabis, especially when smoked. These include cardiovascular, pulmonary, and mental illnesses, then the motor vehicles accidents, and, of course, addiction. In legalizing cannabis for recreational purposes, the federal government needs to exercise caution. It must establish public health objectives and be accountable for them. It must focus on protecting Canadians and reducing harm. The CMA is therefore recommending a broad public health approach, which would focus on 1. Preventing problematic drug use, 2. Ensuring access to treatment services for those who wish to stop using, and 3. Increasing the safety for those who are using them through harm reduction. The goal of this approach is to decrease the negative health, social, and economic consequences of drug use for the individual, the community, and society as a whole. Children and youth are especially at risk of harm, given their brain's development. And they are among the highest users of cannabis in Canada. To better protect this part of the population, we're recommending that the legal age of legalization be set at 21 years. The quantities and the potency of cannabis should also be more restricted to those under the age of 25. Despite these increased risks, however, evidence shows that youth today don't believe cannabis has serious health effects. A comprehensive public health strategy for cannabis must, therefore, include education, similar to what's been done with tobacco.
Should be implemented before and no later than the enactment of any legislation in order to increase awareness of the harms and to conduct further research on its impact. The CMA urges the government to support the widespread dissemination of a lower-risk cannabis use guidelines, incorporating its messages into educational strategies. Once legislation is in effect, cannabis will be available for those who wish to use it for health issues, either with or without medical authorization. We are therefore recommending only one regime for both medical and non-medical use. However, this regime will need to ensure access for those unable to acquire cannabis legally, for example, those below the minimum age. If the government does decide to maintain two separate systems, we recommend that the legislation be reviewed within 5 years to assess, for example, the number of users in the medical system, and the number of physicians authorizing medical cannabis use. Cannabis use has significant health risks, and we continue to call for more research into its effect. Legalizing won't change the risk. The government's focus should therefore be first and foremost on protecting Canadians, especially the young, and reducing harm to health. Thank you, and I'd be happy to answer any question you may have.
Thank you very much. Now we'll go to the Department of Public Safety and Emergency Preparedness. Mr. Bupsing.
Good afternoon, Chair, committee members. Thank you for the opportunity to speak to you from a law enforcement and public safety perspective regarding Bill C-45. Again, my name is Trevor Bupsing. I'm the Director General of Law Enforcement and Border Strategies at Public Safety Canada. And again, I'd just like to briefly introduce my colleague, Jennifer Letfalla, who's the Director General for Enforcement and Intelligence Programs at the Canada Border Services Agency. Ma collègue et moi sommes ici aujourd'hui.
My colleague and I are here today to answer your questions about our respective organizations' roles in relation to Bill C-45.
Une approche.
The government has taken a balanced approach to the cannabis legalization and regulation. And we have focused on ensuring the necessary law enforcement and public safety dimensions are incorporated into the legislation and are informing the development of the regime that will be put in place to regulate cannabis.
45 reflects the collaborative work that has been accomplished by Health Canada, the Department of Justice, Public Safety, the Royal Canadian Mounted Police, and the Canada Border Services Agency, along with provincial and territorial governments and law enforcement stakeholders. Public Safety Canada has taken a leadership role in working with law enforcement from across the country and with our international partners to ensure that the legalization and the regulation of cannabis is accomplished with a public safety lens. In preparation for the Cannabis Task Force work, Public Safety held a roundtable discussion on the legalization of cannabis with law enforcement and provincial and territorial government representatives. The discussions provided clear direction on elements and perspectives that required consideration and needed to be reflected in the proposed Cannabis Act and the legalization regime. This information was provided to the task force and helped guide their consultations with law enforcement, other stakeholders, and Canadians. Law and border enforcement recognize that a legalized cannabis regime needs to protect public health and safety, particularly amongst youth. In this regard, Public Safety Canada and its partners, such as the RCMP and the CBSA, have focused on several key objectives in the development of the bill. First, the need to keep criminals and organized crime networks from infiltrating the legal cannabis market, strengthening laws to reduce the cannabis black market, and protecting youth. Legalizing cannabis is a significant change in social norms, but what we know is that cannabis has been a very lucrative commodity for criminals, and this too needs to change. The RCMP and law enforcement across the country can attest to the fact that organized crime has been heavily involved in the illicit cannabis market and making significant profits which are used to fund illegal activities. It's been estimated that there are up to 650 organized crime or criminal organizations in Canada, and up to 50% of those have been identified as being involved in the illicit cannabis black market. It's difficult to fully anticipate how organized crime in the illicit market will react once the cannabis regime comes into effect. Organized crime involvement in any commodity or activity can change as the supply and the demand shifts and the opportunity for their profits are affected. However, much work is underway to keep cannabis profits out of the hands of organized crime. Public Safety Canada is supporting other federal departments that are leading discussions on cannabis taxation and pricing. These are important aspects to help ensure that projected revenues from the production, distribution, the sale do not flow to organized crime. As the new regime is built, requirements under the Act, such as the criminal record checks for those who want to produce cannabis, will keep criminals presently operating in the illicit cannabis market from moving into the legal regime. RCMP, federal policing, and other Canadian law enforcement will continue to work nationally and with our international partners to target organized crime and criminal networks, and Public Safety Canada will support these efforts by monitoring change in the illegal drug market. Regarding border security, the CBSA currently investigates and interdicts the unauthorized cross-border movement of cannabis at Canada's ports of entry while maintaining the free flow of legitimate travel and trade. The new legislation will maintain the existing cross-border framework with respect to the illegal movement of cannabis. As such, the Canada Border Services Agency will continue to examine persons and shipments for cannabis at our ports of entry pursuant to the Customs Act. The agency will also continue to work closely with law enforcement partners such as the RCMP and local policing agencies who are responsible for pursuing investigations pursuant to the new Cannabis Act. It's important to note, Chair, that the proposed Cannabis Act does not impede law enforcement's ability to target and dismantle cannabis operations. The bill sends a strong message about the seriousness of the crimes that involve cannabis. For example, the maximum penalties for criminal offenses under the proposed act for producing, distributing, selling, and importing and exporting cannabis can result in 14 years imprisonment. Another very important objective of the government is that Public Safety Canada and the law enforcement community will work to support protecting youth. The Act clearly reflects the view that we want to keep cannabis out of the hands of youth by restricting access to cannabis, deterring unlawful activities with cannabis through appropriate sanctions and enforcement measures. This is why adults who use youth to commit a cannabis crime would face the same 14 years maximum penalties as those who illegally sell or traffic cannabis. Further, provinces and territories have the ability to establish their own provisions to prohibit persons possessing any amount of cannabis under the minimum age. This would also give police authority to seize cannabis from youth while not subjecting them to criminal prosecution for possessing or sharing very small amounts of cannabis. The government's been clear that strictly regulating cannabis within the legalized framework is of the utmost importance. As such, a ticketing scheme is proposed under the proposed legislation. This would allow law enforcement to issue a criminal ticket to an individual 18 years or older for relatively minor violations of the rules set out in the Act, including possession of cannabis beyond the legal limit of 30 grams, but up to 50 grams of cannabis, or for home cultivation 5 or 6 plants and or outside the prescribed restrictions. And the penalties of these acts is a monetary fine of $200. In conclusion, Chair, Public Safety Canada recognizes the degree of effort required to ensure the necessary public safeguards are in place as we move forward with the proposed cannabis legislation. We'll continue to work with Health Canada, the Department of Justice on all aspects of the new regime, including licensing compliance and a robust public awareness campaign, specifically targeting youth. We will be communicating the new law enforcement regime to police, all Canadians through online training modules, leveraging the media and social media opportunities. Furthermore, we'll be undertaking continuous research, data collection, evaluation, open dialogue across Canada with law enforcement stakeholders. We'll work to support law enforcement to implement and operationalize the new legislation. To conclude, Mr. Chair, the proposed new Cannabis Act will be an important piece of legislation from a law enforcement and public safety perspective. Thank you, and my colleague and I are happy to take your questions.
Thank you very much. Now we go to the Vancouver Police Department by video conference, and I offer Inspector Bruce the opportunity to have an opening statement. Can you hear us all right, Inspector Bruce?
Yes, I can, and hopefully you can hear me.
We can. Perfect.
Excellent. Good afternoon. I am Inspector Martin Bruce of the Vancouver Police Organised Crime Section. With me is Staff Sergeant Bill Spearn, and the bill is a subject matter expert in organised crime-related investigations. On behalf of Chief Adam Palmer, I'd like to thank the honourable members of the committee for the opportunity to make a submission on Bill C-45, and being mindful of the committee's time, I will be brief. The concern of the Vancouver Police Department are very likely to be those echoed by the Canadian Association of Chiefs of Police and other public safety partners. However, in the local context, our concerns fall into four main areas: access by youth, personal cultivation, the role of organised crime, and the implementation timeline. With regards to access by youth, our view is that allowing 12 to 17-year-olds to possess or socially share up to 5 grams of marijuana will create issues when police need to interact in a number of settings where youth are present, but in particularly in our schools. For example, what powers will our officers have to intervene and seize marijuana that is being offered to a vulnerable student by another youth, or to deal with any other nuisance calls involving youth effectively? We note that the proposed ticketing scheme will apply to those aged 18 years and over. This possession ability, combined with personal cultivation in the home, appears to conflict with the government's stated objective to create a highly regulated environment that minimizes youth access to the drug. With regards to personal cultivation, we oppose it and believe that it will be a catalyst for overproduction that will flood the illicit market and effectively undermine the pricing structure and supply offered by the regulated regime. It will also bring with it the potential for home invasions, break-and-enters, robberies, theft of electricity, nuisances and other calls for service that make communities less safe and further stretch police and other first responder resources that are already grappling with the opioid overdose crisis in this province and elsewhere. Enforcement of the 4-plant maximum will be impossible to effectively enforce, and as the new act will be layered over existing medical marijuana regulations, it will be difficult for frontline officers to determine what authorities they have in the myriad of potential circumstances that will exist. Seizures later determined to be unlawful may leave police agencies liable for degraded marijuana stored over time that has to be returned to owners. Officers will also have the potential for British Columbia Police Act complaints for misinterpretation of the various provisions. The role of organised crime. If the pricing structure and availability of regulated marijuana isn't set at realistic levels, organised crime will take advantage in the same way they have done with illicit tobacco products. To meet any increase in demand, criminal elements will also have the potential to increase output, especially in urban settings, under the cloak of personal production and through a proliferation of residential marijuana grow operations. With regards to the implementation timeline, the implementation of Bill C-45 leaves us with many unanswered questions, especially around where responsibilities will ultimately lay and around how and when that information will be conveyed. In the absence of that detail, we have concerns that the remaining timeline poses significant challenges with regards to the appropriate training and equipping of our members, amending our procedures, and potentially adapting our facilities. Finally, we would seek assurances that funding will be in place for a comprehensive public education strategy and that it will be implemented well in advance of legalization, and that such a campaign will focus on the developmental harms associated to youth, other known harms linked to marijuana use, and the dangers associated to the impaired operation of motor vehicles. Thank you again for providing us with this forum, and we'd be pleased to answer any questions that the committee might have. Thank you.
All right. Well, thank you very much. And now we'll proceed to our 7-minute questions and answers. And we'll start with Dr. Ray Olson.
All right, thank you, Mr. Chair. I'd like to take this opportunity just very quickly to correct some information that was given to the committee at a previous session regarding the increase in impaired driving in Colorado. I have two letters here from the states of Colorado and from Washington State to the Attorney General of the United States that specifically says that the increased detection was due to different methods that were in place that were not in place before legalization. And in Colorado, that from in a 6-month period in 2016 compared with the same 6-month period in 2017, impaired driving due to marijuana actually decreased by 21%. And I will offer copies of both these correspondences to the clerk for distribution to all interested members. Thank you. Okay, now I'll go on with my questioning. Thank you. I just wanted to clarify something. I wasn't sure if I understood. This is directed to the Vancouver Police Department. Thank you so much for testifying. Were you stating that with the scheme for 12 to 17, that the ticketing scheme did not apply to them, to that population, and that this ticketing only applied to, did I misunderstand, that it only applied to people over 18?
Our understanding is that it is for youth for 12 to 17, so that's our understanding of the current situation.
Can't be ticketed, is that your understanding? No.
That is.
No, they can be ticketed. In fact, the legislation quite clearly says that if they're 12 to 17, they will have the substance confiscated, they will be ticketed, but will not have a criminal record if it's under 5 grams. That's what the legislation says. I just wanted to correct that, I think. Okay. Now, with the Canadian Medical Association, I have an understanding that, as you say, the medical science is that they're still developing brain tissue until 25, and you're recommending 21. Now, our concern is, as you're probably aware, that the greatest amount of highest proportion of use for populations is 18 to 24. Now, we've had a lot of discussion about this. Would you agree that there would be risk of significant harm simply to the 18 to 21 group if they were not able to buy it legally, would in fact go to the illegal market and have the be faced with the criminal sanctions as well as having to deal with the dangerous elements in the black market?
I could say most of them began before the age of 18, but at the age 18 to 24, they are already addicted to that. Mm-hmm. And it's why we have a great proportion at this age. Mm-hmm. And we still want to have this age at 21 and maybe 25, because the damage done to the brain will be permanent, and it's more than we think. We think it's a recreational drug, but this recreational drug make damage to the brain for the rest of the life of these people. So we have to protect them, and it's why we are so focused on this issue. And maybe Jeff had some other.
Thank you. It's a fair question, and I would say we're, of course, really focused primarily on the medical evidence and what that shows in terms of the effect of marijuana on the developing brain, and we understand the other sort of considerations, and that's why we sort of said, ideally 25 would be the right age, because brain development occurs up until that point. I would say we're, in many ways, very surprised that the medical evidence hasn't been taken into more account, and we recognize, maybe that's because we're medical professionals and that's our job. And so we recognize some of the competing priorities in balancing those risks. I would say from our perspective, based on what we've seen in clinic, what the evidence shows, we still think the right balance is 21, recognizing, as you say, that the competing risk would be having use go to other sources. We think it's a little bit easier to try and mitigate some of those things than it is to undo the harm potentially that occurs under the age of 21. So we continue to think that would be a good sort of common ground.
Yeah. No, I understand. And again, from the purely medical scientific perspective, I would actually be the first to agree. However, as you've said in your testimony, that they're already using it in high amounts now that it is illegal. It is already illegal, and they're not a lot of them are just not listening to the advice about it. So if you raise the age to 21, would you have any less youth usage of it? Would the people from 18 to 21 be using it any less if you put the legal age at 21 than they are right now when it's already illegal and they're using it a lot?
We hope they would.
And and this recommendation doesn't come alone. It comes with a good education. When it will be legalized, it will be permitted to push a good educational state for the youth.
Sure.
So, and if they are really well aware at the age of 12, 13, 14, they will just be away from this, maybe more. And if they decide at the age of 21 to take it, it will be their judgment, and the damage will be less. But if there are already damage in their brain at the age of 16, 17, and 18, 19, it will be for the life. And our doctors in Canada are just concerned about this damage. We see these people every day in our office, and we see how they are suffering of this, and they regret it. But because it is associated with addiction, they can leave it. So we have to support them when they want to leave this bad habit they taken.
Okay, thank you. How much time do I have left?
44 seconds.
Okay. And this is a quick question developed for our public safety colleagues. Now, one of the things we talk about in prohibition, we all know that the historical example of prohibition in the United States and how much criminal activity there was due to illegal alcohol and what happened to the landscape after that. I've heard some criticism of that analogy because it's 100 years old. That this happened. That being said, despite the passage of a century of time, do we have things to learn from that example in response to public safety and prohibition?
Thank you very much for the question, Chair. Just to the honorable member, I think we do, but keeping in mind it is 100 years difference, and we're dealing with different players and groups. I think what we're doing now is we're creating a regime with a legalized supply of cannabis. And so our sense is that we want to get that framework put into place. We want to have safe access to cannabis. We want to make sure that in terms of law enforcement, that we're actually going to have the ability to deter organized crime. And then 3, for some of the other issues around our youth, that have just been discussed, I think that's important as well. So for us, it's important that we make sure that we have a lot of public awareness for youth around the system. I think that's probably a little bit different 100 years ago in terms of communications, but all that to say that I think it's very important that public awareness, number one, around the regime is important, and then law enforcement specifically has the capability and the ability to deal with organized crime in the black market to ensure that profits don't land in the hands of organized crime, largely because profits usually go to other areas of concern.
Thank you very much.
Time's up. Mr. Weber.
Thank you, Mr. Chair, and thank you all for being here today and presenting to us, in particular, the Vancouver Police Department, Inspector Bruce and Staff Sergeant Speen. Your concerns and the concerns of the Canadian Association of Chiefs of Police are certainly concerns of the Conservative caucus, and we thank you for presenting here today to express your concerns. In particular, the access to youth through personal cultivation at home. I feel that this is going to be an incredible problem. Of course, you oppose it. The 4-plant maximum, you mentioned the enforcement of it being almost impossible. And also the potential, actually it will flood the illicit market. And of course, the crimes involved with that, the home invasions, electricity theft, everything you said, absolute perfect sense, and we agree with you 100%. Again, your training and the timelines are going to be difficult. You are going to go into the months after July 1st of 2018 into homes with 4, 5, 6 plants. What do you do? It's going to be interesting anyways to deal with all the problems that are going to occur from this. You mentioned the pricing structure, and I've mentioned this earlier today as well. To compete with the illicit market, I just don't see it happening. Although some presenters here today suggest that we can be comparable in price with the black market, I just don't see it with all the regulations that are in place in the, oh boy, I think we may have lost our friends down in Vancouver. Okay, that just lost my train of thought with them. I was going to ask them some questions. Are they still there?
We have you by audio.
Oh, good. Okay, I can hear you, but I cannot see you. But in any event, I just want to say thank you, first of all, for bringing these concerns forward. They are definitely the concerns of our caucus, and I would like to know how our Liberal government is going to be dealing with these incredible issues that are going to occur from allowing personal cultivation at home. Any further comments with regard to that? No? No?
Not really from the placing group.
Okay. Well, best of luck to you. I know that you're going to need it, and all the police forces around Canada are going to certainly experience much difficulty when this comes into place. I have a question to Canada Board of Services, Jennifer LaFolla. Have you seen any increase in smuggling of marijuana into Canada from the legalized states, in particular Washington being right along the border? Have you seen any significant difference at all in the smuggling of marijuana and marijuana products into our country?
So in terms of the smuggling from, let's say, Washington State into the Vancouver area, we have noticed a significant increase in the amount of seizures that have been undertaken by our officers. I don't have the specific percentage, but we did notice a significant uptake with respect to the seizure rate.
Mm-hmm.
Smuggling, I don't believe it has increased all that much over previous years, but a lot of individuals believe that they can bring marijuana into Canada from Washington State, for example, and therefore the seizure rates in those areas have grown.
Interesting. We had testimony this morning from the Honourable McClellan indicating, too, that her experience going down there talking to stakeholders is that these legal states are now smuggling, obviously, into other parts of the states as well, causing big problems in areas where it's not legal, and I can see that occurring through the border into Canada as well. And vice versa, once we become a legal country when it comes to the cultivation of marijuana, you would likely see a significance of smuggling efforts across the border into the states, I would imagine. Would you not think so?
I think at this point it's a bit premature to speculate on what's going to happen in terms of the flow going from north to south. That being said, we are going to be working with CBP as well as monitoring the trends of any seizures as well as smuggling attempts from our country or the other way around. But at this point, I think it's a bit premature to speculate.
Sure. I guess a thought that I have too is the issues that we've been having with respect to the opioid crisis and 98% of the opioids coming from China into our country. And of course, Canada Board of Services has a key role there in preventing that from getting through to our border, but with great difficulty. With respect to the marijuana as well, I can just see immense issues occurring because of the legalization of this product, and I too wish you well in your efforts and Canadian Board of Services efforts. It's going to be a concern and a huge challenge there. I'd like to also thank the CMA for being here today and your concerns as well, the health concerns with regard to the ingestion of smoke into your system. We've worked so hard to try to decrease the use of tobacco use in this country, and yet we are encouraging, through legalization, even more so with respect to harming your system by ingesting marijuana. So I do appreciate your concerns. There are concerns as well. So with respect to a question, I don't know how much more time I have, Mr. Chair. I have just a little bit here. Okay. Thank you. thank you for presenting and expressing your concerns. Finally, we have some people here today who have expressed serious concerns over the legislation and the legalization of this product. So thank you all for being here today. No questions, sir.
Mr. Davies.
Thank you, Mr. Chair. Thank you to the witnesses. Mr. Marcoux, from a medical health perspective, would I be correct in assuming that smoking cannabis is more damaging to your health than ingesting cannabis in a non-smoking manner?
For the damage to the brain, I think is quite the same. But smoking cannabis has a high incidence of pulmonary and cardiovascular incidents, and it's worse on this side. And for the addiction, I think it's also the same, because it's a print in the brain, and we are very concerned about the outcome of the print on the brain for the young, because this print is permanent, and that is very worrying.
Mm-hmm. Thank you. To our CBSA colleagues, it's funny, this summer I think a lot of us MPs, we were in our ridings, and I know that I always have an experience with people having trouble crossing the border both ways. Canadians who get turned away from the U.S. border, and Americans trying to come into Canada who are turned away by CBSA. And in fact, I had 2 young gentlemen from Los Angeles who were turned away by CBSA because they had prior convictions. I've had cases where someone's been turned away for having an impaired driving, a DUI as they call them in the United States. I'm just wondering, how will CBSA treat Americans with cannabis possession convictions after this becomes law, C-45 becomes law? Will that still be a ground for denying entry to an American citizen coming into Canada?
So, as you know, CBSA is the organization that is charged with the responsibility of determining admissibility into our country. If that is still an offense, if that person was found criminally responsible for whatever action, yes, they would be inadmissible to our country, because you're taking, in determining whether someone's admissible, we're looking at the criminal record that is being held by the United States and determining whether or not that is in fact a crime in Canada.
Weren't a crime in Canada. Say this C-45 passes, we're using July 1, 2018, but whenever it passes, so it's no longer a crime in Canada to possess 30 grams of cannabis. And you have an American who was convicted in the past of possessing under 30 grams of cannabis. That would no longer be a crime in Canada. Would that be a barrier to them entering Canada at that point? It no longer being a crime here? It would still show up on their criminal record.
It would still show up on their criminal record, and they could be criminally inadmissible. I'm going to have to come back to you on that one, if that's all right.
I appreciate, of course. Now I'm going to reverse it, because we heard some testimony this morning. Once we legalize cannabis possession in this country, according to C-45, it'll no longer be a crime for adults in Canada to possess certain amounts of cannabis and to consume it. I'm concerned when those Canadian citizens go to the border with the United States and they're asked by a U.S. border officer if they've ever taken drugs, which happens routinely. Not convictions. They ask if you've used drugs. And I've had Canadian citizens who have been denied entry to the U.S. for answering. Has CBSA had any discussions with their counterparts on the U.S. side to work out an agreement so that Canadian citizens aren't placed in the awkward situation of either having to lie to U.S. border officials, which is wrong, or if they admit to doing what is perfectly legal under Canada, they run the risk of being denied entry to the U.S. Are you aware of any discussions in your department to resolve that issue with the American border authorities?
So that was identified as an issue with respect to our assessment on Bill C-45. First and foremost, obviously, any Canadian traveling to the United States has to answer truthfully to all questions. That being said, there have been initial discussions with counterparts, but it has not been resolved.
Okay, thank you. My last question, in the purposes of the bill, in Section 7, E says that the purpose of the bill is to reduce the burden on the criminal justice system in relation to cannabis. So CBSA is responsible for administering the RCMP, I believe. Is that correct? No, RCMP
We're only
doesn't.
at the border.
Oh, you're only at the border then.
Mm-hmm.
Okay, then I'll ask that question to our VPD colleagues. VPD officers, can you still hear me?
Yes, we can.
Oh, thank you. So I'll ask you, does the VPD expect to have the your burden reduced in relation to cannabis offenses upon the coming into force of this act?
We are concerned about the demands and calls for service, especially with regards to home production and other nuisance type calls. So, we're kind of anticipating what might happen. We can only base our predictions on what we think organized crime might do, what citizens may decide to do now that certain aspects are legal, especially around home grows and growing some marijuana themselves, perhaps for their own use or perhaps for sale. So we just don't know how what the call load is going to look like, but we're fearful of it, especially here in Vancouver and in BC. We're already stretched with enforcement related to the opioid crisis and fentanyl and concentrating on those issues. So it's kind of a great unknown, but we're wary of it just based on the current taxing of our own resources.
Okay, I come from Vancouver. I'm proud to represent Vancouver Kingsway, and so I'm well aware of the dispensaries that are operating in Vancouver, and I know that there's legal licensed dispensaries and unlicensed dispensaries. I'm aware that generally the Vancouver Police Department has not closed down the unlicensed dispensaries, where I know that they're selling edibles and all sorts of products that licensed facilities are not allowed to. Deputy Chief Lepard has said in a report that the VPD is not shutting down the dispensaries unless they pose a public safety risk. And so I would assume that because they're not shutting down these dispensaries, they're not posing a public safety risk in the eyes of the VPD. Is that a correct assumption on my part?
It would be proportional. If we receive information that the dispensary is selling to youth or there's a direct organized crime linkage, then we would definitely intervene. The regulation of the dispensaries here in Vancouver is through a City of Vancouver bylaw, and obviously the number of dispensaries has increased exponentially since they first appeared here in Vancouver, so it becomes an enforcement issue of what takes priority, and so we are going to respond to our citizens if they complain, but can we dedicate resources to closing all of the dispensaries? The short answer is no, we can't.
Quickly, how many dispensaries are operating in Vancouver, approximately both licensed and unlicensed right now, selling cannabis?
I am estimating around 100, perhaps 120, 130 that may be in the city's licensing process. A much smaller number have actually been granted licenses to operate. A question would be is where the source of their inventory, where that's coming from. Is it from licensed producers, or is it from perhaps overflow from the medical system and being sold illicitly? That we don't know.
Thank you very much.
Okay. Thank you. Mr. Ayoub, 7 minutes.
Merci, Monsieur le Président.
Well, thank you very much, Mr. Chairman. Now, education is a point that's important, and Dr. Marcoux mentioned it and said that it plays an important role in making young people and people aware of what they need to know to make an informed decision about their use or consumption of these products, be it legal or soon to be legal or illicit. Now, we see when we talk about education, we also have to talk about budgets because the two are tied together. I agree that we do need to increase funding for education and awareness to deal with the proliferation of use among young people. Now, we know that there are rates of use among young people. There are problems that can be potentially cognitive problems that can affect their brains. Now, how can we draw a comparison with alcohol consumption, which also has an impact on one's health, as does cannabis? But how can we explain the legal age for alcohol, the differences between the provinces and the territories, Ontario and Quebec, for example? 18 years in Quebec, 21. So there are these differences. And now we're hearing that in Ontario, and there's some logic here, we talk about having a confederation, which involves some leeway. They legislate in their own jurisdictions. But how is it that in Ontario, marijuana may be legalized at 19 when that's below the legal age for alcohol? So how do you react to that? Now, when the witnesses before you said that it's younger or easier for young people to get their hands on marijuana than it is alcohol or tobacco. So I'm concerned by that fact, and maybe the answer isn't an easy one, but I'd like to hear your comments. Well, first of all, in what you've raised, there are a number of aspects, and it's an important that needs some reflection. Now, people need to be aware of things. Up to now, people didn't talk about it. It was used in hiding. We didn't talk about it. But now young 12-year-olds need to be made aware of the consequences of products that they may be using. Now, when they get older, where they make their own decisions, they will have learned earlier that there are consequences, proven consequences, not just for their ability to concentration. Psychoses, for example, there are consequences in the long term. So we all need to learn a great deal about cannabis. There's a lot that remains to be learned for everyone. There's a lot of scientific research that hasn't been done as well. Now, when we talk about medicinal cannabis, it can't be prescribed when we don't know how it will interact or what side effects it will have based on the patient's age or size, for example. So now we're talking about prescriptions for a product where there are a number of unknowns. Now, this is very difficult. Well, it's already being prescribed. Well, it's recommended when all other methods have proven ineffective, when patients are in a terminal phase of their lives or other medication isn't working. So from a medical perspective, we're seeing recommendations for prescriptions because we can't talk about prescriptions, in fact, because that's based on data, proven data, when we know how it will interact, what the contraindications are, etc. So the word prescription isn't acceptable for doctors at present, and that's why we talk about distribution for cannabis and for alcohol.
Up on a couple of points. The point about education is extremely important, and the latest numbers I've seen in terms of the money that would be budgeted towards education for marijuana use for youth was $9.6 million, whereas the budget for the federal tobacco strategy, for example, is $38 million. And I think we've gotten to a point in Canada where there's no adult who smokes who thinks it's good for them. We've done a good job of helping people understand the health risks, and when they make that decision, they're making an informed adult choice to take on the risks. We're not anywhere near that point with tobacco. There's still a fairly large cohort of people who think not only is it not harmful for them, it may actually be good for them. So we need We need more money, not less, in terms of that education piece. With respect to the age, I mean, I hear that argument a lot, that we should set the age at 19 because that's what it is for alcohol. To me, that's very lazy thinking. It just says we're just going to go along with the status quo and we're not going to evaluate this based on its own merits. If you look at the United States, where they have an age of majority for alcohol of 21, who's to say that that's not better for a substance like alcohol? In fact, there are a lot of groups, mental health groups and others, who are saying it may be time to reevaluate the age at which alcohol can be purchased. So I would encourage people to look at this based on what the evidence shows for this particular product and not the historical decisions that were made for alcohol. And as you say, those are differential based on the provinces in any case. So we really hope that people will look at this on its own merits. Thank you for that question.
Merci. Peut-être dans le temps qui me reste, une question pour...
Well, with the time that I have left, I'd like to ask a question to our law enforcement representatives in Vancouver. Now, when you arrest someone in possession of cannabis who's caught driving, for example, under the influence of drugs, do you have any statistics on the number of arrests that are directly related to cannabis compared to alcohol, driving under the influence of alcohol? Have you compiled those types of statistics?
I don't have those statistics at hand.
You have it
as far as the possession aspect goes, typically by policy we don't charge for simple possession, but as far as use related to impaired driving, I really don't have those stats at hand.
If you can provide it, if you've got them, maybe later on, that would be great.
Certainly, we can do that.
Thank you.
Time's up. All right, thanks very much. That completes our 7-minute rounds. We'll go to 5-minute rounds, starting with Dr. Carey.
Thank you very much, Mr. Chair, and I just wanted to thank everybody for being here. I just wanted to mention to the Vancouver Police, I think you were corrected by my colleague from Winnipeg that there were penalties and ticketing in this legislation. I had it checked. There are no required penalties for underage possession of up to 5 grams. It was Ontario that actually announced last week that they would allow police to confiscate pot from those under 19. So, in fact, you were correct. So I just want to correct the record in that regard. First question for me is for CBSA. I'm from Oshawa. And you know what? We're a border city. We do a lot of trade. Actually, some of our truck drivers go back and forth across the border many times per day. And we're really concerned about the thickening of the border. And as my colleague in the NDP brought up, there's been some questioning and people being turned back just for admitting that they've used recreational marijuana. With this legislation, do you see this becoming even a bigger issue?
I think at this point, it would be, I can't speculate as to what kind of impact it's going to have on the U.S.-Canada border with respect to entry into the United States.
Do you think it'll get better because of this legislation?
Do I think it'll get better?
Sure.
Do I think it would facilitate entry?
Yeah. If I answered it in one way, and I'll answer it or ask you the question in the other way.
No, I don't think it would facilitate entry. I think a CBP officer is going to assess each case presented to him or her and is going to ask questions based on the merits of each individual trying to seek entry.
Yeah, I don't think it's going to be helping our trades with Mr. Trump in the United States. But anyway, next question is to the Canadian Medical Association. First of all, I appreciate your stance. Canadians expect the government to look after the health and safety of Canadians and put that priority first. They don't expect compromise, I suppose. And to see the government looking at this substance where the evidence is quite clear that up to age 25 there's significant consequences for our youth utilizing it. What do you think? Should the government be basing the legal age of marijuana consumption on science, or this compromise that they're going back and forth? Does that even make medical sense to you that they would compromise to such a significant amount, and not only by having it at age 18, but I think you're well aware in this legislation, kids 12 to 17 can have 5 grams, and 5 grams, my understanding, can be 10 to 15 joints. What do you think of the lack of respect for science in this decision that the government's put forth at 18?
I would just tell you and ask Jeff go on with that, but it's damaging if it is taken at the age of 12, before the age of 25. And it's done a little every day for a long time, it will be damaging for sure. And I don't know how we can manage it in a proper way. Jeff, est-ce que tu veux continuer, s'il te plaît?
Thank you. So I'll just reiterate what I said before, which is that for us, one of the most sort of challenging aspects of the discussion has been around the age. And where we've been a little bit surprised that people haven't been more respectful of the evidence and the real potential for damage. These are not sort of theoretical lab models. These are studies, and we know that the earlier people start, the greater the damage, the more permanent it is, the greater the likelihood of becoming addicted to marijuana. We have all the statistics, we have all the evidence we need in terms of the effect on education, career attainment, IQ levels, all these types of things. And yet, you know, we keep hearing, well, we need to keep it consistent with the age of alcohol. And again, to us, you know, this argument doesn't hold water. And this is certainly, you know, we have a few concerns with the bill. This is definitely one of them. We'd really like to see more emphasis placed on, exactly as you're saying, health and safety. And this is really one way the government could show that it's serious, is by taking the medical evidence more seriously than we think it has been to date. We understand, again, there are other issues at play. We're very respectful of those issues. We understand the other priorities that the government and others have, but we continue to believe that health and safety should be the primary consideration.
Well, this appears to be, it's going to be a huge experiment on the Canadian public, and unfortunately they seem intent on moving that way. I'd like to ask the Vancouver Police, the federal government is moving forward with this, and really, as was brought up, very limited funds available to the people on the ground. It seems there's not a lot of money for enforcement tools, public education, training for on-the-ground police officers, even the science, when you guys are going to be tasked with deciding, is this person impaired while they drive? I've not seen a valid driving test. I've seen you can tell whether somebody's consumed or not, but whether they're impaired or not, there's not even a scientifically valid test for that yet. So I was going to ask you, do you think the government has focused on ensuring the necessary law enforcement and public safety dimensions are incorporated into the legislation, or do you think it's significantly lacking?
Our concern would basically be at the application at the street level. As you mentioned, to determine if someone, for example, is impaired by marijuana driving, that requires a drug recognition expert. And just for one of those individuals, it's an intensive training course. They have to be recertified every year. And the last figure that I heard, I'm not sure if it's completely accurate, is that there were approximately 400 drug recognition experts in all of Canada at this time. So if we're going to see a spike in impaired driving through the use of marijuana, our issue will be there is how do we have enough resources on the street, have these experts trained in time to deal with it. And that's the basis of our concern.
What about the blood test? Is that even constitutional?
Dr. Carey, time's up. Sorry. Ms. Sidhu.
Thank you all for being here. My first question is Canada Border Service Agency. What plan does the agency presently have in place to ensure that cannabis is not imported or exported for non-medical purposes, while also not slowing down border crossing?
We have put into place, we do have mechanisms to control the export of contraband goods. Is that what your question is focusing on? Okay. So as part of the CBSA's mandate to support public safety and facilitate the free flow of individuals, we do control the goods entering or exiting the country. We used a variety of threat and risk assessment methodologies, intelligence, as well as supporting technologies to potentially identify contraband, in this case marijuana, that is entering or exiting the country.
Thank you. My next question is for the Vancouver Police Department. Any market for cannabis is in effect an illicit market. However, young Canadians presently have easier access to cannabis than they do to cigarettes, which are legal. How do you expect the legalization and restrictions of cannabis to impact both the illicit market and youth access?
I guess our concern is that in allowing home grows, that youth would have more access to marijuana, rather than trying to keep them away from marijuana by, let's say, putting it in a storefront. Having, every residence in the country being permitted to grow 4 plants would, in turn, give youth easier access to it than putting it, let's say, behind a store shelf.
Are there any way to detect cannabis use that do not require invasive search, such as blood test? What training do police officers present receive in recognizing impaired caused by cannabis use? Is any level of THC in blood being agreed upon and indicating that the individual's ability to drive being impaired?
We're aware, and the Vancouver Police took part in it in a trial of screening devices on the roadside. We're not sure exactly how that's going to work by application. One of the devices requires the tongue to be scraped. So it's, do we have a compliant individual at the roadside? And again, to make the determination whether or not someone is impaired, as I mentioned previously, the Drug Recognition Expert Program is the principal way to do that. And most agencies, I would speculate, will not have enough members that are trained in that particular skill to cope with what we anticipate to be a rise in impaired driving due to marijuana. And so that's the dilemma.
Thank you. My question at the CBSA, what kind of public awareness and education campaign relating to cannabis use implemented prior to the coming into force of Bill C-45 in regards to border crossing, many cross every day to escape for the hassle? What kind of the education need to be raised before enforcing C-45?
So the CBSA is going to be undertaking a number of communications aspects to educate the public that the movement of marijuana across the border is still illegal. We will be putting signs at ports of entry. As well, there will be we're going to employ social media as well as update a number of websites indicating what the obligations of travelers are coming into and out of the country. So basically, those are the types of methodologies we're going to be using.
Do you think now there's a need before implementing the C-45, should be implemented now, that education role?
I do believe a education campaign beforehand would be useful, and we are undertaking some activities to that end. Yeah.
Thank you.
Okay, now we have Ms. Gladden.
Thank you, Chair. I want to talk a little bit about the border because my community of Sarnia-Lambton is a border community. I'm distressed to hear that with 290 some odd days left to go before we are supposedly legalizing marijuana, that we have no deal with the U.S. In terms of when you get to the border declaring that you have done something that's legal in Canada and you will not be allowed into the U.S., so that's disturbing. The other thing that is disturbing is that there's 3 treaties that we signed that we would have to give notice of if we're going to breach our treaty. And these are treaties signed with the UN that I assume Homeland Security would be concerned about. So if we don't, to my knowledge, we haven't given notice, and if we notified now, it would be January of 2019 before we could actually legalize marijuana in Canada without breaking our treaty. So have you heard any of these concerns from Homeland Security?
I'm sorry, which treaties are you referring to?
The 1961 Single Convention on Narcotic Drugs, the 1971 UN Convention on Psychotropic Substances, and the 1988 Convention on Illicit Traffic in Narcotic Drugs and Psychotropic Substances.
I do understand those treaties, and I understand that there are discussions going on with Global Affairs, Health Canada, with those international organizations around those conventions and the way forward for Canada.
All right, one of my other questions has to do with the topic of mandatory testing. So once we legalize marijuana, one of the concerns that I had previously in my career, I was director of engineering at Suncor, and we wanted to implement a zero tolerance policy for drugs. We didn't want people operating a refinery that were under the influence. And actually, the Supreme Court declared that it is an invasion of a person's privacy to do mandatory testing. So I'm concerned for, Air Canada's pilots that I'll be flying on their planes and people operating nuclear facilities and chemical plants if there's no ability to do a mandatory test once it's perfectly legal for people to consume marijuana. And so from a public safety point of view, could you comment, Mr. Bupsing?
I would just say that we're in discussions with various organizations. The provinces and the territories have the flexibility to engage in discussions with organizations that control things such as landlord-tenant acts, et cetera. With respect to airlines that you mentioned, again, those discussions are ongoing in terms of understanding what are the implications for these various industries.
Yes, they're ongoing, but in 290 days, they'll matter more. I just also wanted to mention to the clerk that with respect to the data we were talking about earlier in terms of the increase in impaired drug driving that we've seen in Colorado and in also Washington, I can provide you with the data where my information came from. In fact, I think we're going to hear from Smart Approaches to Marijuana tomorrow, who show 145% increase in impaired drug driving for marijuana from the 2013 to 2016 time period, which I will send you, and also information reported by SAM.org, where Washington saw a doubling once they legalized marijuana, a doubling from 8% to 17%. So I'm happy to send that to the clerk as well. I'd like to hear from the Canadian Medical Association a little more discussion about prevention. It seems to me that with all the effort spent to try to criminalize trafficking and all these various things, we're not focusing as much, or I don't see as much in C45, on trying to prevent people from getting on drugs in the first place. So if you could comment.
Thank you very much for the question, and it's very important, and it's part of our submission is the importance of prevention, and part of that is education. So helping young people understand the risks of starting at a younger age, and helping disseminate the information that they can use so that, again, they can make an informed decision in a way that currently really they don't have easy access to information in a way that they can digest. So, the way that young people consume information is very different than the way others might, and so part of our strategy would be to make sure that that's available to them in different platforms, different types of media, so that they understand the risks before they undertake that. So there definitely part of the education needs to be a significant prevention strategy, as well as treatment, harm reduction, all the other types of things. So I agree. I think we could probably see a little bit more of that, hopefully as we get a better sense of what that education program will look like.
Very good. Time's up.
Okay, moving on to Mr. Oliver.
Thank you very much. For Vancouver Police, the committee did a study on an opioid crisis in Canada. We heard firsthand from from first responders in Vancouver, so very, very aware of the situation you're dealing with there and just the ongoing struggle with the opioid crisis that you have there. But just to come back, though, to I think the question that was at the table at one time. So under the federal legislation, the prohibition for youth under 5 grams from 12 to 18, there is no criminal federal charges for that. So it would come down to, I guess, same with liquor license, it would fall under provincial legislation, and the provinces would have to put in place mechanisms to control those situations. So if you wanted to take or seize the under 5 grams from someone of that age group, that would be provincial legislation. I know you've been experimenting with ticketing around some of this already. How has that been working? I think you've been using bylaw officers to issue tickets for violations for some of the cannabis. Has that been working well for you, that model of prevention?
Our City of Vancouver bylaw officers have been issuing tickets to marijuana stores that are not licensed under the city's bylaws. A very small percentage of those have been paid, and a number of them remain unpaid.
Okay. All right, thanks for that. The other question I had, then, this one back to CMA. So there's been a bit of discussion now about the age threshold and how to set that. And there's clearly competing interests here. I think everybody is aware of the medical research that says really until the age of 25, you really should not be using cannabis. But then there's other competing pressures, because we know that 30% of people under the age of 30 are using cannabis. We have one of the highest rates of use of cannabis in the developed world. There's black market concerns. But I've been a bit concerned about the tone from the CMA here today, sort of that the government is dismissive or not paying attention to the medicine and science behind this. So I just, in the fall of last year, the CMA said in your position statement that 25 is the ideal minimum age for legal purchases, but that 25 was unrealistic. So just as you said, it's not going to be realistic to hold and prevent youth from accessing marijuana at the age of 25, but then you put another lens to it and said maybe it's 21. The government put the same lenses to it and said maybe it's 18. So I just think, I think it's best that we work together on this rather than that tone of you're not paying attention to the medical science, and that's just my observation on it. But I come back to, at the end of the day, if it's illegal, short of using criminal charges, how do you stop? How are we going to stop kids from doing that? So one is to close the black market down as best we can, and there's been lots of discussion about how effective the legislation will be on that. But the other is obviously education, education, education. And I think it would be, do you want to comment on what parameters you considered to go from 25 to 21? And maybe you've already talked about the education piece, so I won't ask for that again, but I just wanted to soften your message a bit here on that.
Je vais introduire la réponse en disant que...
Well, I'll introduce my answer by saying that brain development isn't linear. It develops in the early years. There's a great deal of development in volume, and then the connections are established. So that's how it works. And over the later years of when the person matures. Now, we also know that addictions will be created earlier. And the earlier it's created, the more it will be a problem, because the brain is still malleable. So if we can delay the start of cannabis use, then we can delay the addiction. Now, there are social factors and whatnot saying that, okay, well, perhaps at age 21, someone will be setting up their lives. They'll have more access to education, etc. So that would have an impact. But there's another point that's linked to the education component and the education that needs to be provided to young people, and that is based on research. Now, a product is being legalized, and scientifically speaking, we there are a number of unknown factors, many unknown things.
The point I made that if the CMA was really staying true to the science, true to the research, you would be here saying the age limit should be 25, not 21.
I will ask Jeff to complete it.
Sure, thanks. And I understand what you're saying, and certainly it's not our intent to appear adversarial, but I think expressing a certain degree of frustration around some of the conversations, I think is I think we have been a little bit frustrated by some of those conversations that have taken place. You're right, to an extent, once you get between 18 and 25, it's going to be a little bit arbitrary in terms of where you set that, and we recognize that. And that's exactly why we tried to take into account the different perspectives, which is to say, to what point does the brain develop, and then also what are some of the social considerations and the law enforcement considerations, and what does the data show. So I agree completely, whether you're saying 21, 22, 23, I guess the principle is the later the better, taking into account these other considerations. And we would like absolutely to work with the government to try and find a solution. I think our concern has been that it appears to us that that conversation maybe ended prematurely, that we haven't necessarily had an opportunity to have further dialogue around what that could potentially look like, and I think that's an opportunity that we would welcome. So we certainly don't want to appear adversarial, but we'd like to have those concerns taken into account. Thank you very much.
Time's up. Okay, thanks very much. Now we move to the 3-minute round. Mr. Davies.
Thank you. Well, picking up where my colleague, Mr. Oliver, was going, it strikes me as intuitive that you wouldn't want to damage your brain by taking anything that might alter your consciousness, and that as a young brain is developing, that it would be susceptible to more damage. That would be the thesis I would have in my mind. But I want to just test the science a bit on this, because are there actually long-term, longitudinal studies, peer-reviewed, that show the impact of marijuana on developing brains? Because I'm curious how those studies would even have been conducted, given that marijuana has been illegal, and given the ethical considerations. I mean, you can't have a control group of 15-year-olds that you're giving marijuana to or not. So I'm just wondering, it's not that I doubt the intuition of it, but I am curious, as the health committee, we try to look at the science. How settled is the science on the score of the impact of cannabis on brains and brain development?
Thank you. I would say it's not entirely settled. There's no question that there's work left to be done. I think a lot of the studies, to your point, are really retrospective. So it's looking at people who have smoked in the past and looking at the impact that may have had. There's a lot of confounding variables there. Socioeconomic status, different types of educational opportunities. But controlling for those, we do see a difference in terms of things like educational attainment, IQ, vocational attainment, these types of things. And it does appear to be primarily related to cannabis consumption. The earlier the age, the higher the levels, the greater the impact. But I agree that there is definitely further research that needs to be done. And in states and in places where it's been legalized, I think we're at the beginning of that in a more prospective fashion, and probably will gather more data over time.
Okay, thank you. In terms of age, I think Mr. Oliver also described some of the competing issues that we have. I'm not suggesting this at this point, but just as a concept, would the age, this government has chosen 18 as the floor, and I'm thinking that there are a number of factors that would at least suggest that it should be 19. One, it sounds to me that the later you can delay the onset of cannabis use, that's intuitively better for brain development. 7 out of 10 provinces already set the age for drinking at 19. And it strikes me that 19, most high schools, there are few 19-year-olds in high school generally. So you will limit the impact of legitimate legal cannabis possession in high schools. That's competing against the reality that 15 to 18-year-olds are getting cannabis no matter what we do or say. So I'm just wondering, given all those things, I think you've mentioned 21, would you suggest that 19 be a more reasonable floor, or are we just being arbitrary?
I mean, I like it better than 18, but I think to an extent, I think there is some arbitrariness to it, and I I understand the argument about driving people into the black market, and I see all that, but at the same time, and again, understand the lens that we're using, which is the health and safety lens, primarily, and we leave the sort of enforcement angle up to other people. We would still like to see it later than 19, again, for the protection of the developing brain. It's very straightforward, and everyone understands. So, we understand that the government has to balance all these competing priorities, and we're trying to do what we can on behalf of our physicians and their patients to have the best protection and the best consideration of health and safety possible in the legislation.
Do you have similar concerns with alcohol? Like, is it a similar? Are the concepts the same?
They're very similar, and as I alluded to earlier, a lot of people say, well, we'll make it 19 because that's what it is for alcohol, but in fact, there's still debate and there's still controversy over that. I mean, that age limit was set a long time ago, and there are a number of people who work in mental health services who feel that that discussion should be reopened, and that perhaps a later age for alcohol as well would be appropriate. I'm not suggesting we open that discussion today, but just to say that there is controversy around that as well in certain circles.
From a medical perspective?
From a medical perspective.
Time's up.
Thank you. Thank you.
And that winds it up. And I just want to say thank you very much on behalf of the committee for excellent information and excellent witnesses. You're providing us with a lot of information. And I want to comment on, Mr. Oliver mentioned the opioid study we did. We had first responders from Vancouver, and some of the most compelling testimony we had in 2 years was from those responders. And so we thank you and the police department and your first responders from Vancouver for helping us understand your perspective. But thank you very much for the Medical Association, CBSA, and Border Services. I appreciate it very much. And with that, we end the meeting. See you tomorrow morning.